ಮೂವತ್ತನೇ ತಾರೀಕು ಈಗ ಅದ್ರದ್ದೇನು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಈಗ ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ, ನಾನು ಮ್ಯಾಸ್ಟರ್ ಕೋರ್ಟಿಗೆ ಬರ್ತೀನಿ, ಇದು ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಬರ್ತೀನಿ. ಸಿವಿಲ್ ಕೋರ್ಟಲ್ಲಿ ತಗೊಂಬನ್ನಿ ಯಾವ್ದು ಏನೇನು ಹೇಳ್ತೀನಿ. ಆ ವಿಟ್ನೆಸ್ ಬಂದ್ರೆ ಕ್ರಾಸ್ ಮಾಡಕ್ ನೋಡಿ ಹೇಳ್ತೀನಿ.
ಈಗ ಅವ್ರದ್ದು ಕ್ರಾಸ್ ಮಾಡ್ತೀರಾ, ಏನು ಪಾರ್ಶಿಯಾಲಿಟಿ ಮಾಡ್ತೀರಾ?
ಪಾರ್ಶಿಯಾಲಿಟಿಯಲ್ಲಿ ನೀವು ಏನ್ ಪಾರ್ಶಿಯಾಲಿಟಿ ಮಾಡ್ತೀರಿ?
ಈಗ ನಾನು ಹೋದ್ರೆ ಮಾತ್ರ ಕ್ರಾಸ್ ಮಾಡ್ಬೇಕು ಅಂತೀರಾ, ಅವ್ರ ಹೋದ್ರೆ ಕ್ರಾಸ್ ಮಾಡ್ತೀರಾ?
ನೀವು ಸೀನಿಯರ್ ರೀ ನೀವು.
ಸರ್ ಆಫ್ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡಿ ಸರ್.
ಓಕೆ ಮೇಡಮ್, ಸಾರಿ ಮೇಡಮ್.
ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಎಲ್ಲ ಸರ್ಕ್ಯುಲರ್ ಮಾಡಿಲ್ಲ ಮೇಡಮ್. ಆಕ್ಚುಲಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಮಾಡ್ಬೇಕು. ಮೂರು ನನ್ಗೆ ಸಿಕ್ಕಿರೋ ಪಕ್ಕದಲ್ಲಿ ಯಾವ್ದು ಗೊತ್ತಿಲ್ಲ.
ನಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇದೆಯಾ ಅದ್ರಲ್ಲಿ?
ಹೇಳಿ ಕೆಲಸ ಮಾಡಲ್ಲ ಸರ್, ಸುಮ್ಮನೆ ಅದೇ ಸಂತೆ
ಇದಕ್ ಬರೋದು ಅಷ್ಟೇ, ಸುಮ್ನೆ ಕೆಲಸ ವಿಟ್ನೆಸ್ ಬಂದರೆ ಮೊನ್ನೆ ಇದು ಮಾಡಿಲ್ಲ ಅವರು.
ಮೆಮೋಸ್ ಹೊಸ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಫ್ರೆಶ್ ಫೈಲಿಂಗ್ಸ್ ಮೆಮೋ ಎಂಟರ್ಟೈನ್ ಮಾಡಂಗಿಲ್ಲ ಕೋರ್ಟ್. ಹಳೆ ಫೈಲ್ಸ್ ಇದ್ರೆ ಮಾತ್ರ 4 days ಅಂತ ಮಾಡಿದ್ದಾರೆ. ನೋಟಿಫಿಕೇಶನ್ ಬಂದಿಲ್ವಾ ನಿಮ್ಗೆ? ನೋಡಿ ನೋಟಿಫಿಕೇಶನ್ 60 of 2022. ಫ್ರೆಶ್ ಮೆಮೊ 4ನೇ ದಿವಸಕ್ಕೆ ಬರುತ್ತೆ. 438, 439, 482 ಕೋರ್ಟ್ ಮುಂದೆ ಮೂವ್ ಮಾಡಂಗಿಲ್ಲ. ಸೆಕೆಂಡ್ ಟೈಮ್ ಆಲ್ರೆಡಿ ಬಂದಿರೋ ಮ್ಯಾಟ್ರ, ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ ಅಥವಾ ಆಲ್ರೆಡಿ ಬಂದಿತ್ತ? ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂದ್ರೆ ಏನಕ್ಕೆ? ಕಂಪ್ಲೈನ್ಸ್ ಗಿಂತ ಏನು? ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿದ್ದು ಯಾವಾಗ? ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ರೋಸ್ಟರ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಡುತ್ತದೆ. ರೋಸ್ಟರ್ ಅಲ್ಲಿ 4ನೇ ದಿವಸಕ್ಕೆ ಬರುತ್ತೆ. ನೀವು ಯಾವತ್ತು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೋ ಅವತ್ತು. ಎಕ್ಸಾಂಪಲ್ ನಮ್ಮ ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇರ್ತದೆ, ಬಹಳ ದಿವಸದಿಂದ ಬಂದಿರಲ್ಲ ಅಂತ ಮಾತ್ರ ಮೂವ್ ಮಾಡ್ಬೋದು. ಇಲ್ಲ ನಮ್ಮ
ಇದೆ.
ಹೇಳಿ
42.
ಹೇಳಿ.
Mother of
Ah.
classified requested
Serial number ಇವತ್ತು
ಮತ್ತೆ ಇದೆ.
ಹಾ
ಟುಡೇ ಇಸ್ ದಿ ಬರಿಯಲ್ ಡೇ.
ಫಸ್ಟ್ ಟೈಮ್ ಮ್ಯಾಟರ್ ಇದು. ಫಸ್ಟ್ ಟೈಮ್ ಮ್ಯಾಟರ್ ಇದು.
ಫಸ್ಟ್ ಟೈಮ್ 48 ಲಾಸ್ಟ್ ವೀಕ್ ಬಂದಿತ್ತು.
48
ಲಾಸ್ಟ್ ವೀಕ್ ಬಂದಿತ್ತು.
ಹಾ
ಅದರ್ ಕೌನ್ಸಿಲ್ ಹ್ಯಾಸ್
ಹಾ
ಟುಡೇ ಮದರ್ ಆಫ್ ದಿ petitioner.
ತಿಳ್ಕೊಳ್ಳಿ ಮಾಡೋಣ, ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಬರುತ್ತೆ. 3ನೇ ಮ್ಯಾಟರ್ ನಿಮ್ದಿದೆ, ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ. ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಆನ್ ಮೆರಿಟ್ಸ್. ಏನ್ ಹೇಳಿ ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ. ಯಾವ್ದು? 56 ಏನ್ ರೀಸನ್ ಏನು? ಅರೆಸ್ಟ್ ಆಗಿದಾರಾ? ಇದೇನು ಬರೆಯೋದಿಲ್ಲ ನೀವು? ನೋಡಿ, ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ has filed memo for withdrawal. That petition is filed at 438 of CRPC and the petitioner has been arrested. ಇದೆಯಾ? Arrest. Petition become infectious. In view of the petition, of the memo, then urgency ಇದೆ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಅಂತ ಬರ್ತಾರ ನೋಡಿ. ಆಯ್ತು, ಪೋಸ್ಟಿಂಗ್ ಮೆಮೊ ಇದ್ದಂಗೆ ಕೊಡ್ದು ಯಾವ್ದೋ ಬೇರೆ ಇರ್ಬೇಕು ನೋಡ್ರಿ. ಯಾಕೆ ಕನ್ಫ್ಯೂಷನ್ ಯಾಕೆ? ಆಯ್ತು, the petitioner has been arrested and hence it becomes infectious. In view of the petition is dismissed as infectious in view of the arrest of petitioner. 56. 46 to 53. ಇಲ್ಲ.
My lord, serial number 51, my lords. I appear for the petitioner in this matter.
Yes, madam.
Seek a week's time, my lords.
Why, madam? Why?
My colleague has an emergency.
Right. Petitioner counsel seeks time. List this matter on next hour, madam. Date to next Monday.
Please, my lords.
11.
I'm grateful, my lords.
First time ಅಲ್ಲ, earlier time ಕೇಳಿಲ್ಲ. ಆಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಹೇಳಿ, ಏನಾಗ್ಬೇಕು? ಏನ್ರಿ ಏನಾಗ್ಬೇಕು? ಹೌದು ಹೇಳಿ. ಆಯ್ತು ಹೇಳ್ರಿ. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ರೀ. 54 to 69. 54 to 69. 70 to 83. ಇಲ್ಲ. 84 to 87. Petitioner counsel 1 week time. ಮೇಡಮ್ 1 week ಟೈಮ್ ಕೊಟ್ಟಿರ್ತೀವಲ್ಲ, ಅವೆಲ್ಲ ಮತ್ತೆ ಆಗ್ತಾ ಇದಾರ?
Honorable court directly objection. District court order copy produce ಮಾಡಿಲ್ಲ.
ಹೌದು.
ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೈಕೋರ್ಟ್ಗೆ
ಹಾಕಿದ್ರಿ, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ನೀವೇನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ.
ನಾನು ಕ್ರೈಮ್ ತೋರಿಸ್ಬಿಟ್ಟು ಬಿಡಿಸ್ತೀನಿ.
ಎಷ್ಟು ಸರ್?
2 days.
2 days time granted.
And for the petitioner, my lord. Lord, one simple objection they have raised, my lord. Offences are not tallied in the prayer, my lord. My lord, he was arrested subsequently, my lord. Few offences are less for this petitioner, my lord. For accused number 1 to 4, my lord, offences are more, my lord. In the remand application, it is there, my lord. The same offense we have mentioned in the prayer, my lord.
Remand application only offense which has been invoked against you, that has been
Please,
mentioned.
my lord, in the prayer. Page number 80 is the remand application, my lord. He was arrested after lapse of 2 years, my lord.
After lapse of 2 years.
2 years. 1 to 4 have been arrested in 2019, my lord.
Page 80.
Page 80, my lord, in first para only, my lord. These are the offences against this petitioner, my lord.
This petitioner, remand application. Thought. The counsel submission is that this petitioner has been arraigned after 2 years, and in the remand application, offences are invoked under section 8, 22, 23, 28, 29 of NDPS Act. And the very same offences are mentioned in the prayer column. The office objections may be overruled. There is the remand application and submission. In the prayer column, the relevant penal provisions proved against the petitioners are mentioned, and hence office objection is overruled.
The SPP is NCB, my lord. Respondent is NCB.
HCGP ಅಲ್ಲ, next ಯಾರು? ಗೌತಮ್
Already copy was served, my lord. Copy was served to ASG, my lord. Additional solicitor.
ಗೌತಮ್ ದೇವ್ ಅಂತಾನೆ ಇದೆ ಇಲ್ಲಿ.
My lord, they were all central government panel councils, my lord.
Panel council, central government ಅನ್ನ ಅವರೇನಾ?
ಹೌದು, my lord. ಹೌದು.
ಅವರೇನೆ
Already they were represented. We served the copy in ASG
ನೋಟಿಸ್
office.
ಮಾಡೋಣ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ASG ಅನ್ನೋದಕ್ಕಿಂತ ಅಡ್ವೊಕೇಟ್ ನೇಮ್ ಯಾರ್ದೋ ತೋರಿಸಿದ್ದಾರೆ.
Gautam Dev Ullal, my lord.
ಆಯ್ತು, ಗೌತಮ್
NCB.
ದೇವ್ ಸಿ ಉಳ್ಳಾಳ್ for NCB is directed to take notice and file objections if any. List this matter on Monday. Monday ಎಷ್ಟು ಮೇಡಮ್?
Tuesday, my lord. Kindly have it on Tuesday, my lord.
11th ಮಾಡುವ 12th.
12th, my lord. Monday, one more matter is there, my lord.
12th.
Please, my lord. Grateful, my lord.
Suresh Babu. Additional counsel is absent, 1 week time granted. Harish Prabhu. Absent. Harish Prabhu. ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ, 1 week ಕೊಟ್ಟಿದ್ದೀವಿ.
ಫಸ್ಟ್ ಮ್ಯಾಟ್ ಮಾಡಿ 5
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಯಾವುದು? ಇದು 5ನೇ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದೀವಿ, ಹೇಳಿ.
ಸಾರಿ ಮೇಡಮ್, ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಮ್ಯಾಟರ್. ಹರೀಶ್ ಪ್ರಭು absent, 1 week time granted. 6 Siddesh H absent, 1 week time granted. 7 absent, 1 week time granted. Rajanna absent, 1 week time granted. A.N. Radhakrishna ಹೇಳಿ. counsel 6 3 days time granted. Rajaram S absent, 1 week time granted. 11 Prasanna DP absent, 1 week time granted. Second time Gharla. Yes madam, weeks time. Counsel 6 weeks time granted, and if not complied, this matter on 12th. 13 to 24 HCGP is directed to take notice
for petitioner, your honor. Serial number 13.
13 ಏನಾಗಬೇಕು ಹೇಳಿ.
ಅದರಲ್ಲಿ modification application file ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ ರೀ, ಅದೇನು ಬಂದಿಲ್ಲ, ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಬಂದಿಲ್ಲ. HCGP ಡೈರೆಕ್ಟ್ ಮಾಡಿದೀನಿ. HCGP is directed to take notice and file objections if any.
14
List this matter on 11th. 14 ಅಲ್ಲಿ POCSO matter, and also HCGP directed to notify the complainant, public informant, public victim. ಯಾವ್ದು 14th ಅಲ್ಲ? 14 ಡೇಟ್ ಜಾಸ್ತಿ ಕೊಡಿ. 13th. 15 to 24 any other submission except directing the HCGP?
Lordship, item number 21, Lordship. 438 petition happens. Maybe have it this Thursday or Friday, Lordship.
Next Monday.
Great.
Next Monday. ಹೇಳಿ. ಕನೆಕ್ಟೆಡ್ ಇದೆಯಾ? ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ. ಆಯ್ತು. 20 ನಾಡಿದ್ದು 11th. ಸೇಮ್ ಡೇಟ್. ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. ನೋ ಅರ್ಜೆನ್ಸಿ. 25 to 42 HCGP is
39.
One second. HCGP is directed to take notice and file objections if any. ಯಾವ್ದಲ್ಲ? ಹೇಳಿ. ಆಯ್ತು. ಈ 26 ಒಂದ್ ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ? ಆಯ್ತು. ನಿಮ್ದು ಇದೆಯಾ? ನಿಮ್ಮ ಮೆಟೀರಿಯಲ್ ಇದೆಯಾ?
ACB.
ಅವ್ರು ಬರ್ಲಿ ನೋಡೋಣ. ಅವ್ರು ಬಂದಾಗ ಅವ್ರು ರೆಡಿ ಪಾಸ್ ಓವರ್ ಇದು ಮಾಡಿ.
Serial number 40.
Council ಬೇರೆ
ಮನಮೋಹನ್ ಇದ್ರಲ್ಲಿ ನೋಡೋಣ ಬರ್ಲಿ ಅವ್ರೇನ ಪಾಸ್ ಓವರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಅಲ್ಲಿ ಬಡ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಬೇರೆ ಎಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಬಡ್ಸ್ ಆಕ್ಟ್
ಆಯ್ತು.
ಎಲ್ಲದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಒಂದು ಮಾತ್ರ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅದ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅದು ಎಷ್ಟು ನೋಡೋಣ, ಅವ್ರಿಗೆ ಅವಕಾಶ ಕೊಡೋಣ.
ಡೇಟ್ ಕೊಟ್ರೆ
ಕೊಡೋದು ಡೇಟ್ ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ ಈಗಾಗಲೇ 11th ಗೆ ಸಬ್ಮಿಷನ್ಸ್ ಇದ್ರೆ ಮಾಡಿ.
39 and 42.
ಹೇಳಿ 39 ಸೈಯದ್ ಅಕ್ಬರ್ ಪಾಷಾದ್ರಲ್ಲಿ ಏನಾಗ್ಬೇಕ್ರಿ? ಪೋಕ್ಸೋ ಇದೆಯಾ? HCGP is and also HCGP is directed to notify complainant / informant / victim. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದು 42 ಏನ್ರಿ?
42.
ಅದ್ರಲ್ಲೂ ಹಾಗೇನಾ? ಸೇಮ್ ಮಾಡ್ರು ಅದ್ರಲ್ಲೂ. ಬಟ್ ಡೇಟ್ಸ್ ಮಾತ್ರ 13th ಆಗುತ್ತೆ. 2 ದಿವಸ ಹೆಚ್ಚಿಗೆ ಕೊಡ್ತೀವಿ ನೋಟಿಫೈ ಮಾಡಕ್ಕೆ. 38 ಏನಾಗ್ಬೇಕ್ರಿ?
ಒಂದ್ ಕರೆಕ್ಟ್ ಮಾತ್ರ ಬೇಲ್ ಆಗಿದೆ. ಬಟ್ ಅದ್ರಲ್ಲಿ ಕಂಡೀಷನ್ ಆದ್ರೆ ಈ ವೀಕಲ್ ಕಂಡೀಷನ್ 10 days ಅಪಿಯರ್ ಆಗಬೇಕು ಅಂತ. ಈ ವೀಕಲ್
38 ಏನಕ್ಕಿದೆ ರೀ ಇದು?
ಫಸ್ಟ್ ಟೈಮ್
ಮೊದಲೇ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದೀನಿ.
ಒಂದು ಲಾಸ್ಟ್ ನಾನು ಆರ್ಡರ್ ಆಗಿತ್ತು.
ಅದು ಲಾಸ್ಟ್ ಮೇ ಆರ್ಡರ್ ಆಗಿದ್ದಕ್ಕೆ ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಅಪಿಯರ್ ಆಗಬೇಕು ಅಂತ
ಅದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ರಿ. ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಆ ಕಂಡೀಷನ್ ನ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. ದಟ್ಸ್ ಆಲ್.
ಈ ವೀಕಲ್ 10 days ಕಂಪ್ಲೀಟ್ ಆಗ್ತದೆ. ಅಪಿಯರ್ ಬಿಫೋರ್ ದಿ ಐಒ.
ಹೌದು, ಅಪಿಯರ್ ಆಗಿ
ಈ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಈ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ ರೀ?
ಸೆಕ್ಷನ್ ಸೇಮ್ ಬೇರೆ
ಅಫೆನ್ಸ್ ಬೇರೆನಾ? ಅಫೆನ್ಸ್ ಬೇರೆ ಆದ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದೇನ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಕೇಳಿ, ಹಂಗೇನಾರು ಇದ್ರೆ. ಈಗ ಇದನ್ನ ತಗೊಂಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮುಗಿತಾ ಮೇಡಮ್? ಪಾರ್ಟ್ ಥರ್ಡ್ ಇನ್ ಆರ್ಡರ್. ಏನೋ ಬೋಗಸ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಇನ್ ಫೇವರ್ ಏನು ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಅಂಡ್ ಗ್ರ್ಯಾಂಡ್ ಡಾಟರ್ ಇದಾರ? ಕೃಷ್ಣಪ್ಪ ಮನೆದು ಶಂಕರಪ್ಪ ಪಾಸ್ ಓವರ್. Paniraj Kashyap. Copy subjections on IA 1/22 to assist the prosecution, that is copy to be served to the petitioner. Serve ಮಾಡಿದಾರಾ ನಿಮಗೆ? ಮಾಡಿದಾರಾ? ನೋಡಿ. The petitioner counsel would submit that a copy of IA 1/22 is served. ಈಗ ಹೇಳ್ರಿ ಯಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಯಾರು ಇದರಲ್ಲಿ? PC ನರೇಶ್ ಕುಮಾರ್ for de facto complainant.
Directed the petitioner to stay with the complainant. Both are married.
ಯಾವ ಕೇಸ್ ಇದು?
376 matter my lord.
ಅದ ಆ ಮ್ಯಾಟರ್ ಇದು. ಬಟ್ ಇದು ಅಯ್ಯ ಇನ್ನು ಇದಾಗಿಲ್ವಾ?
It was filed.
ಇನ್ನು ಅದ್ರ ಮೇಲೆ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. ಏನಾಯ್ತು? ಇಬ್ರು ಒಟ್ಟಿಗೆ ಇದಾರ?
Even last time also
ಮಾಡಿದ್ವಿ, ಈಗಲೇ ಹೇಳಿದ್ವಿ. ಅದಕ್ಕೆ ಹೇಳಿದ್ವಿ. ಇಲ್ಲ ಇವತ್ತು ಅಯ್ಯ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ, ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ ನೋಡೋಣ.
20 days.
ಆಯ್ತು, ಏನಾಗುತ್ತೆ? ಈಗ ಒಟ್ಟಿಗೆ ಇದ್ದೀರಲ್ವಾ? ಯು ಬೋತ್ ಆರ್ ಹ್ಯಾಪಿ ನೌ.
Let there be an interim order.
ಆಯ್ತ್ರಿ, ಇಂಟ್ರಿ ಮಾಡ್ರ ಅವಶ್ಯಕತೆ ಏನಕ್ಕಿದೆ? ಈಗ ಇಬ್ರು ಮದುವೆ ಆಗಿದ್ದಾರೆ, ಈಗ ಒಟ್ಟಿಗೆ ಇದ್ದಾರೆ, ವಾಸ ಇದ್ದಾರೆ, ಏನಾಗ್ಬೇಕು? ಈಗ ಅಯ್ಯ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ, ಪ್ರಾಸಿಕ್ಯೂಟಿಂಗ್ ಅಸಿಸ್ಟ್ ಮಾಡಕ್ ಅಷ್ಟೇನೆ. ಆಯ್ತ್ರಿ, ಎನಫ್ ಏನ್ ಆಗಲ್ಲ. ಲೈಫ್ ಲಾಂಗ್ ಒಟ್ಟಿಗೆ ಇರ್ಬೇಕ್ರಿ. ಲೈಫ್ ಲಾಂಗ್ ಬೇಲ್ ಕೊಡದೆ ಇರಲ್ಲ ನಾನು. ಒಂದ್ ಸ್ವಲ್ಪ ದಿವಸ ಇದ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ. ಇರ್ಲಿ, ಏನಾಗ್ತದೆ ನಿಮ್ಗೆ? ನಾವು ಪ್ರಿಸಿಪಿಟೇಟ್ ಮಾಡ್ಬೇಡಿ ಅಂತ ಹೇಳಿದೀವಿ. ಆಯ್ತು, ಅವ್ರಿಗೆ ಹೇಳಿದಿರಲ್ಲ ಸ್ಟೇಟ್ಗೂನು. ನೀವು ಹೇಳ್ರಿ, ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡ್ರಿ. ಇನ್ನು ಲೈಫ್ ಲಾಂಗ್ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೋದು.
ಬಾಡಿಗೆ ಮನೆ ಮಾಡಿಲ್ಲ ಅಂತ, ಇನ್ನು ಬಾಡಿಗೆ ಮನೆ ಮಾಡಿಲ್ಲ ಅಂತ.
Your Honor, the petitioner is ready to stay in the complainant sister's house, but they are not willing. ಬಾಡಿಗೆ ಮನೆ ಹುಡುಕ್ತಾ ಇದ್ದಾರೆ. ಒಂದಿನ 2 ದಿನದಲ್ಲಿ ಹುಡುಕು ಅಂದ್ರೆ ಕಷ್ಟ.
ಆಯ್ತು, ಹುಡುಕ್ಲಿ, ನಿಧಾನಕ್ಕೆ ಹುಡುಕಿ. ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ ಇನ್ನೊಂದ್ ತಿಂಗಳು ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ, ಆಗ್ಬೋದಾ? ನಿಮ್ಗೆ ಅತ್ತಾನೆ ಒಂದ್ ತಿಂಗಳು ಇನ್ನೂ ಬೇಡ, ಅರೆಸ್ಟ್ ಮಾಡೋದು ಇಲ್ಲ, ಮಾಡಲ್ಲ. ಕೋರ್ಟ್ ಆಲ್ಸೋ ಪರ್ಸೂಯಿಂಗ್ ದಿ ಮ್ಯಾಟರ್. ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಅಂತ ಇದು ಸ್ವಲ್ಪ ಒಟ್ಟಿಗೆ ಇರ್ಲಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಒಂದ್ ಬಾಂಡಿಂಗ್ ಬರುತ್ತ್ರಿ, ಸ್ವಲ್ಪ ದಿವಸ ಒಟ್ಟಿಗೆ ಇರ್ಲಿ. ಬಾಂಡಿಂಗ್ ಬಂದ್ಮೇಲೆ ಸರಿ ಆಗುತ್ತೆ, ಎಲ್ಲ ನ್ಯಾಚುರಲ್ ಪ್ರೋಸೆಸ್, ಏನಾಗಲ್ಲ. ನೀವು ಇವ್ರ ಯಾರ್ರಿ ದೊಡ್ಡದವನು?
ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಆಗ್ಲಿ ರೀ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಗ್ಲಿ, ಹೈಕೋರ್ಟಿಗೆ ಬಂದಾಗ ಗೌನ್ ಹಾಕ ಬರ್ಬೇಕು ಅಲ್ವಾ? ಫೋನ್ ಹಾಕ ಬರ್ಬೇಕಲ್ವಾ? ಆಯ್ತು, ಬರ್ಬಾರ್ದು ಹಿಂಗೆ. ಯಾರೇ ಆಗ್ಲಿ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಬ್ರದರ್ ಇಲ್ಲ ಆಗ್ಲಿ ಯಾರೇ ಆಗ್ಲಿ ಕೋರ್ಟ್ ಬಂದು ಅಪಿಯರ್ ಹಾಕುವಾಗ ವಿ ಹ್ಯಾವ್ ಟು ಕಮ್ ವಿತ್ ಹೈಕೋರ್ಟಿಗೆ ಬರುವಾಗ, ಹೌದಿಲ್ಲ? ಒಂದು ಡಿಸಿಪ್ಲಿನ್. ಅದೇ ನೀವ್ ಹೇಳಿ, ಎಷ್ಟ್ ದಿವಸ ಮನೆ ಮಾಡ್ತೀರಿ? ಎಷ್ಟ್ ದಿವಸ? ನೆಕ್ಸ್ಟ್ ಮಂಡೇನಾ? ಮನೆ ಮಾಡಿ ಜೊತೆರಿ, ಸ್ವಲ್ಪ ಬಾಂಡಿಂಗ್ ಗಟ್ಟಿ ಆಗ್ಲಿ ರೀ. ಮನೆ ಮಾಡಿದ್ಮೇಲೆ ಇನ್ನೂ ಬಾಂಡಿಂಗ್ ಸ್ವಲ್ಪ ಗಟ್ಟಿ ಆಗುತ್ತೆ. ಇನ್ನು ಆಗ್ಲಿ
ಕೊಟ್ಬಿಟ್ರೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ಹೇಳಿದ್ನಲ್ರಿ, ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ. ಐ ಹ್ಯಾವ್ ಗಿವನ್ ಓರಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ನಾಟ್ ಟು ಪ್ರಿಸಿಪಿಟೇಟ್ ದಿ ಮ್ಯಾಟರ್ ಅಂತ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ಹೇಳಿದೀವಿ ಅಲ್ವಾ? ನಮ್ಗೇನ್ ಬೇರೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ, ಅವ್ರಿಬ್ರು ಒಟ್ಟಿಗೆ ಇರ್ಲಿ ಅನ್ನೋದೇನ ಆಸೆ.
ಒಟ್ಟಿಗೆ ಇದ್ದಾರೆ
ಇರ್ಲಿ ಅನ್ನೋದೇನ ಇನ್ನೂ ಸ್ವಲ್ಪ ದಿವಸ ಅಂತ. ಸ್ವಲ್ಪ ದಿವಸ ಲೈಫ್ ಲಾಂಗ್ ಇರ್ಲಿ. ಆಯ್ತು, ಲೈಫ್ ಲಾಂಗ್ ಇರ್ಲಿ. ಆಯ್ತು, ನೋಡಿ ಏನಾಯ್ತು ಹೇಳಿದಿ ಕೌನ್ಸಿಲ್. ನಾನ್ ನಿಮ್ಮನ್ನ ನೋಟ್ ಮಾಡೋದಿಲ್ಲ, ನಿಮ್ ಪ್ರೆಸೆನ್ಸ್. ಡಿ ಫ್ಯಾಕ್ಟೋ ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ಆಬ್ಸೆಂಟ್ ಅಂಡ್ ಹೆನ್ಸ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಎಷ್ಟು ವೀಕಲ್ಲೇ ಕೊಡಿ. 11th ಬೇಡ, 18th. ಆಯ್ತು, 18th ಫ್ರೈಡೆ ಅಲ್ಲ ಮೇಡಮ್, ಬೇಡ ಅಷ್ಟು ದಿವಸ ಬೇಡ, ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲೇ ಕೊಡಿ. ಯಾವ ತರ ಒಂದ್ ದಿವಸ ಅವ್ರಿಗೇನೋ ಆಂಗ್ಸೈಟಿ ಏನಾರು ಮಾಡ್ಬಿಡ್ತಾರೆ ಅಂತ. 15th ಆಗಿ ನೀವು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡ್ರಿ ಕನ್ಸರ್ಟ್ ಪೊಲೀಸ್. ಒಟ್ಟಿಗೆ ಇರೋರ್ನ ಬೇರ್ ಮಾಡೋದ್ ಬೇಡ ನಿಮ್ ಪೊಲೀಸ್. ಆಮೇಲೆ ಇನ್ನೇನ ಆಕ್ಷನ್ ತಗೊಂಡ ಆಮೇಲೆ ಅದು ಚೆನ್ನಾಗಿ ಒಟ್ಟಿಗೆ ಇದ್ದವ್ರನ್ನು ಇದಾದಂಗ ಆಗ್ತದೆ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ನಸೀರ್ ಅಲ್ಲಿ. ಸುಮಾರು ಇಲ್ಲ, ನಮ್ದೇನಿದ್ರು ಇವತ್ತಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಆಗ್ಬೋದಾ? ಆಯ್ತು, ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಪಾರ್ಟ್ ಔಟ್ ಮಾಡ್ರಿ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಅಂದ್ರೆ ಯಾವಾಗ ಮೇಡಮ್? 11th. ನಾವೇನಂದ್ರೆ ಒಂದೊಂದ್ ದಿವಸಕ್ಕೆ ಒಂದೊಂದ್ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ. ಅವತ್ತಿಗೆ ಅಷ್ಟೇ ಕೇಸ್ ಬರ್ಬೇಕು. ಎಲ್ಲಾನು ತುಂಬಿಕೊಂಡು ಆಮೇಲೆ ರೀಚ್ ಆಗದೆ ಇರೋದು ನಿಮ್ಗೂ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್, ಕೋರ್ಟ್ಗೂ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್. 46 ಶಿವಪ್ರಸಾದ್ ಎಸ್. ಇಲ್ವಾ? ಪಾಸ್ ಓವರ್. ಚೇತನ್ ಬಿ. ನೀವು ಪಾಸ್ ಅವರಾ? 48. He is A1. A1.
Complaint is at page number 14.
Charge sheet ಆಗಿದೆ ಇಲ್ಲ?
Charge sheet ಎಲ್ಲ ಆಗಿದೆ. Petitioner is 8 years.
Charge ಆಯ್ತು. 8 years?
8 months.
8 months ಇಂದ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾನೆ. ಕಾಲಮ್ ನಂಬರ್ 17 ಎಲ್ಲಿದೆ ಹೋಗಿ.
Page number 14 is the complaint.
ಕಂಪ್ಲೇಂಟ್ ಬೇಡ್ರಿ, ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ಆಗಿದೆ. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು ಅಲಿಗೇಷನ್?
Charge sheet allegation is that there are 5 persons who deceased ಮತ್ತೆ deceased friend ಹೋಗ್ತಾ ಇರುವಾಗ ಸ್ಪ್ರೈಟ್ ಕುಡಿಯಕ್ಕೆ ಹೋಗ್ತಾ ಇರುವಾಗ ಅವ್ರನ್ನ ತಡೆದು ಸಡನ್ಲಿ A1 ಮತ್ತು ಅದರ್ಸ್ ಎಲ್ಲರೂ ಸೇರಿ
1 ಮತ್ತು 2 ಆರೋಪಿಗಳು ಸಾಕ್ಷಿ ಮಂಜು ಮತ್ತು ಅವರ ಸ್ನೇಹಿತ ಬೊಬ್ಬಟ್ ಸಿಂಗ್ ಅವರನ್ನು ವಿನಾಕಾರಣ ಇದರ್ಸೆ ಬಾಗ್ರೆ ಎಂದು ಹೆದರಿಸಿ ಕಳುಹಿಸಿದ್ದು. ಸಾಕ್ಷಿ ಮಂಜು ಮತ್ತು ಅವರ ಸ್ನೇಹಿತ ಬೊಬ್ಬಟ್ ಸಿಂಗ್ ಅವರು ಸ್ವಲ್ಪ ಮುಂದೆ ಹೋಗಿ ಪುನಃ ವಾಪಸ್ಸು ಅದೇ ರಸ್ತೆಯ ವಿಘ್ನೇಶ್ವರ ಸ್ಟೋರ್ ಮುಂಭಾಗದಲ್ಲಿ ಬರುತ್ತಿದ್ದಾಗ 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಗಳು ಸಮಾನ ಉದ್ದೇಶದಿಂದ ವಿನಾಕಾರಣ ಸಾಕ್ಷಿ 1 ಮತ್ತು ಅವರ ಸ್ನೇಹಿತ ತಡೆದು 2ನೇ ಆರೋಪಿಯು ಬೊಬ್ಬಟ್ ಸಿಂಗ್ ಗುಂಡಾರ್ ಅವರ ಮುಖದ ಮೇಲೆ ಕೈಯಿಂದ ಹೊಡೆದಿದ್ದು ಸಾಕ್ಷಿ ಮತ್ತು ಬೊಬ್ಬಟ್ ಸಿಂಗ್ ಅವರು ವಿರೋಧಿಸಿದಾಗ 1ನೇ ಆರೋಪಿಯು ಬೊಬ್ಬಟ್ ಸಿಂಗ್ ಗುಂಡಾರ್ ಅವರ ಕುತ್ತಿಗೆ ಪಟ್ಟಿ ಹಿಡಿದು ಅವನ ಬಳಿ ಇದ್ದ ಚಾಕು ತೆಗೆದು ಅವರ ಎಡಗಣ್ಣು, ಹುಬ್ಬು, ಎಡ ಮೊಣಕೈ, ಎಡ ಕಿಕ್ಕೊಟ್ಟೆ, ಎದೆಯ ಬಲಭಾಗ ಮತ್ತು ಹೊಟ್ಟೆಯ ಬಲಭಾಗಕ್ಕೆ ಬಲವಾಗಿ ಇರಿದು ಕೊಲೆ ಕೈದಿರುವುದು ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಆಯ್ತು. What allegation against
my submission is this, my lord. As per the complaint,
CW1 ಇದಾನಲ್ಲ ಅವನು ಐ ವಿಟ್ನೆಸ್.
The complaint is a eyewitness, but he has not seen the full incident. Partly he seen, and thereafter he went to get his friends. After getting his friends, the dead body was lying. That is the allegation. And the police have never traced out remaining persons. The complaints they say that there are 5 persons. Only 2 persons, A1 and A2, have been falsely implicated. and there is a CC footage camera that was recorded by the police. But in the inquiry and in the report, the police have never disclosed that CC footage. And moreover, the deceased and the accused are no way relations, and there is no cause between the deceased and accused. Simply the complaint and FIR and charge sheet is that suddenly they attack and one ಚಾಕುವಿಂದ ಏವನ್ನು ಇಲ್ಲ ಅಲ್ಲಿಗಿಂತ ಇಲ್ಲಿಗೆ, and there is no cause. ಅವ್ರಿಗೆ ಯಾವುದೇ
motive, according to you, no motive.
No motive. And moreover, police have seized the CC footage that night. That has now never been produced before the. And if that has been that has been opened, the A1 and A1 is never seen at all. That has been hid by the station police. And entire charge sheet has been filed now. No necessary petitioner in the judicial custody since he is in 8 months, and the grandmother of the petitioner died yesterday. Today is the burial day. And in the all the witnesses are identical statement, copy paste. CW2 and 3
are also eyewitnesses. And as per the complaint, they are along with the accused, A1.
Along with
A1, because they are friends of CW2
and 3 along with accused. A1.
Yes. As per the complaint. And their 164 statement was recorded.
That's why, according to your argument, that they have not been arraigned as accused. Because only they have witnessed the incident and no vote of conduct.
Please. Their 164 statement was recorded, and they are also witnessed the murder. And they specifically told that because of some psychological problem, he was a little drunk, this A1, and he only stabbed. That blood-stained knife was recovered. A1 correct.
ರಿಪೋರ್ಟ್ ಬಂದಿದೆ, FSL ರಿಪೋರ್ಟ್ ಬಂದಿದೆಯಾ? ಬಂದಿದೆ. FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನಿದೆ? FSL ಅಟ್ಲೀಸ್ಟ್ ಇವುಗಳು ಪೇಜ್ ಇಂಜೆಕ್ಷನ್ ಹೇಳ್ಬಿಟ್ರೆ ನಮಗೂ ಈಸಿ ಆಗ್ತದೆ ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ. FSL ರಿಪೋರ್ಟ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ, ಓನ್ಲಿ ರಸೀಟ್ ಆಫ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ, ರಿಪೋರ್ಟ್ ಬಂದಾಗಿಲ್ಲ. ಬಂದಿದೆಯಾ?
ರಿಪೋರ್ಟ್ is that holding us. FSL report is not there. Report ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ಲ. ನೋಡಿ.
And tomorrow may submit to last according to complaint. There are read one page number 14.
ಹೇಳಿ.
ನಾನು ಮೂಲತಃ ಮಧ್ಯಪ್ರದೇಶ ರಾಜ್ಯದವನಾಗಿದ್ದು ಹೀಗೆ ಸುಮಾರು 2 ತಿಂಗಳಿಂದ ಮೇಲ್ಕಂಡಗಳ ವಾಸವಾಗಿದ್ದೆ. ಇದೇ ದಿನ ನೀವು ಬೈಯಪ್ಪನಹಳ್ಳಿ ಹೋದರೆ ಸೈಟ್ ನಲ್ಲಿ CJN ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ವತಿಯಿಂದ ಡ್ರೈವಿಂಗ್ ಆಪರೇಟರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ. ನನ್ನ ರೂಮಿನಲ್ಲಿ ನಮ್ಮ ರಾಜ್ಯದ ನನ್ನ ಸ್ನೇಹಿತರಾದ ಭೂಪತ್ ಸಿಂಗ್, ಪರಮೇಶ್ ಸಿಂಗ್, ಜ್ಞಾನ ಸಾಗರ್ ಪಡ್ವಾಲ್ ಅವರ ಜೊತೆ ವಾಸವಾಗಿದ್ದು ಇವರುಗಳು ಸಹ ಡ್ರಿಲ್ಲಿಂಗ್ ಆಪರೇಟರ್ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. ಈ ದಿನಾಂಕ ಕೆಲಸಕ್ಕೆ ರಜೆ ಇದ್ದುದರಿಂದ ನಾವೆಲ್ಲರೂ ರೂಮಿನಲ್ಲಿ ಇದ್ದೆವು. ರಾತ್ರಿ ಸುಮಾರು 9 ಗಂಟೆಯಲ್ಲಿ ನಾನು ಮತ್ತು ಭೂಪತ್ ಸಿಂಗ್ ಅವರು ಸ್ಪ್ರೈಟ್ ಕುಡಿದುಕೊಂಡು ಬರೋಣವೆಂದು ಹೊರಗಡೆ ಹೋಗಿದ್ದು ಹೊಸ ಬೈಯಪ್ಪನಹಳ್ಳಿ 7ನೇ ಕ್ರಾಸ್ ಹೋಗುತ್ತಿರುವಾಗ 5 ಜನ ಅಸಾಮಿ ನಮ್ಮನ್ನು ಏಕಾಏಕಿ ತಡೆದು ದೇರ್ ಇಸ್ ನೋ ರೀಸನ್ ಕಾಸ್ ಅಂಡ್ ಅದರಲ್ಲಿ ಇಬ್ಬರು ನಮಗೆ ಕೈಗಳಿಂದ ಹೊಡೆದಿದ್ದು ಮತ್ತೊಬ್ಬರು ಇದರ್ಸೆ ಬಾಗ್ರೆ ಎಂದು ಹಿಂದಿಯಲ್ಲಿ ಹೇಳಿದರು. ಅಲ್ಲಿಂದ ನಾವು ಸ್ವಲ್ಪ ಮುಂದಕ್ಕೆ ಹೋಗಿದ್ದು ಅಲ್ಲಿಯೂ ಸಹ ಅಂಗಡಿ ಬಾಗಿಲು ಹಾಕಿದ್ದರಿಂದ ವಾಪಸ್ಸು ರೂಮಿಗೆ ಹೋಗಲೆಂದು ಶ್ರೀ ವಿಘ್ನೇಶ್ವರ್ ಸ್ಟೋರ್ ಬಳಿ ಬರುತ್ತಿರುವಾಗ ಅದೇ 5 ಜನ ಅಸಾಮಿಗಳು ನಮ್ಮನ್ನು ಸುತ್ತುವರೆದು ನಮಗೆ ಏಕಾಏಕಿ ಕೈಗಳಿಂದ ಹೊಡೆದರು. ಒಬ್ಬ ವ್ಯಕ್ತಿಯು ಒಂದು ಚಾಕುವನ್ನು ತೆಗೆದು ಏಕಾಏಕಿ ಗುಂಪು ಎಡೆಗಣ್ಣು ಬಲ ಇದೆ ಮತ್ತು ಪಕ್ಕದ ಬಳಿ ಹೊಡೆದು ಹೊಟ್ಟೆಯ ಬಳಿದು ಹೊಡೆದು ಹೊಟ್ಟೆಗೆ ಜೋರಾಗಿ ಗಾಯಗೊಳಿಸಿದರು. ನಾನು ಭಯಗೊಂಡು ಓಡುವಾಗ ಅಲ್ಲಿದ್ದ ಒಬ್ಬನು ಇಷ್ಟು ಜಾಸ್ತಿ ಹೊಡೆಯಬೇಡ ಎಂದು ಕನ್ನಡದಲ್ಲಿ ಹೇಳುತ್ತಿದ್ದನು. ನಾನು ಅವರಿಂದ ತಪ್ಪಿಸಿಕೊಂಡು ರೂಮಿಗೆ ಓಡಿ ಹೋಗಿ ರೂಮಿನಲ್ಲಿದ್ದ ನನ್ನ ಸ್ನೇಹಿತರನ್ನು ಕರೆದುಕೊಂಡು ಸ್ಥಳಕ್ಕೆ ಬಂದಾಗ ಆ ಆಸಾಮಿಗಳು ತಪ್ಪಿಸಿಕೊಂಡಿದ್ದು. ಭೂಪತ್ ಸಿಂಗ್ ಗೊಂಡ ರಸ್ತೆಯಲ್ಲಿ ಅವರು ನಮಗೆ ಹೊಡೆದ ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿ ಕುಸಿದು ಬಿದ್ದಿದ್ದು. ಆತನ ಎಡಗಣ್ಣಿನ ಬಳಿ ಬಲ ಎದೆಯ ಕೆಳಗೆ ಎಡಪಕ್ಕೆಯ ಬಳಿ ಹಾಗೂ ಹೊಟ್ಟೆಯ ಎಡಭಾಗ ಇಳಿತದ ರಕ್ತ ಗಾಯಗಳಲ್ಲಿ ಆತನಿಗೆ ಪ್ರಜ್ಞೆ ಇರಲಿಲ್ಲ. ನಾವು ಆಂಬುಲೆನ್ಸ್ಗೆ ಕರೆ ಮಾಡಿ ಬೋರಿಂಗ್ ಮತ್ತು ಲೇಡಿ ಕ್ರಿಶ್ಚಿಯನ್ ಆಸ್ಪತ್ರೆಗೆ ರಾತ್ರಿ 10:30 ಕರೆದುಕೊಂಡು ಹೋದಾಗ ವೈದ್ಯರ ಪರೀಕ್ಷಿಸಿ ಭೂಪತ್ ಸಿಂಗ್ ಗೊಂಡ ಮಾರ್ಗ ಮಧ್ಯದಲ್ಲಿ ಮೃತರಾಗಿರುತ್ತಾರೆ. ನನ್ನನ್ನು ಮತ್ತು ಭೂಪತ್ ಸಿಂಗ್ ಗೊಂಡನನ್ನು ತಡೆದು ಹಲ್ಲೆ ಮಾಡಿದ ವ್ಯಕ್ತಿಗಳು ಸುಮಾರು 20 ರಿಂದ 30 ವರ್ಷ ವಯಸ್ಸಿನವರು. ಕಳ್ಳನೆಯ ಮೈಕೊತ್ತು ಹೊಂದಿದ್ದು ಕನ್ನಡ, ಹಿಂದಿ ಮಾತನಾಡುತ್ತಿದ್ದು. ಅವರನ್ನು ನಾನು ಇದೇ ಹೊಸ ಪ್ರಯತ್ನದಲ್ಲಿ ಆಗಾಗ್ಗೆ ಸಂಜೆ ವೇಳೆ ನೋಡಿದ್ದು. ಅವರ ಹೆಸರು ನನಗೆ
and Essential Commodities Act.
ಅವರಿಗೆ ಮಾತನಾಡಿಕೊಳ್ಳಿ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ನಾನು ಅವರು ನೋಡಿದ್ದು ಪುನಃ ನೋಡಿ ಉದ್ದೇಶಿಸುತ್ತೇನೆ. Remaining for 5 persons are there. The police have not at all traced them. And moreover, remaining point is the police have seized the CCTV footage that has not been disclosed. If that is opened and seen the CCTV footage photo, the petitioner
CCTV footage seize ಮಾಡಿದಾರೆ ಅಂತ ಕೇಳಿದೆ.
ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಇದರಲ್ಲಿ ಎಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ.
ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು ಏನು ಬೇಸಿಸ್?
ಮಾಡಿದ್ದಾರೆ, ನಮ್ಮ
ಬೇಸಿಸ್ ಏನು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಸೀಸ್ ಮಾಡಿ ಅವರು ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಡೈರೆಕ್ಟ್ ಹಿಮ್ ಟು ಪ್ಲೇಸ್ ಸೇಮ್ ರಿಪೋರ್ಟಿಂಗ್.
ಅದನ್ನ ಮಾಡ್ಬೋದು.
ಅದಕ್ಕೆ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ತೋರ್ಸಕ್ ಏನಿದೆ ನಿಮ್ಮ ಹತ್ರ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ನೀವು ಬಂದು ಸುಮ್ಮನೆ ಬಂದಿಲ್ಲ CCTV ಫುಟೇಜ್ ಇದೆ ಕೊಡಿ ಅಂತಂದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ? ಏನೇ ಮಾಜರ್ ಇದೆಯಾ? ಸೀಸರ್ ಬಗ್ಗೆ ಮಾಜರ್ ಇದೆಯಾ? ತೋರ್ಸಿಲ್ಲ, ನಾನೇನ್ ಮಾಡಕ್ಕಲ್ಲ. ಪ್ಲಸ್ ಸೀಸ್ ಮಾಡಿನೂ ಅವ್ರು ಕೋರ್ಟ್ ಮುಂದೆ ಇಟ್ಟಿಲ್ಲ, ಸಪ್ರೆಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಡೈರೆಕ್ಟ್
that is the one of the main ground.
ಮೇನ್ ಗ್ರೌಂಡ್ ಗೆ ದಾಖಲೇಬೇಕು ನನಗೆ.
ಅದಕ್ಕೆ ನಾನು
ನೀವು ಹೊಸಾರು ಬಂದು ಹೇಳಿ ನಾನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
CC ಫುಟೇಜ್ ಇತ್ತು, ಸೀಸ್ ಮಾಡ್ರಕ್ ನಾನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ? ದಟ್ ಇಸ್ ದಿ ನಾನು ಅವ್ರು ಮಾಡಿದಾರೆ ಅಂತ ಹೆಂಗೆ ಏನ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ?
That's all your argument.
And the yesterday
grandmother
plays the burial day. And since from 8 months is chasing, the petitioner is avoided with any conditions.
ಅಂದ್ರೆ ನಿಮ್ದು ಬ್ಲಡ್ ಸ್ಟೈನ್ ನೈಫ್ ಸೀಸ್ ಆಗಿದೆ, ಕ್ಲಾತ್ ಏನಾರು ಸೀಸ್ ಆಗಿದೆ, ಒಂದು ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾತ್.
ಇವ್ರದೇನಿಲ್ಲ, ಓನ್ಲಿ ಚಾಕು, ನೈಫ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸೀಸ್. ದಟ್ ಈಸ್ ದಿ ಓನ್ಲಿ ಇದಷ್ಟ. ದಟ್ ಈಸ್ ದಿ 164 statement of CW2 and 3. ಇವೆಲ್ಲ ಸೈಕಲ್ ಸ್ಟೇಟ್ ಅವೆಲ್ಲ.
But the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 14/11/2021 at about 9 p.m. when the CW1 and his friend, that is victim, going to have this Sprite near Payapanalli 7th Cross, this petitioner and other accused number 2 abused and threatened the victim, and when both of them went forward and returning in the very same road near Vigneshwara store, this petitioner and accused number 2 with the common intention wrongfully restrained the CW1 and victim, and accused number 2 fisted on the face of the victim, and when both the CW1 and victim registered the same, this petitioner with the knife inflicted injury on his neck. hold on neck holding his collar putty, an inflicted injury with his face, eyebrows, left hand and left abdomen and on the chest, and also inflicted injury on the right portion of the body. As a result, he succumbed to the injuries. The counsel appearing for the petitioner would submit that in the complaint, specific allegations are made against 5 persons, but only file the charge sheet against accused number 1 and 2. The counsel also would submit that no action taken against other accused persons who are there at the spot along with this petitioner and accused number 2. The counsel also would submit that there was a CCTV footage at the scene of occurrence and the same has not been placed before the court. The counsel also would submit that the prosecution mainly relies upon the statement of CW2 and 3. And this petitioner is in custody from last 8 months. The police have already completed the investigation and filed the charge sheet. No need of further custodial trial. The counsel also would submit that accused number 2 has already been granted bail.
No relation between petitioner
And the counsel also would submit that no relationship between the victim and this petitioner, and both of them are strangers, and also no motive for committing the murder. The counsel also would submit that grandmother passed away yesterday and today there is a cremation, and hence he may be enlarged on bail. For contra, the counsel appearing for the state would submit that the CW2 and 3 who were there along with the accused at the time of the incident, and they have witnessed the incident of inflicting the injury by this petitioner, and both of them are eyewitnesses to the incident. The counsel also would submit that their statement was recorded before the learned magistrate under 164 of CRPC. The counsel also would submit that bloodstained knife was recovered at the instance of this petitioner, and the same was sent to the FSL, and FSL report is also awaited. And hence there is a prima facie case against the petitioner herein, and hence not entitled for bail. Having heard the respective counsel and also on perusal of material, the specific allegation against A2 is that he fisted on the face of the victim. But specific overt act allegation against this petitioner is that he inflicted injury with knife all over the body. The cause of death is mentioned in the postmortem report on account of multiple injuries sustained by him. The statement of CW2 and 3 that they are the eyewitnesses to the incident, and both of them were along with the accused at the time of the incident.
The complaint is
Apart from that, CW1 is also along with the victim, and when they started inflicting injury, when this petitioner started inflicting injury with knife, he went and brought other his roommates, and in the meanwhile he was lying in the spot, and that is the statement of CW1. When the CW2 and 3 statement was also recorded before the learned magistrate, that they are the eyewitnesses to the incident, and apart from that, bloodstained knife was recovered at the instance of this petitioner, and the same is also seized and sent to the FSL, and the report is awaited. And hence there is a prima facie case against the petitioner herein, and specific court act allegation is also made against him by CW1 to 3. The very contention of the petitioner counsel that this petitioner is in custody from last 8 months cannot be a ground to enlarge him on bail, since heinous offense of murder has been committed. The counsel would also submit that no motive to commit the murder, and the same can be considered in the course of trial and not at this stage. The other contention of the petitioner counsel that grandmother has been passed away, and there is a cremation today. And on the ground of the cremation of grandmother also the petitioner cannot be released when he inflicted injury with knife. That too on the over the body of the victim, and the cause of death is also on account of multiple injuries sustained by him. Hence, not a case for enlarging him on bail. You have the discussions made up by past following order. Bail petition is rejected. 49. PP 302 114.
Please.
Last time,
CDR ಬಗ್ಗೆ.
One more. The facts of the
CDR.
What is the case of prosecution? Accused number 1 is the son of deceased.
A1 is the son of deceased.
Accused number 1 and accused number 2 are friends.
Accused number 1 and 4. Two are friends.
The accused number 1 wanted the entire property of his mother to be given to him. That is the motive against it. Then it is further case of prosecution not that accused number 1 and accused number 2 conspired to commit murder of the deceased. Turn accused number 2 contacted accused number 3 to 5. Present petitioner is accused number 5. And it is further case of prosecution not that on 15/10/2021 at about 8:30 p.m. accused number 2 to 5 were waiting near the house of the deceased. Accused 3 and 4 entered the house of the deceased and committed her murder. And when they came out from the house, accused number 3 and 4, they were apprehended by the public on the spot. And on the last occasion, Lord, I pointed out to your Lordship that it is the case of prosecution that they were, accused number 2 to 5 were staying in lodging. And Lordship just wanted to know whether CDR indicates that they were in the said lodge. So as far as that is concerned, my Lord, the CDR shows that all the accused persons, 2 to 5 were in Chikkaballapur.
Chikkaballapur.
Yes. Know that the one tower covers a very huge area. And this specific case of prosecution, my Lord, that I was present when the offense was committed near the house of the deceased. In this regard, my Lord, I would like to call your Lordship's attention. The CDR which I have prosecution has produced. CDR pertaining to the petitioner are from page number 148 to 160, my Lord.
160.
Yeah. I request your Lordship to come to page number 160. So we can see on the left hand side, the serial numbers of calls is mentioned. 1190, your Lordship, 11,790. Serial number 11,790.
719.
Yes, on the left hand side. Shows that, my Lord, at 11:52, my Lord, I was in Chikkaballapur.
790 ಯಾವ್ದಿಲ್ವಲ್ಲ 740 ಇದೆ 740 ಇದೆ ಎಷ್ಟನೇದು ಹೇಳಿ 3 4 5ನೇದು 740 ಇದೆ ಕೆಳಗಿಂದ 4ನೇದ 789 ಇದೆ 789
Yes, 11,790. I was in Chikkaballapur at about 11:52, that is about 12 o'clock. Then your Lordship, the next entry is not by 22:90. That means by 9:19 I was in Andhra Pradesh. And my instructions were not that the distance between the Chikkaballapur and this particular village is more than 500 meters. So Lordship, I can see that by 9 o'clock, if I am there, I must have left immediately after 11:52. So my presence at the scene of offense at 8:30 p.m. on that day is totally falsified. So when attempt is made by the prosecution to say that I was in custody, I was present on the scene of offense, it's falsified. But other circumstances may also have to be viewed with suspicion. And other circumstances, but of course, I have pointed out to the Lordship on the last date of appeal, last day of hearing, that it is not on page number 67, my lord. The statement of Ramakrishna Reddy. He is a boy working in that particular lodge where it varies that we were all residing. But he has only identified accused number 3 and 4, 3 and 4. He has not identified me, and I have not been sure. One circumstance. And another circumstance also, my lord, that is on page number 69. According to prosecution, Lord, the knives were purchased by accused number 2 and the present petitioner. Lordship, kindly say I have. Lordship, kindly permit me to read this statement once again. ದಿನಾಂಕ 24/10/2021 ನಾನು ಅಂಗಡಿಯಲ್ಲಿ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಿದ್ದೆ. ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಪೊಲೀಸ್ ನಮ್ಮ ಅಂಗಡಿ ಬಳಿಗೆ ಇಬ್ಬರು ಆತನನ್ನು ಕರೆದು ಅವರನ್ನು ನಮ್ಮ ಅಂಗಡಿಯ ಬಳಿ ವಿಚಾರ ಮಾಡುತ್ತಿದ್ದೆ. ದಿನಾಂಕ 14/10/21 ನಮ್ಮ ಅಂಗಡಿಯಲ್ಲಿ 2 ಚಾಕುಗಳನ್ನು ಖರೀದಿ ಮಾಡುವುದಾಗಿ ಹೇಳಿದರು. ನಾನು ಸಹ ಸದರಿ ಚಾಕುಗಳ ಫೋಟೋಗಳನ್ನು ನೋಡಿ, ಒಂದು ಚಾಕು ಮರದ ಹಿಡಿಕೆ ಬಂದಿತ್ತು, ರಕ್ತ ಸಿದ್ಧವಾಗಿತ್ತು, ಮತ್ತೊಂದು ಚಾಕು ಪ್ಲಾಸ್ಟಿಕ್ ಹಿಡಿಕೆ ಒಳಗೊಂಡಿರುತ್ತದೆ. 2 ಚಾಕುಗಳು ನಮ್ಮ ಅಂಗಡಿಯಲ್ಲಿಯೇ ಸಿಗುವ ಚಾಕುಗಳಾಗಿರುತ್ತದೆ. ಪೊಲೀಸರು ಕರೆದುಕೊಂಡಿದ್ದ ವ್ಯಕ್ತಿಗಳ ಹೆಸರು ಕೇಳಿದಾಗ it doesn't say that, my lord, we are the persons who have purchased the knives from the same shop, but such knives are being sold in that shop. Only on the basis of the say of the police, he came to know of these and there are no similar antecedents against this gentleman. Also, he is married and having 2 minor children.
Yes,
Lord, nothing is recovered from him.
A2 and A5 are the friends, and initially A3 is initially
A1 and 2 friends.
Right?
A5?
A5 and A2 are friends.
A2 and A5 are friends.
So far, A1 to A2. Intern, both are residents of Hyderabad. A2 was doing pimp job there in Hyderabad. A5 also doing the same job in Hyderabad. And my lord, A2 knows A3, the main assailant. He started calling him from 1/10/2022.
1/10/22.
I had given CDR, my lord. This A5 was using 2 mobile phones. One number is 90100071157. The CDR shows that he was frequent touch with A3, A4, A2. I have marked in CDRs. That phone number will be switched off on 13/10. They left from Hyderabad on 13/10. And he started communicating in another number, 96183859666. It was recorded from his position. There are 2 SIMs are used in one phone, but one SIM was deactivated, and he started, after coming to Chikballapur, he started communicating in another SIM. In that, my lord, from 13/10 onwards, he started communicating with all the 3, and he stayed along with all the 4 persons stayed in the same lodge. And my lord, immediately when the A3 and A4 was caught red-handed, there with the other witnesses, at that time also A3 calls to A5, 823, because they are
Immediately apprehending him.
they are inside the compound. A2 and A5 are outside the compound, just 20 feet away. When the people are caught red-handed, this 2 and 5 started running away from the spot. It was not witnessed by any person because like public, they are outside the compound. And after catching that A3 had called 823, we caught out by public. And once again, A5 contacted A4 by 844 after the murder. And even 855 also they called. By that time, they started leaving the Chikballapur. This is the main evidence.
Lordship, I was present in Chikmagalur for last time. It was 11:52 in the morning, according to the CDR produced by the prosecution itself. Then by 9:15, I am in Hyderabad, I mean, in Andhra Pradesh, which are away from 500 kilometers away from. No question of CDR should also reflect the call is made by.
ಆಯ್ತು 844 845 ಅಲ್ಲಿ ಕಾಲ್ ಮಾಡಿದಿರಲ್ಲ ನೀವು ಆವಾಗ ಎಲ್ಲಿದ್ದೀರಿ?
Lordship, by 11:52 I have left this. Thereafter there are no calls.
11 na?
11.
Incident at what time?
8:30 in the evening, night.
8:30 in the evening.
Yes.
What time you left? What time you left?
According to the CDR, Lord, on 15/10/2022 level, the last call which was made or received is in the morning at about 11:52.
Morning 11:52.
Lordship, I can refer to page number 160.
ನಿಮ್ಮ ಟೈಮಿಂಗ್ಸ್ ಈಗ ಹೇಳಿದ್ರಲ್ಲ 8:44 8:55.
The phone number 961 8385 966. That number last page ಅಲ್ಲಿ ಇದೆ.
ಇದೆಯಾ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ?
Last page.
A5 A4 A5 A3 A5 A4 A5 A3 all at 20 23 20 36 20 44 20 55. These are the calls. Nodili.
According to the prosecution,
These are the phone calls.
according to the case of prosecution, for the CDR of my calls, I have produced on page number 148 to 160. These are the CDRs given to me by the prosecution. If we go by this, my lord, 11:52 was the last moment which I was in Chikmagalur. And thereafter only at 9:15 I am in my village, which is more than 500 kilometers. That if the
ಅದು ಯಾವ ನಂಬರ್ ಅದು?
this number is my number according to the 9060 624 4268.
68. That is different number.
That is the phone according to the prosecution. This is the phone seized from my possession.
No, total two SIMs.
That's the J2 number. 458. So this is the number, of course, I have got from the statement. Let me see. Caesar Mahagar note. Caesar Mahagar note.
Chikmagalur. ನಂಬರ್ ಎಷ್ಟು ಒಂದು ಅಕ್ಯೂಸ್ ನಂಬರ್?
ಎರಡು ನಂಬರ್, ಒಂದು
ಯಾವ್ದಾದ್ರು ಹೇಳಿ.
90 1000 7157 and another number is 961 8385 966.
966.
In Chikmagalur, he used that 966 number last.
966. ಅದೇ 844 855 ಅಲ್ಲಿ. ಎಲ್ಲ ಅಲ್ವತ್ತಿನ ದಿವಸ ಎಲ್ಲ ಹೋಲ್ ಡೇ ಎಲ್ಲ ಚಿಕ್ಕಬಳ್ಳಾಪುರದಲ್ಲೇ ಇದಲ್ಲ. ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಬೇರಿಂಗ್ ನಂಬರ್ 13/448 ವಾರ್ಡ್ ನಂಬರ್ so and so.
Statement is on page number 117. And according to them, this is my phone number 906062 4268. 4268. That is the CDR.
ಸೀಸರ್ ಯಾವ್ದು ಮಾಡಿರೋ ಅವನ ಹತ್ರ ಇಟ್ಟಿದ್ದಾರೆ ಅವತ್ತಿನ ದಿವಸ.
This is the number 9060624268. That is the number which I have referred.
Incident at 8:30. ಹೌದಾ? Incident at 8:30.
I am in my village by 9:15, which is 500 kilometers away from Chikmagalur. The last call which reflects in my CDR is 11:50 in the morning. And thereafter only our location is shown that I am in my village. My CDR does not reflect any call from accused number 3 and accused number 4.
ಯಾರು ಐ ವಿಟ್ನೆಸಸ್ ಸರ್ ಇದ್ದಾರೆ?
Eyewitness ಇಲ್ಲ sir, eyewitness.
ನಾನು ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಹಾಕೋರ್ನ CW.
ಅದಕ್ಕೆ ಇನ್ಸಿಡೆಂಟ್ ಗೆ 2-3 ಆರ್ ಕಾಟ್ ರೆಡ್ ಹ್ಯಾಂಡೆಡ್ ಅಲ್ವಾ?
ಅಲ್ಲಿ
ಮನೆಯಿಂದ ಹೊರಗೆ ಬಂದ ತಕ್ಷಣ
2-3 regarding 2-3 is concerned.
Yes,
There are
yes.
3 eyewitnesses. Out. Out the petitioner, counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that accused number 1 is the son of the deceased and accused number 2 is the friend of accused number 1. The motive for committing the murder is in respect of the property. Accused number 3 to 5 are engaged by accused number 2 since A1 given superior to accused number 2. That on 15/10/2021 at 8:30 p.m. accused number 2 to 5 were watching near the house of the victim, and A3 and A4 went inside the house of the victim and committed the murder, and immediately A3 and A4 were arrested by the general public at the spot. And also case of the prosecution is that all of them stayed together in a lodge before committing the murder. And thereafter apprehended the accused persons, and case also registered and investigation is also conducted and filed the charge sheet. The present petitioner is accused number 5, and counsel appearing for the petitioner would submit that the only case against this petitioner is that he was watching outside the house of the victim, and no overt act allegation against this petitioner, and only relying upon the statement of a large boy. But he identified only accused number 3 and 4 and not identified this petitioner. Only on suspicion, this petitioner has been implicated in the case. The counsel also would submit that no recovery, but in instance of this petitioner, hence this petitioner may be enlarged on bail. For contra, the counsel appearing for the state would submit that this petitioner and accused number 2 are the friends. And accused number 2 knows A3. And accused number 2 given the superior to accused number 3 to 5.
What's the only touch number 2? Sir, he the contest number 2.
3. A2 gave 3 to 5.
3 is a friend of it. A5.
3 is the friend of
A5.
3 to 5. The counsel would submit that CDR collected by the IO discloses from 1/10/2022. But incident was committed, incident of murder was committed on 15/10/2022. The counsel also would submit that this petitioner was using 2 mobile phones, and he was in constant touch with accused number 2 to 4. Both the SIMs are our submission and ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಇಲ್ಲ ಸ್ಟೇಟ್ ಅಂತ ಬಂದಿದೆ ಮೊದಲೇ ಬರ್ಕೊಂಡು ಏನಾಯ್ತು ಮೇಡಮ್? Both the SIMs are seized at the instance of the petitioner hearing. The counsel appearing for the state also would submit that all of them stayed together in a lodge. And immediately when the accused number 3 and 4 are caught hold of by the public at the spot, the accused number 5 made a phone call to accused number A4. By his using mobile number 9618385966. And he spoke with him for about 101 seconds, 194 seconds, 246 seconds, and 64 seconds. And all of the tower location is also particularly in respect of the place of incident. The counsel also would submit that he also called A3 and spoke to him 266 seconds. That is at 8:23. And this petitioner called A4 also at 20:44 p.m. And again he called A3 at 8:55 p.m. And tower location also is very clear that all of them were together and committed the murder. But when the accused number 3 and 4 are caught hold of by the public, this petitioner left the place. And hence there is a prima facie material before the court that before committing the murder, they are all of them in constant touch with 11022 till the date of committing the murder. And though there was no any recovery, CDR report is very clear that this petitioner was in the place of incident and watching along with A2 outside the house, and A3 and A4 went and committed the murder and they were apprehended. Having heard the respective counsel and also on perusal of material available on record, this petitioner is arraigned as accused number 5. And case of the prosecution also that all of them joined together in committing the murder of the victim. The A2 and A5 are friends according to the prosecution. And also he was in touch with the other accused from 11022. And no doubt the eyewitnesses CW 2 to 4 are with regard to apprehending accused number 3 and 4. And in order to connect this petitioner, prosecution mainly relies upon the 2 telephone SIMs which have been. And the tower location is also collected by the IO. And CDR report is also clear that he was using both the telephones, both the mobiles. And apart from that, prosecution also relies upon the statement of the large boy and contention of the petitioner counsel that he identifies only accused number 3 and 4. And the fact that all of them stayed in the lodge at Chikballapur. Chikballapur lodge tane? Chikballapur. And all the tower location in between the accused number 2 to 5 were there at the spot. When such being the material available on record, when CDR is collected and tower location is there, and the very contention of the petitioner counsel that at 11:22 itself, he was at Andhra Pradesh on that day. In respect of other mobile is concerned, and the same cannot be a ground to enlarge the petitioner on bail. The very case of the prosecution that 2 SIMs are seized from the instance of this petitioner, and apart from that, this petitioner contracted accused number 4, 3 at the spot itself, and tower location is also nearby the place of incident. When such being the material available on record, it is not a fit case, and the grounds which have been urged by the petitioner counsel before this court can be urged before the trial court during the course of the investigation. Hence, there is a prima facie case against the petitioner that this petitioner is in constant touch with accused number 2 to 5 from 110-2022 till the committing the murder of the victim. In view of the discussion made about order, bail petition is rejected. What is our?
Three years and 5 months.
3 years, 5 months.
ಎಲ್ಲ witnesses almost
ವಿಚಾರಣೆ ಆಗಿದೆ.
ಜನ witnesses 3 ಜನ given up ಬರ್ತಾನೆ ಇದೆ. Investigation ಎಲ್ಲ ಆಗಿದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ, ಎಕ್ಸಾಮಿನೇಷನ್
ನಾನು ಇಲ್ಲಿ ಸಿಟ್ಟಿಂಗ್ ಅಲ್ಲಿ 439 ಅಲ್ಲಿ ಕುತ್ಕೊಂಡು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಮೆರಿಟ್ಸ್ ಕೇಸ್, ಹೌದಲ್ಲ? ಅದೆಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಬೇಕು. ದಿಸ್ ಕೋರ್ಟ್ ಕೆನಾಟ್ ಯುಸರ್ಪ್ ದಿ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನಿಮ್ ಗ್ರೌಂಡ್ ಏನ್ ಈಗ ಇಲ್ಲಿ ಈ ಕೋರ್ಟ್ ಮುಂದೆ?
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ಮುಗಿದ ಮೇಲೆ
ಪನಿಷ್ಮೆಂಟ್ ಎಷ್ಟು ವರ್ಷ? ಲೈಫ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್, ಹೌದಾ? ಮತ್ತೆ 3 ವರ್ಷ, 3 years, 5 months is a ground. Is it a ground? Taking of a life of a person, howda? You take the order on merits before the trial court only. Examination of some of the witnesses is not a ground.
ಐವಿಟ್ನೆಸ್ ಕೂಡ ತುಂಬಾ ಕಾಂಟ್ರಡಿಕ್ಟರಿ.
ಆಯ್ತ್ರಿ, ಅದನ್ನ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಕಾರದ ಅವ್ರು, ನಾನ್ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ. Whether I can appreciate the evidence of the trial court witnesses? ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು. ഞാൻ ಬೇಗ ಡಿಸ್ಪೋಸಲ್ ಬೇಕಾದ್ರೆ ಹೇಳೋಣ ಅಷ್ಟೇ. That's all.
Eyewitness examined and he supported the prosecution case.
ಸಪೋರ್ಟ್ ಮಾಡಿದಾರೆ.
ಅದರಲ್ಲೂ ಕಾಂಟ್ರಡಿಕ್ಟರಿ ಇದೆ.
ಆ ಕಾಂಟ್ರಾಡಿಕ್ಷನ್ಸ್ ನೀವು ಅಲ್ಲಿ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ಬೇಕ್ರಿ. ಕಾಂಟ್ರಾಡಿಕ್ಷನ್ಸ್, ಒಮಿಷನ್ಸ್ ಎಲ್ಲ ನೀವು ಅಲ್ಲೇ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ಬೇಕು. ಒಮಿಷನ್ಸ್, ಕಮಿಷನ್ಸ್, ಕಾಂಟ್ರಾಡಿಕ್ಷನ್ಸ್ ನಿಮ್ ಕೇಸ್ ನೀವು ಅಲ್ಲಿ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಡಬಲ್ ಮರ್ಡರ್ ಕೇಸಾ? ಅಲ್ಲೇ ಒಮಿಷನ್ಸ್, ಕಮಿಷನ್ಸ್, ಕಾಂಟ್ರಾಡಿಕ್ಷನ್ಸ್ ಎಲ್ಲ ಅಲ್ಲೇ ಟ್ರಯಲ್ ಕೋರ್ಟೇ ನೋಡ್ಬೇಕು. Heard the petitioner, counsel and also the counsel appearing for the state. This is a successive bail petition. Earlier ಬಂದು ಹೋಗಿದ್ದೀರಲ್ವಾ ನೀವು? ಸೈಟೇಷನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಮೊನ್ನೆ May 24th ಕೇಳಿದ್ದಾರೆ, ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ. ಬೇಕಂದ್ರೆ ಅಪ್ಡೇಟ್ ನಿಮ್ಗೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀನಿ. ಬೇಕಾ? ಮಮತಾ ಕೇಸಲ್ಲಿ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಹೇಳೋರು. ಬೇಕಂದ್ರೆ ಹೇಳ್ತೀನಿ ಮಮತಾ ಕೇಸ್. Mamata and another 24th May. Heard the petitioner, counsel and also the counsel appearing for the state. This is a successive bail petition filed by the petitioner before this court, and earlier this court considered the bail petition in criminal petition number 6745 of 2019 with order dated 21st day of January 2020, and also in the month of 10th of December 2020 in criminal petition number 7487 of 2020. The main contention before this court is that prosecution witnesses were examined before the trial court, and there are contradictions in the evidence of prosecution witnesses, and this petitioner is in custody from 3 years 5 months. 3 years 5 months. ಆಯ್ತು ಹೇಳಿ.
ಎಕ್ಸಾಮಿನೇಷನ್ ಆದ್ಮೇಲೆ ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಬಹುದು.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಆಯ್ತು ಬರ್ತೇನೆ. ಅದೇ ರೀ. And this court with order dated 10th day of December 2020, liberty is reserved to the petitioner to renew his prayer for bail before the trial court after the examination of CW6. Trial court anta liberty ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. The counsel also submits that after the examination of CW6, bail petition was moved before the trial court, and the trial court has rejected the bail petition while order dated 6th day of December 2021, and hence petitioner may be enlarged and bail. For contra, the counsel appearing for the state will submit that the liberty is given to approach the trial court, and the liberty was already exercised by filing an application, and trial court rejected the same. And apart from that, counsel appearing for the state will submit that the prosecution witnesses have been examined before the trial court, and all of them have supported the case of the prosecution. And counsel also submits that it is a case of double murder, and no grounds are made out. Having heard the respective counsel, and this court already considered the matter on merits when disposing of the criminal petition number 6745 of 2019 dated 21st day of January 2020. No doubt this court also given the liberty to approach the trial court after the examination of CW6. And after the examination of CW6, a bail petition was filed before the trial court, and the same is also rejected. When such being the material on record, this court cannot sit and appreciate the contradictions which have been pointed out by the petitioner counsel before this court, and this court cannot usurp the jurisdiction of the trial court appreciating the evidence of prosecution witnesses. And the counsel appearing for the state also would submit that witnesses have supported the case of prosecution before the trial court. And when considering the material available on record, and particularly some of the witnesses have been examined before the trial court and yet to complete the evidence of prosecution. The apex court also in the judgment reported the reportable judgment of Mamata and another was a state within bracket NCT of Delhi and another criminal appeal number 878 of 2022 dated 24th of May 2022, and that an important circumstance which should have come up but has not been taken into consideration by the High Court is that crucial witnesses are yet to be examined. The release of the second respondent on bail, at this stage, would run a grave risk of impeding a fair trial. The apprehension of the appellants and of the prosecution that the witnesses may be tampered with cannot be regarded as lacking in substance. Having considered the material and record and also the principles laid down in the judgment, and remaining witnesses have to be examined before the trial court. And when such being the case, this court already pointed out that this court cannot usurp the jurisdiction of the trial court for appreciating of the contradictions, omissions, and commissions. Sitting in considering the matter under section 439 of CRPC, in view of the discussions made up by Pasipalanggoda, bail petition is rejected. However, the trial court is directed to dispose of the matter as early as possible, and some of the witnesses have been examined before the trial court.
The offences are 354, 354, 323, 506, 341 of IPC and 12 and 18.
12 and 18.
12 and 18 of this.
No, charge sheet already filed.
That should have been filed. Complaint. That page.
Notify Madidara. Victim is not notified, and hence learned HCCP is once again directed to notify the victim. Madidara. Madam order sheet. HCCP is direct. HCCP submits that already notified the victim. Mother. Victim of the mother.
Subsequent complaint after crime number 6 of 22, which was instituted before the Karnataka police, wherein complaint being at page 24.
Earlier, one more complaint was given
Against the other accused.
Other accused, not against these accused.
Not against.
And page number
26 is the type copy of the complaint.
26.
And as per the complainant, there are two separate dates that are put: 23rd of February and 21st of February. Very complaint is ambiguous. Doesn't disclose when the actual offense happened. And this complaint is a direct follow-up to the protest of the people against the father of the complainant. And I have already produced the same. There were two complaints given to the local authorities against the father of the complainant. The first being to the DC on 22nd of September 2021, which I have produced in page 48 and 49 is the type of
earlier complaint.
This is the complaint given by the people of Karnataka against the father of the complainant.
Against the father of
the complainant, who has been creating a lot of trouble for all the business community and other people. Complaint being as follows:
this is in September.
Hardware Malikarada this complaint was the reason for the backlash and two complaints being
whether in this complaint these petitioners are also the complainants,
people who took lead as protesters. The father of the first petitioner was the leader of the business community. And he was
ಆಯ್ತು
the head of the
ಏನು ಅಲಿಗೇಷನ್ ಏನ್ರಿ 12 and 18 ಪೋಕ್ಸೋ ಆಕ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನ್ ಅಲಿಗೇಷನ್ ಅಂದ
ನನ್ನ ತಂದೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ, ನಾನು ಸುಮ್ಮನೆ ಬಿಡುವುದಿಲ್ಲ ಅಂತ ಗೌತಮ್ ಮತ್ತು ರಾಜು ನನ್ನ ಕೈ ಕಾಲುಗಳಿಗೆ ಹೊಡೆದು ಗಾಯ ಮಾಡಿರುತ್ತಾರೆ. ಇದರಿಂದ ನನಗೆ
ನನ್ನ ತಂದೆ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದೀಯ ಅಂತ
4 ಜನರು ನನ್ನ ಕೈ ಕಾಲು ಎಳೆದಾಡಿ ಹೊಡೆದು ಬಟ್ಟೆಯನ್ನು ಹರಿದು ಹಾಕಿದ್ದಾರೆ.
ಇಂಜುರೀಸ್ ಇದೆಯಾ ಹೊಡೆದಿದ್ದು?
There is an injury.
ಏನು ಇಂಜುರಿ ಸರ್?
Linear scratch mark of 4 centimeters left, linear scratch mark of 3 centimeters right forearm, linear and scratch mark of
simple in nature.
1 to 5 injuries are there. All scratch in it.
Good. Heard the petitioner counsel and also the charge sheet ಆಗಿದೆಯಾ? ಎಲ್ಲಿದೆ ಚಾರ್ಜ್ ಶೀಟ್?
ನನಗೆ ಅಂಡರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ ಚಾರ್ಜ್ ಶೀಟ್?
I haven't yet received the copy. On the last day, the learned CGP had referred to the
164 ಇದೆ.
164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಇರುತ್ತೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ? ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ.
My limited knowledge is that.
ಚಾರ್ಜ್ ಶೀಟ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಹಾಕಿಲ್ಲ.
64 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ.
Good. Heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that the victim has given the complaint, but complaint dated 23/2/22, stating that her father is running Parvati electrical and hardware shop. ಏನದು?
Crime number 6, please, not where
earlier case in
no, an observation has been made with respect to this case. Where the honorable court has observed that a subsequent
ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆಯಲ್ಲ, ಇನ್ನೊಂದು ಕಂಪ್ಲೇಂಟ್ ಅದ್ರ ಬಗ್ಗೆ ಹೌದಾ?
ಈ ಕಂಪ್ಲೇಂಟ್ ಬಗ್ಗೆ ಅಲ್ಲಿ observation ಮಾಡಿದೆ.
ನೋಡಿ ಏನಾಗ್ತದೆ?
In the complaint dated stating that his father is running Parvati electrical and
hardware shop that on 23/2/22 in the early morning at 4 o'clock, herself and Vasanta, who is working in the shop belongs to her father, the petitioners who are having ಏನೋ ಶಾಪ್ ಇದೆ ಅದು ಚಿನ್ನದ ಅಂಗಡಿ, jewelry shop and also hardware shop, hardware and glass plywood shop, and continuously following her they came in the motorcycle and caused obstruction and tried to assault her. and the first petitioner hearing. Held her neck and caused the life threat. The other two petitioners assaulted with club and threatened that they are going to commit rape on her. That she has given the complaint against her father and caused the injuries. Based on the complaint, police have registered the case and matter is under investigation. And offences are invoked under section 354A within bracket D, 323, 324, 506, 341, and section 12 and 18 of POCSO Act. The counsel appearing for the petitioner would submit that against the father of the victim complainant, a complaint was given by the villagers. Two complaints, well, first one the villagers.
First, both are from the village. First being the one given on 22nd of September 2021, and on page number 50, the second complaint.
That is dated 22/9/2021, and also another complaint dated 19/1/22.
Pardon me, 26/2/22. 26/2/22 on page number
26/2/2022.
And subsequently, action has also been taken by the local authorities.
And also action has been taken by the local authorities in pursuance of the complaint given
On page 59.
to the deputy commissioner. The council also would submit that in the meanwhile, one more complaint was given by this complainant in the month of January. So that is on 19/1/22. No action was taken in respect of the earlier complaint, and hence one more complaint was given on 23/2/22.
The parents in 6.
And the same is the modus operandi of complainant in giving the complaint. The council also would submit that this court in criminal petition number 3477 of 22, in respect of crime number 6 of 22, already granted bail. In criminal petition number 3477 of 22, dated 10th day of June 2022. And only with an intention to circumvent the situation of the present complaint is filed, and these petitioners are arraigned as accused number 1 to 3 in crime number 12 of 22. 12 of 22. 12 of 22. And hence, with the malafide intention, the present application is filed. Present complaint is filed, and hence they may be enlarged and paid. For counter, the council appearing for the state will submit that these petitioners have not only caused life threat and also assaulted, and hence he has sustained the simple injuries. Having heard the respective counsel and also on perusal of material, no doubt there is a complaint against the father of the complainant.
It has a rowdy sheet also.
Complainant by the villagers. And also the council submits that in pursuance of the said complaint an action was taken. And also the complaint government clearly discloses that she is the daughter of person who is running the business, and also alleged incident was narrated in at 4 AM when she was proceeding along with the person who is working in the very same shop belongs to the complainant father. When searching the material and also offences which have been invoked against the petitioner is also under section 12 and 18 of POCSO Act. And the same is subject to dictation ಕೊಡುವಾಗ ಯಾಕೆ ಭಯ ಆಗ್ತೀರಿ ನೀವು They heard you and then I am passing an order.
The eyewitness that is arrested.
ಹೇಳದಿದ್ರೆ ಹೇಳ್ಬಿಡಿ ಎಲ್ಲ ಕೇಳ್ಬಿಟ್ಟು ಇನ್ನೊಂದ್ಸರಿ ಹೇಳ್ತೀನಿ. Don't interfere with while passing an order.
But the prima facie complaint again passed given to the local authorities is with respect to the eyewitness that is cited, because she was the one he was using to file atrocity cases prior to moving on to Prosecution. There are subsequent cases which were filed and all of them were acquitted against which the complaints were given, saying that there was a grave threat that anybody who opposed him would be arraigned as accused in a FCST atrocity matter. For this purpose, he has stopped that and now he started with the Prosecution cases.
ಆಯ್ತಾ?
Being the material record and also the offences which have been invoked are also the section 180.
And that is with regard to the sexual harassment. And having taken note of the gravity of the offence and also accusation made in the complaint, and also the prior complaints against the father of the complainant, and also earlier cases are registered invoking the special enactment of SCST Prevention of Atrocities Act 1989. It is a fit case to exercise the powers of 438 of CRPC with a condition to cooperate with IO for the investigation.
Initially, the registered the offence under section 324 and 104 and 106 matter. Subsequently, the improved version of the complaint, 307 has been inserted.
307 again injuries. Injuries.
Not able to get the document.
Henry, injuries, Henry.
Page number 13. Page number 13. And RCSA, it has been stated that. Second paragraph. ಈ ದಿನ ದಿನಾಂಕ 2/5/22 ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಗಾಯಗೊಂಡಂತೆ ತನ್ನ ಮುಂದುವರಿಕೆ ಹೇಳಿಕೆ ನೀಡಲು ಅವರ ಮಾಲೀಕರಾದ ಜಾಕೀರ್ನಿಯ ಅವರ ಬಳಿ ಕಾಲಿಗೆ ಹೇಳಿಕಳಿಸಿತು. ಅದರಂತೆ ಠಾಣಾ ಎಚ್ಸಿ ಮಹದೇವನವರನ್ನು ಗಾಯಾಳು ಆಸ್ಪತ್ರೆಗೆ ಪಡೆಯುತ್ತಿದ್ದ ನೆಲಮಂಗಲ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಕಳುಹಿಸಿತು. ಸದರಿಯವರು ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಗಾಯಾಳನ್ನು ವಿಚಾರ ಮಾಡಲಾಗಿ ಗಾಯಾಳ ಕೀಲಿ ಹಾಕುವವರು ನಾನು ನೀಡಿದ ದೂರನ್ನು ನನ್ನ ಮಾಲೀಕರಾದ ಜಾಕೀರ್ನಿಯರವರು ನನಗೆ ಪುನಃ ಇನ್ನೊಂದು ಸಾರಿ ಹೇಳಿದ್ದರಿಂದ ನಾನು ಸರಿಯಾಗಿ ದೂರ ನೀಡಿಲ್ಲವೆಂದು ತಿಳಿದುಕೊಂಡು ನನ್ನ ಮಾಲೀಕರನ್ನು ನೀವು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ಪೊಲೀಸರನ್ನು ಮತ್ತೆ ಕರೆತನ್ನಿ, ನಾನು ಹೇಳಿಕೆ ನೀಡಬೇಕೆಂದು ಹೇಳಿ ಕಳಿಸಿದ್ರಿಂದ ಜಾಕೀರ್ನಿಯ ಅವರು ನಿಮ್ಮನ್ನು ನೆಲಮಂಗಲ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ
injuries, simple injuries. Good. Or the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution. That on 2/5/22, when the complainant was working in the shop, that is Pakiza cutting shop, having ill will against him, came and threatened, and on the same day at 6 p.m. came and spilled the chili powder and inflicted injury on his chest and also on the abdomen with the weapon. And they left the place, and hence he is taking treatment at Nelmangala Government Hospital. Based on the complaint, case has been registered in crime number 69 of 22. The counsel appearing for the petitioner would submit that the allegation made in the complaint that there was a an earlier incident. And due to the said ill will, they came and assaulted. And also counsel would submit that the injuries are simple in nature and these petitioners are in custody from the date of arrest. And the injury is also out of danger and hence petitioner may be enlarged on bail. For counter, the counsel appearing to the state would submit that due to previous ill will, they went with weapon and inflicted the injury on the chest as well as the abdomen. And though injuries are simple in nature, with an intention to take away the life, went with weapon and inflicted injury. Hence, they are not entitled for bail. Having heard the respective counsel and also on perusal of material and looking into the contents of the complaint, there was an ill will between the petitioners and also the complainant since earlier there was an incident. And hence, they came and inflicted the injury with the weapon. And having taken note of the accusation made in the complaint as well as the gravity of the offense and the injuries are simple in nature and injured is also out of danger, it is a quick case to exercise the process 439 of CRPC with conditions. With conditions. What is the allegation? So, you know the offense of forgery. Forgery.
Office by.
Office by.
A2 ಗೆ reject ಆಗಿದೆ.
A2 reject ಆಗಿದೆ.
27.
Office by.
Defense company limited ಅಂತ ಒಂದು ಕಂಪನಿ ಇರ್ತದೆ ಸರ್. ಇದರಲ್ಲಿ ಸುಮಾರು ಬ್ರಾಂಚ್ ಇರ್ತದೆ. ಈ ಕಂಪನಿದ ಫಿರ್ಯಾದು ಕಂಪನಿ ವ್ಯವಹಾರ ನೋಡ್ಕೊಳ್ತಾ ಇಲ್ಲ ಸರ್. ಕಾರ್ಯನಿರ್ವಹಣೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
This is also a petition under section 438. This court in a common allegation against this petitioner and also against him.
Office by sir.
I three deputy manager, supervisor and office by. All of them.
ಮಿಸ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅಲಿಗೇಷನ್ ಬಿಲ್ ಮೇಲೆ ದಸ್ತಾವೇಜು ದಾಸ್ತಾನು ಕೊರತೆ ಬಂದಿದೆ. ಆಫೀಸ್ ಬಾಯ್.
ಆಫೀಸ್ ಬಾಯ್ ಏನೇ ಸ್ಟಾಕ್ ಅಲ್ಲಿ
ಸಂಬಂಧ ಸೈನ್ ಮಾಡೋದ್ರಲ್ಲಿ ಇನ್ನೊಂದಾಗಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
shortage of stock worth of rupees 31,97,988.
A3 ಮೇಲೆ ಅಲಿಗೇಷನ್ ಅವರೇ ಒಪ್ಪಿದ್ದಾರೆ 3 ಕೇಸಸ್.
ಏನ್ರಿ ಇವನ್ ಮೇಲೆ ಏನ್ರಿ ಅಲಿಗೇಷನ್?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇವನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್. ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್.
And apart from that, even fake receipts also.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನು ಅಲಿಗೇಷನ್ ಅಂದ್ರೆ A1 to A3 ಮೇಲೆ
ಮಾತ್ರ ಇದೆಯಾ? ಆಫೀಸ್ ಬಾಯ್ ಮೇಲೆ ಏನಿಲ್ವಾ?
ಅವರು ನಾವು ಅದನ್ನ ಸರಿಪಡಿಸ್ತೀವಿ ಅಂತ ಅವರೇ ಒಪ್ಪಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಕಂಪ್ಲೇಂಟ್? ಎಲ್ಲಿದೆ? ನಿಮ್ಮಲ್ಲೂ ಇದೆ ರೀ ಆಫೀಸ್ ಬಾಯ್ ಅಂತ. ಕಂಪ್ಲೇಂಟ್ ಹೋಗಿ ನಿಮ್ಮ ಪೇಜ್ 17 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಶ್ರೀನಿವಾಸನ್ ಆರ್ ಡೆಪ್ಟಿ ಮ್ಯಾನೇಜರ್, ಮಿಸ್ಟರ್ ಕಿರಣ್ ಕುಮಾರ್ ಎಜಿ ಗೋಡೌನ್ ವರ್ಕರ್, ಮಿಸ್ಟರ್ ಸಂಜಯ್ ಎಚ್ ಸೂಪರ್ವೈಸರ್, Chandrasekhar PN office by cheating, misappropriation, theft, fraud, forgery and criminal breach of trust of the company. 18 ಅಲ್ಲಿ ಹೇಳಿ.
ಅವರೇ ಒಪ್ಪಿದ್ದಾರೆ ಸಮಯ. ಅಪೀಲ್ ನಂಬರ್ 1 ಶ್ರೀನಿವಾಸನಾರು, ಅಪೀಲ್ ನಂಬರ್ 2 ಕಿರಣ್ ಕುಮಾರ್, ಅಪೀಲ್ ನಂಬರ್ 3 ಸಂಜಯ್.
ಆಯ್ತು, ಸೆಟರೇಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಒಪ್ಕೊಳ್ತಾರೆ. ಆಯ್ತು,
ನಮ್ಮ ಅಪೀಲ್ ನಂಬರ್ 4 ಮೇಲೆ ಏನಿಲ್ಲ ಸ್ಟಾರ್ಟ್
ನಿಮ್ ಕೆಲಸ ಏನು? ನಿಮ್ ಕೆಲಸ ಏನ್ರಿ ಅಲ್ಲಿ?
ನಮ್ಮಲ್ಲಿ ಯಾವುದಿಲ್ಲ ಸ್ವಾಮಿ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಬಂದು ಅವರು ಅಲ್ಲೂ 20 ದಿನದಲ್ಲಿ ನಾವು ಸೆಟ್ಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವರು ಒಪ್ಪಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನ್ರಿ ವಾಟ್ ಇಸ್ ದಿ ರೋಲ್ ಆಫ್ ಆಫೀಸ್ ಬಾಯ್? ಇದೇನೋ ಸ್ಟಾಕ್ ಯಾರೋ ಬೇರೆ ನೋಡ್ಕೊಳ್ತಾ ಇದ್ದ. ಗೋಡೌನ್ ವರ್ಕರ್ ಇದ್ದ. ಗೋಡೌನ್ ವರ್ಕರ್ ಗೊತ್ತಿರ್ತದೆ ಸ್ಟಾಕ್ ಇಂದ ಇರತ್ತೆ. ಇವನೇನ್ ಆಫೀಸ್ ಬಾಯ್ ಏನು ರೋಲು?
One witness statement recorded, my lord. One witness statement recorded.
ಏನಂತ
All are together treated the.
all are together ಸರಿ, ವಾಟ್ ಈಸ್ ಹಿಸ್ ರೋಲ್? ಅದು ಜಾಯಿಂಟ್ omnibus ಸ್ಟೇಟ್ಮೆಂಟ್. ಅದು ಬಿಟ್ರೆ he was not in custody of the stock also. ಸ್ಟಾಕಿಗೆ ಯಾರೋ ಒಬ್ಬ A3 ಇದ್ದ, ಹೌದಾ? A3 ಕಿರಣ್ ಕುಮಾರ್. A2 ನಾ? A2 ಡೆಪ್ಟಿ ಮ್ಯಾನೇಜರ್ ಕಂಪನಿಯವರೆಲ್ಲ. ಜನರಲ್ omnibus ಸ್ಟೇಟ್ಮೆಂಟಾ? ಇವನ ಹೆಸರೇನು?
ಆಟೋ ಡ್ರೈವರ್, ಅದು ಕಂಪನಿ ಆಟೋ ಡ್ರೈವರ್ ಕೆಲಸ.
ಆಟೋ ಡ್ರೈವರ್. ಇವನ್ ಮೂಲಕನೇ ಎಲ್ಲ ಬೇರೆ ಕಡೆಗೆ ಇದು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಆಗಿರ್ಬೇಕು ನೋಡಿ.
ಆಫೀಸ್ ಅವರು ಮ್ಯಾನೇಜರ್, ಗೋಡನ್ ಇನ್ಚಾರ್ಜ್, ಅವರು ಇನ್ಚಾರ್ಜ್, ಆಫೀಸ್ ಬಾಯ್ ಏನೋ ಒಂದೇ
57,66,242 ರೂಪಾಯಿ.
ಮ್ಯಾನೇಜರ್ ಅವರು ಮಾಡಿರ್ತಾರೆ.
ಇವನೇನ್ ತಗೊಂಡೋಗಿ ಹಾಕಂದ್ರೆ ತಗೊಂಡೋಗಿ ಹಾಕ್ತಾನೆ ಅಷ್ಟೇ. ನಿಮಿಷ ಇರ್ರಿ, ಯಾಕೆ ಪೇಷನ್ಸ್ ಇರಲ್ವಲ್ರಿ? ನಾನು ಅವ್ರಿಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಪ್ರಶ್ನೆ, ಹೌದಲ್ವಾ? ಮತ್ತೆ ಅಲ್ವಾ? ಸ್ಟಾಕ್ ಇವನಲ್ಲ, he was not in the custody of the stock, and also the deputy ಇವನಾರ ಇದಾನಲ್ಲ, ಅವನಾರು ಡೆಪ್ಟಿ ಮ್ಯಾನೇಜರ್ ಯಾರು, ಅವರೆಲ್ಲ ಏನ್ ಹೇಳ್ತಾನೆ ಆ ಕೆಲಸ ಮಾಡ್ತಾನೆ. What the petition of counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution. That page number 3 ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್. Karnataka counsel appearing to the petitioner would submit that this petitioner was only an office boy and he has not indulged in committing of any such offense, and he has been falsely implicated in the case, and he is ready to cooperate with the IO for the investigation. For contra, the counsel appearing to the state would submit that this petitioner was working as office boy. He indulged along with other accused persons, that is in charge, Gordon in charge and deputy manager, and committed an offense of misappropriation and criminal breach of trust to the tune of 57,66,242. Hence, there is a prima facie case. Having heard the respective counsel and also on perusal of the material and record, this court rejected bail petition of accused number 2, who was working as Gordon in charge. And the allegation is also that there was a shortage of stock, and this petitioner is working as an office boy. And allegation is also against the other accused who are working as deputy manager and supervisor. And also the prosecution case is that along with other accused persons, this accused also indulged in committing such an offense. And having taken note of this petitioner is an office boy and not having any control with regard to the stock, and the accused number 2 was the stock in charge, and if any shortage of the stock, except the allegation that this petitioner joined hands along with other petitioner, no other material against this petitioner, only on omnibus allegation is made when the statement of witness was recorded. When such being the case, it is a fit case to exercise the powers and Section 438 of CRPC to enlarge remand bail with conditions to cooperate with IO.
This case, Lord, 6 2 days time.
Okay, why 439?
Cancellation of bail, bail was 2 days time.
Bail misplaced, HCGP 6 2 days time. 12th ಇದೆಯಾ ಇನ್ನೊಂದು ಬೇಕಾ? 12th ಬೇಕಾ? After 12th ಬೇಕಾ? And petitioner counsel submits that this matter may be listed after 12th, and with this matter on 13th. ಈಗ ನೀವು 12th ಮೇಲೆ ಅಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ ನಾ ಅದು 2 ಬರುತ್ತೆ. HCGP 6 2 days time, you request after 12th, ಅದನ್ನ ಬರ್ದಿದ್ದೇನೆ ಅಷ್ಟೇ. ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ ಬಿಟ್ಟು ನಾನು ಏನು ಬರ್ದಿಲ್ಲ.
So this done.
307 ಏನಿದೆ ಮೇಡಮ್ ಇಂಜುರೀಸ್? ಸಿಂಪಲ್.
Police officer complaint.
This is that there was a case registered against 3 persons from Bangalore on the allegation that 3 persons raided him, took possession of his car, 250,000, but dropped only 6,000. And the case is pending in Putturu police station. They are custody in that case also. The outcome is that 3 persons like Leonis household. Police were in court for this yesterday. On 5/4/2022, when the complaint PI received information PSI Umesh Beach that the culprits in that case were roaming around in that case. It's one of its car. He followed them. PSI requested this PI also to join him in following them. And Kallipalya, they related their car and stopped it. The culprits, 2 of them, came out of the car, waving knife at the police, deterred them from arresting them. These 2 police officers shot at them. Them, arrested them. Yes. 8 of them, police officials were 8 of them. At least 2 of them armed with service revolver. These 2 boys, young boys, deterred them.
Inflicted injury with what? What is the weapon? Knife.
ಅವರನ್ನು ಶೂಟ್ ಮಾಡಿದಕ್ಕೆ ಒಂದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಟ್ಟು 307 ಹಾಕಿದ್ದಾರೆ. PIಗೆ ಹೊಡಿಲಿಕ್ಕೆ ಬಂದ್ರೆ ಕೈ ಅಡ್ಡ ಹಿಡ್ದ.
ಅವ್ರಿಗೆ ಇಂಜುರಿ ಆಯ್ತು ಅಂತ.
ಅಲ್ಲ, PIಗೆ ಇಂಜುರಿ ಆಗಿಲ್ಲ. PSIಗೆ ಹೊಟ್ಟೆಗೆ ಕುತ್ತಿದ್ರು ಸಿಂಪಲ್ ಇಂಜುರಿ. ಹೊಟ್ಟೆಗೆ ಚೂರಿಯಿಂದ ಕುತ್ತಿದ್ರು.
ಆಗ ಇಂಜುರಿ ಆಗಿದೆ ಅಲ್ಲ?
ಇಂಜುರಿ ಅದೇ ದಿವಸ ಹೊರಗೆ ಬಂದಿದೆ.
ಹೊರಗೆ ಬರಲಿ, ಬಟ್ ಇಂಜುರಿ ಇದೆ ಅಲ್ವಾ?
Today is 91st day.
ಆಗಿದೆಯಾ? ಆಯ್ತು, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ತಗೊಳ್ಳಿ. Heard the petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that these petitioners, question idara, these two petitioners are the accused in claim number 45 of 22. And on credible information received by the IO, inspector, who is the complainant, that they are roaming, made an attempt to apprehend them. And at that time, these 2 petitioners inflicted injury with knife on the PSI. PSI alla? PSI. And hence shot him. Shot yarige? Obniga ibru. And shot both of them and apprehended them, and these 2 petitioners, in order to prevent the discharge of public duty, inflicted injury. And hence case has been registered against the petitioners herein for the offence punishable under section 353, 332 and 307 of IPC. The counsel appearing for the petitioner would suppose that these 2 petitioners have been falsely implicated in the case, and the alleged history that these 2 petitioners implicated inflicted injury with knife is only a created story when they have shot both of them with an intention to escape from the allegations to be made against them. A false case has been registered, and also the injuries are simple in nature, and hence they may be enlarged on bail. For counter, the counsel appearing to the state would submit that though the injuries are simple in nature, these two petitioners indulged in committing an offence against the police officials who are on public duty, and also inflicted injury with knife. And hence there is a prima facie case against the petitioners hearing.
ಕೇಸ್ ಇದೆ, ಹಳೆ ಕೇಸ್ ಇಬ್ರು
ಇಬ್ರ ಮೇಲೆನಾ? ಇಬ್ರ ಮೇಲನ್ನು
ಸೇರಿ
ಆಯ್ತು. ನಿಮ್ ಪ್ರಕಾರ 9?
ಇಬ್ರ ಮೇಲೆ ಅಂತ ಕಾಮನ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. 9 ಕೇಸ್
ಇಬ್ರ ಮೇಲಂತ ಆಯ್ತು. The counsel appearing for the state also submits that these two petitioners are the habitual offenders, and IOA has given the report that there were 9 cases against them. In reply to the submission of the HCGP, the counsel appearing for the petitioner would submit that against one person, one petitioner is 6 cases, and another petitioner only 3 cases. 3 cases. 3 cases, and in all the 3 cases, the petitioner has been indulged on bail. Having heard the respective counsel and also on perusal of material, particularly taking into note of allegation made against these petitioners and also the accusation that they inflicted injury with knife, and apart from that also the IO shot both of them, and both of them have also sustained injuries. The injuries sustained by the officials also simple in nature, and no doubt it is an offence against the society at large, making an attack against the police officials who are in discharge of public duty. However, taking into note of the nature of injuries sustained by the police official as well as the IO shot both of them, and as a result they have also sustained the injuries. IO idralla jothe avರಿಗೆ ರೀ ಅಂತಾರೆ. Both of them have sustained injuries in that process, and considering this and order sheet ಕೊಡಿ. Yes, Manmohan. What is the status?
Pass it on. The first file, I flagged it on the right hand side, note page 79. Inclusion of note the deputy commissioner as A3. Then with the second file notes is
Then fine.
ಎರಡಿದೆ. ಇದರಲ್ಲಿ subsequent plot development that what is recorded. After including plot A3, but we have also plot asked him to appear before us plot on 36. That can also get it to page 92.
92.
Oh.
Page 92. Yeah, first file alla
second file ಅಲ್ಲಿ. Sorry if it is.
Second file ಅಲ್ಲಿ ಯಾವುದು page 92 ಇಲ್ಲ.
Sorry, I'll flag it. Sorry.
ಯಾವುದು flag ಹಾಕಿಲ್ಲ.
Please. First flag not 36, 2022, not the third accused has appeared and his statement not or his interrogation was not undertaken. Jail superintendent also not was present at that point of time. His signature is also there. This is a status note of the present case, the subject matter.
With whom you have interrogated?
Please, Lord.
Interrogated whom?
But A3 and also not further interrogation of the petitioner.
A3.
How? A3 at the page.
What is the development now?
Not now the investigation is still in progress. Not we have also not recorded the statement not of the driver and gunman not of A3. And also not we have seized not the CCTV footage, everything not which was there in the DC's office. That also we have seized, but we have sent it not for forensic, etc. So that even mobile of the DC has been seized, and that not has been sent for not examination. That is the status not as of now.
Other day, while dictating the orders, you intervened and made submission before the court that you are going to place the documents before the court. Where is those documents?
But
where are those documents?
Can I make one submission? But what has happened is not, as Lords are aware, there is a batch of petitions that are pending before the division bench. But there was an order that was passed in that matter. But I just placed the order sheet, that matter.
Yeah. One second.
ತಾವು ಹೇಳಿದ್ ನಂಗೆ ಗೊತ್ತಾಯ್ತು, ಉತ್ತರ ಕೊಡ್ತೀನಿ.
Division bench ಕೊಟ್ರೆ ನಮ್ ಕೋರ್ಟ್ ಕೊಡಬಾರ್ದು ಅಂತ ಏನಾದ್ರು ಇದೆಯಾ?
ಕೊಡಬಾರ್ದು ಅಂತಲ್ಲ.
Is there any bar?
I'm only trying to say that.
Is there any bar?
There is no bar as such, but the scope I'm only making a request. I understand not passed an order. My apologies I said that instructions that we will.
You are here to protect the culprits or you are protect the interest of the general public? You being an officer of advocate of the ACB is constituted to prevent the corruption. You are here to protect the people who are tainted with or are under the helm of affairs. You are here to protect such people or you are appointed as special counsel to prevent the corruption or not? That's why other day you made some mentioning before the court. That's why I came up with the judgments of Supreme Court, of Constitutional Court. This is not the way of you are paid with the public money.
Yes.
The special enactment brought into force with an intention to prevent the corruption in the whole society, which is a cancer. Instead of allowing to reach the fourth stage, which is not curable, at the first stage or in the second stage, it should be cured. That is the only reason when I dictating the order to place the material before the court, you intervened, given an undertaking before the court that you are going to place all the materials before the court. Now you are making submission that matter is pending before the division bench. I know matter is heard from last 15 days. Yourself and state government representing counsel both went there and made the submission. You are going to place those documents in the division bench in order to avoid this bench. Now we are making submission before this court.
But
This is you are paid from state exchequer. You are here to protect the
Yes,
interest of
yes,
the
but
institution and
absolutely.
not to support the people who are indulging in this. You said you have recorded the statement of accused number 1 and 2.
Yes,
Have you seized the file appointment of the accused number 2? Who has appointed him? Who has appointed him to collect the money? An amount of rupees 5 lakhs on behalf of the deputy commissioner. Who has appointed? A2 who received the amount of rupees 5 lakhs.
we have
Get the
asked.
records. I will summon the records from present deputy commissioner who has passed an order for appointing him. He was appointed only for collection. This is the way things are going on. Now you are standing before the court. You are going back with the undertaking even before this court. That's why I asked you whether any bar in not placing the document before this court as you have undertaken. This court wants an answer from you. Have you seized that document?
Those documents, not we have, not the officer has summoned it. Not
ನೋಡ್ರಿ
witness
ಕಣ್ಣು ವರ್ಷ
papers.
ಕೆಲಸ ಬೇಡ ಮನಮೋಹನ್ ಕಣ್ಣು ವರ್ಷ ಕೆಲಸ ಬೇಡ ಐವಾಸ್ ಮಾಡೋ ಕೆಲಸ ಬೇಡ ನೀವು ಅವನು ಯಾರು ಅಪಾಯಿಂಟ್ ಮಾಡೋದು ಅಂತ ತಗೊಳ್ಳಿ ಆಗ್ಲೇ ಸಿಗ್ತಾ ನಿಮ್ಗೆ ಯಾರು ಹೂ ಇಸ್ ದಿ ರಿಯಲ್
ತಗೊಳಕ್ಕೆ ಲೆಟರ್ ಬರ್ದಿದಾರಂತೆ.
ಲೆಟರ್ ಬರೆಯೋದ್ ಬೇಡ ನಾನೇ ಸಮನ್ ಮಾಡ್ತೀನಿ. ಇಫ್ ಯು ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಗೆಟ್ ದೋಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಡೋಂಟ್ ಸಪೋರ್ಟ್ ಸಚ್ ಪೀಪಲ್. ತಿನ್ನ ಅನ್ನ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ರೀ. You are paid from the out of public's money.
Yes.
This court has taken initiative to summon such people, that those people should not be. You are going to the extent of you and state. Voluntarily gone before the division bench and made submission that you may be permitted to place the records.
No.
Then why you are not preventing before this court? ಆಯ್ತು ಎಷ್ಟು ಜನದ್ ನೀವು
This order directing us to file the status report was not ordered way back.
ಕೊಡಿ status report ಕೊಡಿ. If you are not having, I have the report. How many of cases you have filed B report, even red-handedly caught with the money, bribe money. If you are not having, I will summon with the details of those documents. I will pass judicial order and also a threat to this court saying that one of the judge has been transferred. I am ready. Even I am ready to face that also at the cost of public cost. And your ADGP is so powerful and some person spoken to one of our High Court judge came and sat with me and he says, giving an example of transferring of one of the judge to some other district. I will not hesitate to mention the name of a judge also. He came and sat by the side of me and there is a threat to this court. I am going to protect the independence of judiciary at the cost of my judgeship. This should not happen. This should not happen. I will record the same in the order itself. This should not. You people are encouraging such people, state government as well as you are here to protect the institution. You are here to protect the institution, not to do all these things. Society ಅನುಕೂಲ ಆಗ್ತದ್ರಿ. ನೀವು ತಿನ್ನ ಅನ್ನ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಜನರ ಪಬ್ಲಿಕ್ ಮನಿ. ನನಗೇನ್ ಪರ್ಸನಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ, ಯಾರ ಮೇಲೂ ನನಗೇನ್ ಪರ್ಸನಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ. ನನಗೂ ಏನ್ ಹೆದರಿಕೆ ಇಲ್ಲ. ನಾನು ಒಂದ್ ಇಂಚ್ ಜಾಗನೂ ಮಾಡಿಲ್ಲ ಜಡ್ಜ್ ಆದ್ಮೇಲೆ. ನಮ್ಮ ಅಪ್ಪನ ಆಸ್ತಿನ 4 ಎಕರೆ ಮಾರಿದ್ದೀನಿ ಆಫ್ಟರ್ ಐ ಬಿಕಮಿಂಗ್ ಎ ಜಡ್ಜ್. ವೈ ಶುಡ್ ಐ ಹೆಸಿಟೇಟ್? ಇದು ರೋಗ, ಕ್ಯಾನ್ಸರ್. 4ನೇ ಲೆವೆಲ್ ಹೋಗಕ್ಕಿಂತ ಮುಂಚೆ ತಡಿಬೇಕಿದ್ನ. 4th ಲೆವೆಲ್ ಹೋದ್ರೆ ಇದು ಮಾಡಕ್ ಆಗಲ್ಲ. I will bell the cat. Even at the cost of my judgeship. This should not. Now you are going back with your undertaking given by this court saying that unless you produce it, I will summon those documents by judicial order. When I dictated the order, you intervened at the instance of your IO and made given an undertaking before the court that you are going to produce all these documents. Why you are hiding? If the state government and your ACP is not culprits, then why you are hiding all this? 5 ಕೋಟಿ 10 ಕೋಟಿ ಹಿಡಿದವ್ರನ್ನೆಲ್ಲರನ್ನು ಹಂಗಂಗೆ ಬಿಟ್ಟು ಕಳ್ಸೋದು. ವೈ ಯು ಆರ್ ಹೈಡಿಂಗ್? I will summon. I have the powers. That's why I came up with judgments. Other day you mentioned that you have to shut your eyes only regarding this bail petition. That's why I have come up with judgments. Even at the cost of my judgeship also. I will summon. Produce ಮಾಡ್ತೀರಾ ಏನ್ ಮಾಡ್ತೀರಿ? Otherwise now I will summon the DPR secretary. Let him place the documents of AGP service record. ADGP service record. I will summon right now. And then you summon I will summon the state government. You instruct deputy commissioner who is in charge to produce the document for having appointed accused number 2. When he was appointed, let him be before the court. I will pass an order at 2:30. You get him and also instruct state government produce the service records of ADGP before the court. Deputy secretary or secretary to the DPR produce the ADGP service records before the court. ತಿನ್ನ ಅನ್ನಕ್ಕೆ ದ್ರೋಹ ಬಗಿತಾ ಇದ್ದೀರಿ ಮನಮೋಹನ್, ತಿನ್ನ ಅನ್ನಕ್ಕೆ ದ್ರೋಹ ಬಗಿತಾ ಇದ್ದೀರಿ. This court taken the issue only in the public cause, but you are here to public cause. Public cause ನೀವು ಕೆಲಸ ಮಾಡ್ಬೇಕ್ರಿ, not for any individual sake. ನಿಮ್ಗೇನೋ ಬೆನಿಫಿಟ್ ಆಗಬಹುದು, ಅದು ಸೆಕೆಂಡರಿ. And I know you and Advocate General went and made the submission after reserving the matter before the division bench, and now you are placing the document. Is there any bar? That's why I'm asking you. When this court has directed you.
I'm sorry, my lords, I've got a factually incorrect information. Kindly permit me to pass on the order sheet.
Order sheet ನಂಗೆ ಗೊತ್ತ್ರಿ.
ನಾನು ಅವಾಗಲೇ ಬೇಸ್ ಮಾಡಿರೋದು.
ಆರ್ಡರ್ ಶೀಟ್ ಎಷ್ಟಕ್ಕೆ ಟೈಪ್ ಆಗಿದೆ ತರಿಸ್ತಾ? ನಮ್ಮಲ್ಲಿ 1-1.5 ಗಂಟೆಗೆ ಮುಗಿಯುತ್ತೆ, ಹೌದಾ?
ಅಲ್ಲ, ದಯವಿಟ್ಟು ತಾವು ನೋಡಿ.
ಆಯ್ತು, ಕೈಂಡ್ಲಿ ಸೀನೆ ಅದೇನೆ ಹೇಳ್ತಾ ಇರೋದು. ಇಲ್ಲಿ 1ರಿಂದ 1:30 ಆಯ್ತು, ಆಮೇಲೆ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಹೋದ್ರೆ ಇಬ್ರು ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ? ಆಯ್ತು, that's why I'm asking you any bar.
Kindly turn to page 5.
ಆಯ್ತ್ರಿ, any bar in placing the
1 minute. Kindly bear with me for a minute. Kindly turn to page 5. This is the order sheet in those petitions.
ಇದೆಲ್ಲ ಹಳೇದು.
ಹೌದಲ್ಲ, ಅದಕ್ಕೆ serial number 12 ತಾವು ನೋಡಿ. ಅದು ತೋರಿಸ್ತೀರಿ, ದಯವಿಟ್ಟು serial number 12 ನೋಡಿ. Order dated 19/12/2019. Kindly then turn to
19/12 ಬೇಡ್ರಿ ನನಗೆ, ಈ 29/6 ದೇನೆ ಹೇಳಿ.
ಅಲ್ಲ, 29/6 ಹೇಳ್ತೀನಿ. Kindly turn to page 6. The order that was passed on 19/12.
That's why I'm asking, even assuming that you have produced those documents.
ನಾವು ಅವಾಗಲೇ ನಾವು ಪ್ಲೇಸ್ ಮಾಡಿದೀವಿ. It is not
division bench. ನಿಮ್ಮ ಹತ್ರ ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ವಾ ಬೇರೆ? ನಾನು what I summoned from you. That's why I will pass an order.
I'll just clarify.
Including everything threat made to the court also. I will include everything in the order sheet.
But kindly see blood page 6, serial number 3. Kindly see for a moment. Just to point out that this is not what is.
ಆಯ್ತ್ರಿ, ಬಹಳ ವರ್ಷದಿಂದ ನಡೀತಾ ಇದೆ.
ಅವಾಗಲೇ that was a direction.
ವರ್ಷದಿಂದ ಕೇಸ್ ನಡೀತಾ ಇದೆ, but no logical end.
Now finally this honorable court has reserved the matter for order.
Ultimately
our status report now file ಮಾಡಿದ್ದ ಅವಾಗ.
It is now reserved. That is not my concern. I am concerned is only with regard to this case. Someone ಮಾಡ್ರಿ. ಇವರೆಲ್ಲ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ A3 ನ. IAS officer
A3 ನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
But why you have not seized the document of appointment of A2?
That also
A2 by this petitioner.
But A3 also we are not protecting. As I pointed out.
ನೀನೇ ಹೇಳಿ ಹೋಗ್ಲಿ, ಅಪಾಯಿಂಟ್ ಯಾವಾಗ ಮಾಡ್ಕೊಂಡಿದ್ರಿ ಹೇಳಿ. ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾ? ನನಗೆ ಗೊತ್ತು ಮಾಡ್ತೀನಿ ಯಾವಾಗ ಅಂತ ಗೊತ್ತು ಮಾಡ್ತೀನಿ. ಕೇಳಿ ಅವರಿಗೆ, ನಿಮ್ SP ಇದಾರಲ್ಲ ಕೇಳಿ. ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕಾಗಿರೋದು ಅದು ರೀ. ಫಸ್ಟ್ ನೀವು ಕಣ್ಣೋರ್ಸೋ ಕೆಲಸ ಮಾಡ್ಬೇಡಿ ಇಲ್ಲಿ. ಅದನ್ನ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೀವು ಮೇನ್ ಅದೇನೆ. A3 who had received an amount of rupees 5 lakhs, 5 lakhs rupees on behalf of the deputy commissioner when he was appointed. They
sought for information.
ಕೇಳಿ ಅವ್ರು ಕೇಳಿ, ಇಲ್ಲ ನಾನೇ ತರಿಸ್ತೀನಿ ಈಗ ರೆಕಾರ್ಡ್ ನ. He has got all information but he is not disclosing. ಏನ್ ಮಾಡೋದು? ಎಲ್ಲ ಬೇಲಿನ ಹೊಲ ಮೈತಾ ಇದ್ರೆ ನಾವೇನ್ ಮಾಡೋಣ ಹೇಳಿ? ಬೇಲಿನೇ ಇದ್ವಲ್ಲ ಮೇಯ್ತಾ ಇದ್ರು, ನಾವೇನ್ ಮಾಡನ್ರಿ?
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ,
ಅವ್ರ ಹತ್ರ ಇಲ್ಲ ನೋಡ್ರಿ. ಇಟ್ ಶುಡ್ ಬಿ ಫೈಲ್ ಶುಡ್ ಬಿ ಹಿಯರ್ ಬೈ 2:30. ನೀವು ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಗೆ ಹೇಳ್ತೀರಾ, ಯಾರಿಗೆ ಹೇಳ್ತೀರೋ ಗೊತ್ತಿಲ್ಲ. ಇವ್ರು ಯಾರು ಕೊಡೋದಿಲ್ಲ, ಯಾವ ಮೆಟೀರಿಯಲ್ ಕೊಡೋದಿಲ್ಲ. ಐ ವಾಂಟ್ ಆಲ್ ಇನ್ಫಾರ್ಮೇಶನ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಹೌ ಮೆನಿ ಸರ್ಚ್ ವಾರೆಂಟ್ಸ್ ಆರ್ ಇಶ್ಯೂಡ್. ಸರ್ಚ್ ವಾರೆಂಟ್ಸ್ ಯಾವ್ದು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ, ಎಲ್ಲ ವ್ಯವಹಾರ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಸರ್ಚ್ ವಾರೆಂಟ್ ಇಲ್ಲಿ ತಗೊಳ್ಳೋದು, ತೋರ್ಸೋದು, ವಸೂಲಿ ಮಾಡೋದು. ಹೌ ಮೆನಿ ಸರ್ಚ್ ವಾರೆಂಟ್ಸ್ ಆರ್ ಇಶ್ಯೂಡ್ ಅಂಡ್ ಹೌ ಮೆನಿ ಆಫ್ ದೆಮ್ ಆರ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ವಾರೆಂಟ್ಸ್. All details I want. Where is your ADGP? ಎಷ್ಟು ಅವ್ರೇ ಕೇಳ್ರಿ. SP ಏನ್ರಿ ನೀವು? ಬೆಂಗಳೂರಿನಲ್ಲಿ ಎಷ್ಟಿದೆ SP ಪೋಸ್ಟ್? ಒಬ್ರೇನೆ? ಇನ್ಯಾರು ಇಲ್ವಾ ನಿಮ್ಮ SP ಆಫೀಸಲ್ಲಿ? ಅವ್ರೇನಕ್ಕೆ ಮಾಡಿದಾರ ಅವ್ರನ್ನ? ಯಾರು? ಹೂ ಇಸ್ ದಟ್? ಹೆಡ್ ಕ್ವಾರ್ಟರ್ ಅಸಿಸ್ಟೆಂಟ್. ಈಗ 2 ಜನಕ್ಕೆ ರೋಲು, SP ರೋಲ್ 2 ಜನಕ್ಕೆ, ಹೌದಾ? ಬೆಂಗಳೂರದು ACB ಕೇಸಸ್ ನಾವು ನೋಡ್ತಾರ ಇಲ್ಲ? ನೋಡ್ತಾ ಇದಾರೆ. ಹೌ he is permitted to look into the ACB files? Only one post ಇರೋದು. How he is discharging? ಅದಕ್ಕೊಂದು ಆಫೀಸ್ ಮೆಮೊರಾಂಡಮ್, ಹೌದಾ? ಇದೆಯಲ್ಲ ಆಫೀಸ್ ಮೆಮೊರಾಂಡಮ್, ಇದೆಯಲ್ರಿ? ಮತ್ತೆ ಇದೆಲ್ಲ ನೋಡ್ರಿ, ಏನಾಗಿದೆ ನೋಡಿ. ಮನ್ಮೋಹನ್, ಏನ್ರಿ ಇದೆಲ್ಲ? ಇಟ್ ಇಸ್ ಅಶೇಮ್ ಆನ್ ಯು. ನನ್ನ ಪ್ರಕಾರ ಇಟ್ ಇಸ್ ಅಶೇಮ್ ಆನ್ ಯು. ನಿಮ್ ಕೊರಿ ಕೋಟ್ ಇರೋದು ಏನಕ್ರಿ? ವಾಟ್ ಈಸ್ ದಿ ವ್ಯಾಲ್ಯೂ ಆಫ್ ಯುವರ್ ಬ್ಲಾಕ್ ಕೋಟ್? ಇಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ನೋಬಲ್ ಪ್ರೊಫೆಷನ್. ಇವರೆಲ್ಲ ನೋಬಲ್ ಪರ್ಸನ್ಸ್. ನೀವು ಯು ಆರ್ ಹೈಡಿಂಗ್ ಆಲ್ ದಿಸ್. ವೈ ಯು ಆರ್ ಹೈಡಿಂಗ್ ಆಲ್ ದಿಸ್? ಇಸ್ ಇಟ್ ಎ ನೋಬಲ್ ಪ್ರೊಫೆಷನ್ ಜಾಬ್? ಯು ಶುಡ್ ಹಾವ್ ಅಡ್ವೈಸ್ಡ್ ಹಿಮ್. Place it before the court if you are really concerned about the general public. If you are really having concern about the general public, you would have directed them to place all records. Now you are not placing any records. I will pass an order. ನನಗೆ ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯೋ ಗೊತ್ತಿಲ್ಲ, ಯಾರಿಂದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯೋ ಗೊತ್ತಿಲ್ಲ. ಐ ವಿಲ್ ರೆಕಾರ್ಡ್ ರಿಗಾರ್ಡಿಂಗ್ even threat also. It is my duty to protect the independence of judiciary also. I am not affiliated to any political party. And also the ideology of any of the political parties. I am not having any ideology of any public party. I am affiliated to the Constitution only.
I am not for a moment disputing that fact, Lord. But kindly, Lord, my only request is...
If that is the statement, why you are hesitating to place those documents before the court?
Kindly, Lord, consider the situation.
ಏನು ಸಿಚುವೇಶನ್ ಏನಿಲ್ರಿ, ಎಲ್ಲ ಸಿಚುವೇಶನ್ ಎಲ್ಲ ವಿಟಮಿನ್ M ಅಷ್ಟೇ, ಇನ್ನೇನ್ ಬೇರೆ ಏನಿಲ್ಲ. ಪ್ರೊಟೆಕ್ಟಿಂಗ್ ಸಚ್ ಪೀಪಲ್ ಬೈ ದಿ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಆಸ್ ವೆಲ್ ಆಸ್ ದಿ ADGP. ಎಲ್ಲ ಈ ಫಸ್ಟ್ ನಿಲ್ಸಿ, ಪೋಸ್ಟಿಂಗ್ ದುಡ್ಡು ತಗೊಂಡು ಕೊಡೋದು ನಿಲ್ಸಿ ಫಸ್ಟ್. ಎಲ್ಲ ಸರಿ ಆಗ್ತದೆ. I may be harsh, but it is high time. Rise to the occasion. High time. ಏನ್ರಿ ಇದು? You may be other day regarding monitoring court, you objected. ಕಣ್ಣು ಮಾತ್ರ ಮುಚ್ಚಿಕೊಂಡು ಬರೀ ಬೇಲ್ ಆರ್ಡರ್ ಮಾತ್ರ ಬರೆದಿದೆ ಅಂತ. That's why 2014 judgment, investigation monitoring by court does not mean supervision by court. Public interest is the sole consideration and a constitutional court monitors an investigation only when circumstances compel it to do. Now it is compelled to do. That's why I am monitoring.
Can I just pass on two judgments?
What is the 2010 Supreme Court judgment, constitutional bench?
2020 judgment.
Yesterday also Supreme Court said in Nupur's case, what Supreme Court says, why you are not arrested him? That the question I am asking you. ದೇಶನೇ ತುರಿತಾ ಇದೆ, ಇಲ್ಲೂ ಅಷ್ಟೇ ದೇಶನೇ ತುರಿತಾ ಇದೆ ಕರಪ್ಷನ್ ಅಲ್ಲಿ. ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? You people are protecting You people are protecting such people and not placing the material before the court.
I have placed not the
ಏನ್
investigation.
ಮಾಡಿದ್ರಿ ಕೊಡ್ರಿ ಅದು
ಈ case
ಮತ್ತೆ ಅಂಡರ್ಟೇಕನ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಅವತ್ತು. Why you intervened while dictating an order?
My apologies.
Apology ಕಟ್ಕೊಂಡು ಏನ್ ಮಾಡೋದು ನಾನು? ನನಗೆ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಸ್ ಕನ್ಸರ್ನ್. ಐ ಆಮ್ ಕನ್ಸರ್ನ್ ವಿತ್ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್. ಈಗಲೇ ಸೆಕೆಂಡ್ ಸ್ಟೇಜ್ ಫಸ್ಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗಲೇ ಇದನ್ನ ಸರಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಫೋರ್ತ್ ಸ್ಟೇಜ್ ಹೋದಾಗ ಕ್ಯೂರ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಫೋರ್ತ್ ಸ್ಟೇಜ್ ಹೋದಾಗ ಕ್ಯೂರ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಎಂಟೈರ್ ಸೊಸೈಟಿನ ಆವರಿಸ್ಕೊಂಡ್ಬಿಡ್ತದೆ. He constituted 2 persons SPs. One is for if another person objects, the file will go to the another person, another SP, and got it clears the file. Got it clears the files. ನಾ ಹೇಳಿದ್ನಲ್ರಿ ನಿಮ್ಗೆ ಅಷ್ಟೇ ಹೇಳಿದ್ದವ್ರು. ಐ ಆಮ್ ನಾಟ್ ಸಿಸ್ಟಮ್ ಏನಿಲ್ಲ, ಯಾವ ಸಿಸ್ಟಮ್ ಇಲ್ಲ. ಪೋಸ್ಟ್ ಇರೋದು ಒಂದೇ, ಹೆಡ್ ಕ್ವಾರ್ಟರ್ ಅಸಿಸ್ಟೆಂಟ್ ಮೇಡ್ ಇನ್ ಚಾರ್ಜ್ ಆಫ್ ಯಾವ್ದು ಅದುವೇ BBMP BDA ಯಾವ್ದು ಅಲ್ಲ, ಬೇರೆ ಅಲ್ಲ. ಎಲ್ಲ ಸರ್ಪ್ರೈಸ್ ಇರ್ಲಿ. ಅಲ್ಲ BBMP ಅಂಡ್ BDA ಇನ್ಚಾರ್ಜ್. ಏನಮ್ಮ ನಿನ್ ಇನ್ಚಾರ್ಜ್ ಯಾವ್ದಮ್ಮ ನಿಂದು? ಆಮೇಲೆ ಕೇಸಸ್ ಪರ್ಟೈನಿಂಗ್ ಟು ಯಾವ್ದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್? BDA BBMP. ಯುವರ್ ಹಸ್ಬೆಂಡ್ ಈಸ್ ಆಲ್ಸೋ ಎನ್ ಆಫೀಸರ್, ಹೌದಾ? ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಮತ್ತೆ ಇನ್ಯಾದ್ರಲ್ಲಿ ಈಗ ಬೆಸ್ಕಾಮ್. ಆಯ್ತು. ಏನಾರ ಕಂಪ್ಲೇಂಟ್ ಬಂದ್ರೆ ಏನಮ್ಮ ಮಾಡ್ತೀನಿ ನೀನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್? ಮತ್ತೆ ಎಲ್ಲ ನೋನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ BBMP ಅಂಡ್ BDA delegated to the power to the headquarter assistant who is not an SP at all. I will make all this ಇದನ್ನ ಅವ್ರ ಬಾಯಲ್ಲ ಬಿಡಿಸಿದೀನಿ. ಈಗ ಅದಕ್ಕೇನ ನಾನು ಇನ್ನೂ ಸ್ವಲ್ಪ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತೀನಿ. ಹೇಳಿ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇನ್ ಮೈ
I would only request not kindly consider the petition with reference.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನು ನೋಡ್ರಿ ಮತ್ತೆ ನೀವು ಅದು ಹೇಳೋದು ಬೇಡ. ಪದೇ ನೀವು ಅದನ್ನೇ ಹೇಳ್ಬಿಡಿ. ನೀವು ನಾನು ಈಗಾಗಲೇ ಹೇಳಿದ್ದೀನಿ, ಇಟ್ ಇಸ್ ಅಸೇಮ್ ಆನ್ ಯು ವೇರಿಂಗ್ ಬ್ಲಾಕ್ ಕೋಟ್ ಅಂತ. ಮತ್ತೆ ಇನ್ನೂ ಬಯಸ್ಕೋಬೇಡಿ.
I also have my duties towards the client.
What duty? That's why I said you are paid by exchequer of the state. That is public money. You show the concern in respect of the public. Concern show the public. Alva? Mata?
We as lawyers also not be instructed by the client, but we have to go by the instructions. We can't go beyond the instructions that are given by the
instructions.
client.
ಕಳ್ಳರಿಗೆಲ್ಲ ಸಪೋರ್ಟ್ ಮಾಡಬೇಕು ಅಂತ ಏನಾದ್ರು ನಿಮ್ಮ ಪ್ರೊಫೆಷನ್
ಹೇಳುತ್ತಾ? But general statement of that.
ನಿಮ್ಮ ಪ್ರೊಫೆಷನ್ ಹೇಳುತ್ತೆ ಅಂತ?
I'm only making a request. But ನಾವು ಆತರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ but it will have far-reaching consequences.
ನಿಮ್ಮ ಎದುರುಗಡೆ
institution.
ಆಯ್ತ್ರಿ, ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ they should work for the institution,
Absolutely.
not for any self interest.
But what I'm trying to point out is not the statement what Nods had made on the last occasion has come in not as a headlines in not in news channels, newspaper. It will have a bearing not on the agency as such.
ನಾನು ಮಾಡಿದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ತಪ್ಪಿದ್ರೆ you place it on record. ನಾನು ಮಾಡಿದ್ರಲ್ಲಿ ಏನಾದ್ರು ತಪ್ಪಿದ್ರೆ you place it on record. ನಾನು ಏನ್ ಮಾಡಿದೆ ನಿಮ್ಮ ADCP ಮೇಲೆ ನಿಮ್ಗೆ ಅಷ್ಟೊಂದು ಇದಲ್ವಾ? ಆಯ್ತು, DPR ಸೆಕ್ರೆಟರಿ ಕರ್ಸಿ ಪೋಸ್ಟಿಂಗ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಬ್ಬರನ್ನ, ಅದು ಆಂಟಿ ಕರಪ್ಷನ್ ಬ್ಯೂರೋಗೆ ಎಂತವ್ರಿಗೆ ಮಾಡ್ಬೇಕ್ರಿ? ಎಂತವ್ರಿಗೆ ಮಾಡ್ಬೇಕು? I will lay down in my order whom to be appointed. I will pass an order. Not the tainted persons. ಅವರಿಂದ ಏನ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೀರಿ ನೀವು? What you can expect from them? ಕೋರ್ಟ್ಗೆ ಥ್ರೆಟ್ ಇಂಥ ಸಿಚುವೇಶನ್. I am not. That's why when the judge told me like that, I said I am not affiliated to any political party. I will reveal the name of the judge also in my order. ನನಗೇನು ಅಲ್ಲೇನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಕೂತ್ಕೋಬೇಕು ಅಥವಾ ಬೇರೆ ಏನೋ ಮಾಡ್ಬೇಕು ಅಂತ ನನಗಿಲ್ಲ.
Kindly not let it not go to that extent.
ಯಾಕೆ ಹೋಗ್ಬಾರ್ದು ಇಂಥದ್ರಲ್ಲಿ? How you can come and
our institution not also be affected.
Institution affect ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಇಂಥವ್ರೆಲ್ಲ ಬಳಕನ ಇವ್ರನ್ನೆಲ್ಲ ಕೂರ್ಸ್ಕೊಂಡು ಏನ್ ಮಾಡೋದ್ರಿ? ಕೂರ್ಸ್ಕೊಂಡು ಏನ್ ಮಾಡೋದ್ರಿ?
I don't know whom the lords are referring to, but I'm only saying not as an officer of the court, ದಯವಿಟ್ಟು ಮಾಡಬೇಡಿ. ಯಾಕಂದ್ರೆ it will have far-reaching repercussions.
He came and sat by my
But I am not disputing. I don't know who the learned judge is, but I'm only
That's why I
saying.
will reveal it in my order.
ಅದಕ್ಕೆ ನಾನು ದಯವಿಟ್ಟು ಹೇಳೋದು.
ಪರವಾಗಿಲ್ಲ, ನಾನೇನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ರೆ ನಾನೇನ್ ಎಲ್ಗೂ ಹೋಗಲ್ಲ. ನಾನು ರೈತನ ಮಗ.
ನಾವು ಹೇಳಿದೀವಿ.
ನಮ್ಮ ಅಪ್ಪ ಹಾಕಿದ 4 ಎಕರೆ ಜಾಗ ಇದೆ, ಗದ್ದೆ ಉಳ್ತೀನಿ. ಬಟ್ ಈ ತರದ ಕೆಲಸ ಮಾಡೋದಿಲ್ಲ. ಗದ್ದೆ ಹೊತ್ತು 4 ಜನಕ್ಕೆ ಅನ್ನ ಕೊಡ್ತೀನಿ. ಈ ತರದ ಕೆಲಸನ ಮಾಡೋದಿಲ್ಲ. ಯಾರನ್ನ ಕಾಲಿಗೆ ಇಟ್ಕೊಂಡು ನಾನೇನ್ ಬಂದಿಲ್ಲ ಇಲ್ಲಿ ಜಡ್ಜ್ ಆಗಿ.
It is right, Lord. We would want people like your lordships to continue. We don't want such anything, Lord, which will go, Lord,
ಏನ್
the way.
ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ ಇನ್ನು ಅದು ಇದ್ದೀರ ಇವೆಲ್ಲ ಬೇಡ. ಯಾಕೆ ಬೇಕು ಇವೆಲ್ಲ ಅಲ್ವಾ?
ತಾವು ಆತರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಯ್ತು ಅಂದ್ರೆ
ನಿಮ್ಮ ಇವ್ರಿಗೆ SP ಇದಾರಲ್ಲ ಅವ್ರಿಗೆಲ್ಲ ಈಗ ಏರ್ಸಿದ್ನಲ್ಲ, ನಿಮ್ ಇಬ್ರು SP ಗಳು ಇದಾರೆ. ಯಾಕೆ ಮಾಡಿದ್ರು ಅದನ್ನ? ವೈ ದೇರ್ ಆರ್ 2 ಇರೋದೇ ಪೋಸ್ಟ್ 1, 2 ಜನ ಯಾಕೆ ಇನ್ಚಾರ್ಜ್? If he is not budging, I think if he is not budging to the ADGP, that's why one more post is. Have they taken permission from the DPR? ಇದೇನ್ರಿ SP? ನೀವ್ಯಾರ ಇನ್ಸ್ಪೆಕ್ಟರ್ DYSP ನ? SP ಇದೆಯಾ ಪೋಸ್ಟ್ 2? ಒಂದೇನ ಇರೋದು ಬೆಂಗಳೂರು ಸಿಟಿಗೆ? ಅಡ್ಮಿನ್ ಅವೆಲ್ಲ ಬ್ಯಾಡ್ರಿ. ನಾನ್ ಕೇಳ್ತಿರೋದು SP ACB ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಬೇರೆ, SP ಇದೆಯಾ ಅಂತ ನಾನು ಕೇಳಿದೆ. ಇಲ್ಲಿ ACB ಮ್ಯಾಟರ್ಸ್ ನ ಲುಕ್ ಆಫ್ಟರ್ ಮಾಡಕ್ಕೆ ಒಂದೇ ಪೋಸ್ಟ್ ತಾನೇ ಇರೋದು. ರೇಂಜ್ ಬಿಟ್ಬಿಡಿ, ಬೇರೆ ರೇಂಜ್ ಬಿಟ್ಬಿಡಿ. ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ ಒಂದೇ ಪೋಸ್ಟ್. ಅವ್ರಿಗೆ ಉತ್ತರ ಇಲ್ಲ ನೋಡಿ.
ಈಗ
ಪೋಸ್ಟ್ ಕ್ರಿಯೇಟ್ ಆಗಿದೆ.
creation of post was not now. Not I verified. It is there from long. But it is not.
ಬ್ಯಾಡ್ರಿ ನನಗೆ 2 ಬೇಕಷ್ಟೇ. Shall I direct the state government to place the service records of ADGP, or you are going to get? ನೀವು ನಿಮ್ಮನ್ನ ನಾನು ಈಗ ನಂಬಂಗಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ನೀವು other day you gave an undertaking that you are going to place all B report ಯಾವ್ದಾವ್ದು ಮಾಡಿದ್ರಿ ಎಲ್ಲ ಮಾಡಿದ್ರಿ ಅಂತ ಅಲ್ವಾ? ಅದು ಕೊಟ್ಟಿಲ್ಲ ಈಗ. ತೊಳಿ.
Can I just pass on 2 judgments and I'll leave it?
ಕೊಡಿ. I will pass an order if that is the case. ನನಗೆ ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಮಧ್ಯಾಹ್ನ. I will pass an order. You get the records of appointing of A2. ಆಯ್ತಾ? A2, and also instruct this DPR secretary to place the service records of ADGP. Then I will consider all with judgments. What our counsel who is there to defend the not ACB, but he is defending the people who are indulged in such. I will consider your bail petition also. I will dispose your today ಬೇಕಾದ್ರೆ ನಿಮ್ಮ bail petition ಅವ್ರದೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿ ಬಿಡೋಣ. ಆಯ್ತು, will consider all. You get that records when he was appointed. A2 who has received an amount of rupees 5 lakhs on behalf of the deputy commissioner, you place it before the court. And also the service records of ADGP. DPR secretary ಇರಬೇಕು ಕೋರ್ಟ್ ಮುಂದೆ. Whether he comes or deputy secretary comes before the court, both let them be here. I will pass an order. Gone to the extent of threatening a judge also. Even an instance of transferring of a judge from this place to some other place also. Whatever the word is spoken with me, I will extract in the order itself. If having guts to transfer the judge, transfer in first. But 230 ಇರಬೇಕು ನೋಡ್ರಿ. You instruct state government, let be there. All ADGP and other 2 SP and other charge of SP, headquarter assistant now given charge of BBMP, BDA, all should be here while passing an order. I will take up this matter at 2:30. I will pass order in detail. ಯಾವ ಸೈಟೇಷನ್ಸ್ ಇದೆ ಅನ್ನ ಕೊಡಿ, ಅಣ್ಣ ಕೊಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ ಕೊಡಿ, ಅದನ್ನು ಓದನ ಕೊಡಿ. ಚಿದಂಬರಂ ಜಡ್ಜ್ಮೆಂಟ್ 2019. ಓದಿದ್ದೀನಿ ಜಡ್ಜ್ಮೆಂಟ್. ಇನ್ನೊಂದೇನು
Para 67.
ಮುರುಗೇಶನ್ ಜಡ್ಜ್ಮೆಂಟ್. ಐ ನೋ ಆಲ್ ದೀಸ್ 2 ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಇದು 438 ಕನ್ಸರ್ನ್ ಮಾಡಕ್ ಸಂಬಂಧಪಟ್ಟಂತೆ ಬಂದಿರತಕ್ಕಂತ ಜಡ್ಜ್ಮೆಂಟ್. ನಾನೇ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಇಟ್ಕೊಂಡು ಪಾಠ ಮಾಡ್ತೀನಿ ಅಕಾಡೆಮಿ, ಆಯ್ತಾ? ಮುರುಗೇಶನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಲ್ಸೋ 2010. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೂಡ ಇಲ್ಲಿದೆ, ತಂದಿಟ್ಟಿದ್ದೀನಿ ನಾನು, ಆಯ್ತಾ? ನೋಡ್, ಚಿದಂಬರಂ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 438 ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಮಾಡಿರ್ತಕ್ಕಂಥ ಅಬ್ಸರ್ವೇಷನ್. ಇನ್ ಎ ಕೇಸ್ ಆಫ್ ಎಕನಾಮಿಕ್ ಅಫೆನ್ಸಸ್ ಇದ್ದಾಗ,
Additionally, para 64 onwards, court while considering the scope not of 64 onwards, court considered not the scope of
2014 ಅಲ್ಲೂ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ, ಕೊಡ್ತೀವಿ. ಮಾಡೋಣ, ಆಯ್ತು. ದಟ್ಸ್ ಆಲ್ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಮಾಡಿದ್ರಿ. Now you are not going to place the records of the report and all. You are not undertaking. ಅದೇ ಬರಿತೀನಿ. He has given an undertaking, but now turned hostile ಅಂತ. ಏನಂತೆ ಕೊಡ್ತಾರ? ಓನ್ಲಿ ನಿಮ್ಮ DYSP ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಂದಲೇ ಅವತ್ತು you intervened in the middle of the dictating the order. ಹೌದಲ್ಲ?
yes.
Why you are not placing the material before the court? Now who has given an instructions not to place the records ಅಂತ? Who has given an instructions? Other day he has undertaken, and through your mouth only he said.
Yes,
now why you are hesitating? If you are not culprits, why you are hesitating to place the material before the court? No answer alla Manmohan? No answer. You see the interest of the general public. ರೋಗ ಇದು, ಕ್ಯಾನ್ಸರ್ ಎಲ್ಲ ಕಡೆ ಆವರಿಸ್ಕೊಳ್ತಾ ಇದೆ. ಈಗಾಗಲೇ ಸೆಕೆಂಡ್ ಸ್ಟೇಜ್, 3rd 4th ಹೋದ್ರೆ ಅನ್ಕ್ಯೂರಬಲ್ ಕ್ಯಾನ್ಸರ್. ನನಗೇನಿಲ್ಲ, ಭಗವಂತ ಚೂರೇನ ಬುದ್ಧಿ ಕೊಟ್ಟಾನೆ, ಏನು ಚೆನ್ನಾಗಿ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ, ಉಳ್ಮೆ ಮಾಡ್ತೀನಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಇಫ್ ದಟ್ ಈಸ್ ದಿ ಕೇಸ್, ರೈತನ ಮಗ ನಾನು, ಗದ್ದೆ ಉಳ್ತೀನಿ. ಏನ್ ನನಗೇನು ಆತರ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಆಗಿ ಬಂದೆ ಮತ್ತೇನು ಗದ್ದೆ ಉಳೋದ್ರಲ್ಲಿ ಏನು ತಪ್ಪು ಅಂತ ನನಗೇನು ಅನ್ಸೋದಿಲ್ಲ. ಅವರೇ ಅನ್ನದಾತರು. If that is the case, why there was a threat to me? If that is the case, I don't know why. I'm not sitting here to please anybody else. I'm concerned only about this institution. This is nothing but an attack on the independence of judiciary, counsel. This is nothing but an attack on the independence of judiciary. Should not. ಆಯ್ತು, ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ತಗೊಳ್ಳಿ, ಕೊಡಿ. ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ಪನ್ನಣ್ಣ, ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಇಟ್ಕೊಳ್ಳಿ, ಅವ್ರು ಯಾರು ಇದ್ರಲ್ಲ, ಈ ಫ್ಲೇಡ್ ಫ್ರಾಡ್ ಅಂತ ಕೋರ್ಟ್ ಅಲ್ಲ, ಅವ್ರದ್ದು ಏನಾರು ಸಬ್ಮಿಷನ್ ಹೇಳಂಗಿದ್ರೆ, ಮತ್ತೇನಾದ್ರು ಸಬ್ಮಿಷನ್ ಇದ್ರೆ ಹೇಳ್ಬೋದು. ಐ ಆಮ್ ಕನ್ಸಿಡರಿಂಗ್ ದಿ ಸೆಟ್ ಆಸ್ಪೆಕ್ಟ್ ಆಲ್ಸೋ. ಯು ಕೀಪ್ ಹಿಮ್. ಐ ಥಿಂಕ್ ಹಿ ಇಸ್ ನಾಟ್ ಇದರ ಇಲ್ವಾ? Keep him also. If anything to say about the fraud on the court, I will hear him and then I will pass an order. Without hearing anybody else, I will not pass any order. 59.
Offences are my lord. Major offences to my lord. 308, 504, 506, 341.
813.
Accused were arrested and produced on 16/5. Injury is simple in nature, my lord. And also, my lord, the assault is made by accused number 1, my lord. These two petitioners are accused number 2 and 3. I am producing the wound certificate. It clearly shows at the time of taking treatment he is normal and the injury is simple in nature, my lord. And the assault is made by A1, he is abscond. A2 and 3 are dismissed. There is no any specific order. And the facts of the complaint is contrary to the facts mentioned in the remand application. ಕಾರಲ್ಲಿ ಇದ್ದಾಗ ಡ್ರೈವರ್ ಸೀಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ಬಂದು ರಾಡಲ್ಲಿ ಅಸಾಲ್ಟ್ ಮಾಡ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. And in remand application, it is very clear that the car of the complainant touched the bike of the accused number 1. That is very clearly stated in remand application. There is some dispute has arisen and scuffle has taken place. Improve what that agide road race. And absolutely there is no any criminal aspects in these petitioners who are arrived as accused number 2 and 3. Permanent residents of Bangalore.
ಏನ್ರಿ ನೋಟ್ ಆಕ್ಟ್ ಅಲಿಗೇಷನ್ ಯಾರ ಮೇಲೆ ಕೈಯಿಂದ ಹೊಡೆದ್ರ A1 ರಾಡಿಂದ ಹೊಡೆದ ಇವರು ಇಬ್ರು ಕೈಯಿಂದ ಹೊಡೆದ್ರು. Order the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the unknown persons assaulted the victim with their hands and also with the iron rod. And immediately he was taken to Remand hospital. And hence case has been registered against unknown persons. And subsequently, ಯಾರೊಬ್ಬ ಇದಾನ ಸೈಯದ್ ಸಾದಿಕ್ ಅಂತ ಒಬ್ಬನ ಮೇಲೆ ಹಾಕಿದಾರಲ್ಲ ಫಸ್ಟ್ ಅಲ್ವಾ ಒಂದವರು. Hence case has been registered and matter is under investigation. The counsel appearing for the petitioner would vehemently contend that the allegation against only accused number 1 and not against these two petitioners who have been arraigned as accused number 2 and 3. The counsel also would submit that injuries are also simple in nature. And at the first instance, case is registered against unknown persons. And the injured is also out of danger and he may be enlarged on bail. For counter, the counsel appearing for the state would submit that A1 assaulted with iron rod on the head. And allegation against these two persons that they inflicted, they assaulted with their hands. And though injuries are simple in nature, all of them have shared the common intention and inflicted injury with the weapon. Hence, there is a prima facie case. Counsel appearing for the petitioner also produced the document pertaining to National Institute of Mental Health and Neurosciences. And injuries are also simple in nature, that is sutured wound and lacerated wound. Having heard the respective counsel and also on perusal of material, the case has been registered against unknown 3 persons at the first instance. And thereafter, these two petitioners are also arraigned as accused number 2 and 3. And specific court act allegation against accused number 1 that he inflicted injury with iron rod. The other A2 and A3 assaulted with their hands. Taking into note of the accusation made against these two petitioners that they assaulted with their hands. And apart from that, nature of injuries are also simple in nature. Taking into note of accusation against these two petitioners, it is a quick case to exercise the powers of 438 of 439. 439 of CRPC, since they are in custody from the date of their arrest, and they may be enlarged on bail with conditions to cooperate with the IO and not to tamper the prosecution witnesses. Any of the discussions, Madam, I pass the following order. ಅಲ್ಲಿಯವರು ಕೂಡ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಫಸ್ಟ್ ಟೈಮ್ ರೀ. ಅದೇ ನೀವು ನಿಮಗೆ ಡೈರೆಕ್ಟೆಡ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ದಿ ನೋಟಿಸ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫೈಲ್ಸ್ ಅಬ್ಜೆಕ್ಟ್ಸ್ ಇಫ್ ಎನಿ. ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆ. Petitioner counsel 6 time. This matter on 11. 61 DN Shiva. Kumar. Notify ಮಾಡಿಲ್ಲ. ಓಕೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಲಿಲ್ಲ ನೋಟಿಫೈ ಮಾಡಕ್ಕೆ. ಅದು ಮಾಡಿಲ್ವಾ? Correct name is mentioned officer on file objections. HCGP seeks time to notify. No, HCGP is directed to notify the complainant after 50 months. Next time granted. Discuss matter on Friday. ಯಾವಾಗ ಮೇಡಮ್? 8. 62.
My lord, for the petitioners in this case, the petitioners are the accused number 2 and in the present case, my lord, and the offences alleged are 307, 392, 394, 397, 450, 506 and 507, my lord. My lord, charge sheet has been placed and my lord, charges have been printed and trial has also been commenced, my lord. CW1 or the chief examination matra agide swami. My lord, the allegation is that, my lord, the accused number 1
chief agide, class agide.
Class agilla, sir. Chief agide. Chief examination agide.
Then why you have approached this court?
My lord, our actually crime number the order challenge ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ bail. They have not challenged the subsequent actions, my lord. Charge sheet and the evidence. My lord, the allegation is that, my lord, the accused number 1, the accused number 1, 2, 3, my lord, they plot a act of committing robbery in the CW1's house, my lord. Accused number 1 no CW1 or manege hogi, my lord, he will assault the CW1 by way of rod on his leg, my lord. CW2 threw chili powder on CW1, 2 and 3. CW2 and 3 are none other than the wife and daughter of CW1, my lord. Accused number 3, there is an allegation telling that, my lord, he had assaulted with a machete on the head of the CW1.
Now 3 is also the petitioner before the court.
He is the petitioner number 2 and accused number 2 is the petitioner number 1, my lord. My lord, on the wound certificate which is at page number 82, my lord. 82 is the wound certificate of 80. Apologies, my lord. 80. 80 ಬಂದು victim swami. Wound certificate. The injuries are simple in nature. And moreover, my lord, as insofar as the petitioner number 2 is concerned, my lord, there is no injury on the head of the victim. Machete ಅಲ್ಲಿ assault ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ injury ಇಲ್ಲ ಸ್ವಾಮಿ. Secondly, my lord, so far as the recovery is concerned, chain snatch ಮಾಡಿ ಓಡೋಗಿದ್ರು ಅಂತ ಇದೆ ಸ್ವಾಮಿ allegation. The chain is recovered in the spot itself, my lord. My lord, the Hajar is at page number
In recovery at he was
36. 36 ಅಲ್ಲಿ ರಿಕವರಿ ಇದೆ ಸ್ವಾಮಿ. ಒಂದು ಚಿನ್ನದ ಚೈನು 25 ಗ್ರಾಮ್ ತೂಕ ಇರುತ್ತದೆ. My lord, this chain has been recovered in the spot itself. It is not recovered from the accused number 2 or accused number 1 or from the accused number 3, my lord. As far the medical FSL report is concerned, my lord, which is at page number 132. Stain detected. Stain detected. Blood stains machete ಅಲ್ಲಿ ಡಿಟೆಕ್ಟ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಯಾವ್ದ್ರಲ್ಲಿ ಡಿಟೆಕ್ಟ್ ಆಗಿದೆ? ಕ್ಲಾತ್ ಅಲ್ಲ.
ಕ್ಲಾತ್ ಅಲ್ಲಿ ಡಿಟೆಕ್ಟ್ ಆಗಿದೆ.
ಕ್ಲಾತ್ ಅಲ್ಲಿ.
Accused ಯಾಕಂದ್ರೆ ಸ್ವಾಮಿ victim has assaulted the accused also in this case. ಮಚ್ಚಲು ಡಿಟೆಕ್ಟ್ ಆಗಿದೆ.
FSL report.
131 number. Serial number 12 1 ಮಚ್ಚು ಅಂತಿದೆ. My lord, your lordship may kindly see 1. Serial number 12 1 ಮಚ್ಚು.
ಮಚ್ಚು.
ಅದು next page ಅಲ್ಲಿ opinion. Opinion next page. Blood stain was detected in article 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 ಬಿಟ್ಟು 11 and 12. ಎಲ್ಲದರಲ್ಲೂ ಡಿಟೆಕ್ಟ್ ಆಗಿದೆ.
ಎಲ್ಲ ಸ್ಟೈನ್ Except 10.
Except 10.
Except
10
one
only
night.
one night pant ಅಷ್ಟೇ.
Also recovered.
My lord, the allegation is that, my lord, the petitioner number 2, he has assaulted on the head of the victim, my lord, with the machete. That is the macho which is at serial number 12. My lord, in the injury report, in the wound certificate, my lord, there is no such injury which has been found. Insofar as, my lord, the accused number 3's medical report is concerned, my lord, which is at page number 82, which was assaulted by the victim to the accused number 3, Sidnayaka. ಅವರು simple in nature ಇದೆ ಸ್ವಾಮಿ. All the injuries are in simple in nature. Yes, I request your lordship to grant bail, my lord, with any conditions. Just
The machete was recovered from the accused number 3. But also the cloths were on the same spot, my lord. Both the petitioners' cloths are recovered. The stain was detected on the said cloth. There are prima facie case against the petitioner.
A2 ಸ್ಟೈಲ್ ಇದೆಯಾ ಬ್ಲಡ್ ಅಲ್ಲಿ? ಅದರಲ್ಲೂ ಇದೆ.
ಅವ್ರದ್ದು ಇದೆ.
ಹಾ. ನೋಡಿ.
Moreover, my lord, the trial has been commenced, my lord.
ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ.
trial has been commenced.
ಅರ್ಲಿಯರ್ ಬಂದಿರಲಿಲ್ಲ ಕೋರ್ಟ್ಗೆ ಇವರು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಬಂದಿರಲಿಲ್ಲ.
ಈಗ ಯಾರ್ಯಾರು ವಿಚಾರಣೆ ಆಗಿದೆ? ಓನ್ಲಿ CW1
CW1 only, my lord.
ಮಾತ್ರ.
ಅವರೊಬ್ಬರೇ.
The petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 29/10/2020 at 10:15 PM when CW1 was in the shed wherein he was residing along with his family members, accused persons with a common intention holding deadly weapons in their hand showed the machete, knife and iron pipe and caused the life threat. When he replied that he is not having any money, A1 inflicted injury with iron rod on the CW1. And accused number 2 spilled the chili powder on CW1, 2, 3. And accused number 1 snatched the gold chain belongs to the CW2, weighing 25.650 grams. And when the CW1 tried to rescue the CW2, at that time accused number 3 inflicted injury with machete on the CW1. As a result, he had sustained injuries. The police have also registered the case and investigated the matter and filed the charge sheet. The counsel appearing for the petitioner would submit that the main allegation is against accused number 1. And now investigation has been completed and charge sheet is also filed and no need of continuing them in custody. The counsel also submit that there is no any criminal antecedents in Illinois.
Yes, sir.
No criminal antecedents against the petitioner herein. And injuries are simple in nature. Injuries are simple in nature. And though cloths and machete and iron rod are seized, no positive report. For contra, the counsel appearing for the state would submit that the accused number 1 at the first instance inflicted injury with iron rod, iron pipe on the head of CW1. ಕಬ್ಬಿಣದ ಪೈಪ್ ನಿಂದ ಕೊಲೆ ಮಾಡೋ ಉದ್ದೇಶದಿಂದ ಆರೋಪಿರವರ ತಲೆಗೆ ಅಂತಿದೆ ರೀ, ತಲೆಗೆ ಅಂತಲೇ ಇದೆ. ಆಯ್ತಾ, ಏನಾಯ್ತು? ಮತ್ ತಲೆಗೆ ಕಾಲುಗಳಿಗೆ ಎರಡಕ್ಕೂ ಹೆಡ್ ಅಂಡ್ legs. And also specific allegation against A2, who is the petitioner, that he spilled the chili powder on CW123, and making use of the said circumstances, accused number 1 snatched the gold chain of 25 grams, 25.650 grams of gold. And also against the petitioner, accused number 3, that he inflicted injury with machete on CW1. The counsel also submitted that the stained cloth of these two petitioners were seized, and the FSL report is positive that stains with blood. The counsel also would submit that the weapon was seized at the instance of accused number 3, and the same is also stained with blood. And report also confirms the same. Having heard the respective counsel and also on perusal of material, the case of the prosecution is also that these two petitioners, along with accused number 1, went with weapons, that is deadly weapons, and also with chili powder, and spilled the chili powder on accused number CW123. Also caused the injuries with the weapon, that machete. Though the injuries are simple in nature, court has to take note of it is an offense against society at large. And the offenses are grouped against the petitioners are 92, 394, and 397, and also 307. An intention to commit the offense committed the offense, and also the prima facie material disclosed the stains. The parts of these two petitioners stains blood, as well as the seized also stains with blood. When such being the case, it is not a fit case to exercise the power of reported union of service. The counsel also submitted that already CW1 has been examined for examined and yet to examine other prosecution witnesses. Under the circumstances, also not a case for enlarging the petitioner on bail.
Pay for the petitioners.
Last time when SOP verify ಮಾಡಿ ಅಂತ
notification ಇಲ್ಲ sir, ಅದು delay ಆಯ್ತು 2 days charge sheet
Well, I have the may I pass on the copy of the judgment of the Supreme Court, my lord.
ಬಿಡಿದೆ ಯಾವ್ದಾದ್ರು ಸರ್ಕಾರ ಇದೆ ಅನ್ನೋಳಗೆ ಯಾವ್ದು
last time ಇದಾಗಿತ್ತು, but there was a delay. Then he is entitled for statutory bail. 2 days ಆದ್ರೂ ಬರುತ್ತಲ್ಲ.
ಅದರಲ್ಲಿ ನಾನು
charge sheet within prescribed period, denial of bail on ground that restrictions imposed during lockdowns would be not give the right to accused to pay for grant of default bail is really clearly announced, not in accordance with the neither Supreme Court can be held. We have eclipsed the same prescribed also not restrictions imposed during
ನನ್ನ ಸಬ್ಮಿಷನ್ಸ್ ಏನಂದ್ರೆ 167 ಸಬ್ ಕ್ಲಾಸ್ 2 ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ, ಅದು ವಜಾ ಆಗುತ್ತೆ. ಬಟ್ ಅವರು ಏನ್ ಮಾಡ್ತಾರೆ, ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ 439 ಹಾಕ್ತಾರೆ, ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡೋಣ. ಡಿಫಾಲ್ಟ್ ಬೇಲ್ ಚಾಲೆಂಜ್
even that order has not been challenged, but it is a statutory bail. Statute itself provides the right to the accused.
2 days delay.
2 days delay. Sorry, good. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that an amount to consume the alcohol. ಯಾರದು ಡಿಮಾಂಡ್ ಮಾಡಿದ್ದು? ಇಂಜೂರ್ಡ್
the petitioner, my lord, is the husband of
petitioner.
own wife and ಸಾಯಿಸಿದ್ರು.
From the wife, and he was addicted to bad vices, and in spite of the advice was made to him, he continued the harassment, both mental and physical, and that on, full stop, that on 31/10/21, he demanded money from the wife, and when she refused, he abused in a filthy language, and with an intention to take away the life, he assaulted with his right hand. As a result, she fell down. ಅಷ್ಟಕ್ಕೇನ ಬಿತ್ತೋಗ್ಬಿಟ್ಟಿದ್ದಾಳ, ಬರೀ ಕೈಯಲ್ಲಿ ಹೊಡೆದಿತ್ತು.
ಕಪ್ಪಲೆಲ್ಲ ಹೊಡೆದಿದೆ.
He fell down and lost her breath. In order to screen the evidence, pretended that she has committed an offense. Hence, case has been registered and investigated the matter and filed the charge sheet for the offense pursuant to 504 301 of IPC. The counsel appearing for the petitioner would submit that charge sheet is filed after 2 days of delay. And an application is filed before the trial court, invoking 167 of CRPC. And the trial court committed an error in rejecting the application on the ground that there was a COVID situation, and hence delay was passed. The counsel appearing for the petitioner declared upon the judgment reported in the AR 2020 Supreme Court 2921, wherein the apex court in respect of this section 167(2) held that declared default bail indefeasible right to be released, non-submission of charge sheet within prescribed period, denial of bail on ground that restrictions imposed during lockdown should not give right to accused to pray for grant of default bail, is clearly erroneous and not in accordance with law. Neither Supreme Court can be held to have eclipsed the time prescribed under section 167(2). Nor restrictions imposed during lockdown shall operate as restriction on rights of the accused, protected by section 167(2) and granted bail. For contra, the counsel appearing for the state would submit that though an application is filed under section 167(2) of CRPC before the trial court, and the same has not been challenged, the order has been attained its finality, but approached the court by filing an application under section 439 of CRPC, and now cannot contend that the charge sheet was not filed within time, and hence the petitioner is not entitled for bail. Having heard the respective counsel and also on perusal of material, the prosecution also not disputes the fact that charge sheet was filed. Charge sheet was filed after the expiry of the 90 days. That is, there was a delay of 2 days in filing the charge sheet. And counsel also would vehemently contend that the order has been attained its finality. The said contention cannot be accepted for the reason that the statute itself has given the right to accused to invoke section 167(2) when admittedly no charge sheet is filed within time. The right of the petitioner accused is indefeasible right, and he has to be released. And also the trial court has given the reasons that due to COVID, charge sheet could not be filed within time. And Supreme Court in the judgment report supra says that neither Supreme Court can be held to have eclipsed the time prescribed under section 167(2), nor restrictions imposed during lockdown shall operate as restriction on rights of accused, and he has to be protected by under section 167(2), and also the apex court granted bail, taking into note of the principles laid down in the judgment and also the right accrued to the accused under the statute. The petitioner can be enlarged and bail with conditions.
Please.
Magarity 406.
438.
406, 408.
406, 408 and 420. This is the complaint. 5921 is that
ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಚಾರ್ಜ್ ಆಗಿದೆಯಾ?
ಇವರನ್ನು ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್
ಅವರಿಗೆ
ಚಾರ್ಜ್ ಶೀಟ್ ಮೇಲೆ ಬಂದಿಲ್ಲ ಅದಕ್ಕೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಂತಲ್ಲ, ಹಾಕಿ ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಪ್ಲೇಸ್ ಮಾಡಿ. ಆಯ್ತು ನೋಡಿ. ಯಾವಾಗ ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ? ನೀವು ಕಾಪಿ ಕೊಟ್ಟಿರ್ತೀರಲ್ಲ, ನೋಡಿದೀರಾ? ನೋಡಿ ಯಾವತ್ ಬೇಕು ಹೇಳಿ. HCGP submits that charge sheet already filed. And hence petitioner counsel seeks time to place the charge sheet material and dismiss matter on 12th as sought. ಇದೀಗ ರಾಜಗೋಪಾಲ್ ಯಾರು ಬರೋದೇ ಇಲ್ವಲ್ಲ ಈಗ? ಸುಮಾರು ಸರಿ ಅವಕಾಶ ಕೊಡ್ತೀನಿ ನೋಡಿ. This court-wide order dated 27/6/22 made it clear that matter was called twice in the morning session as well as in the afternoon, and counsel was absent. This court also noticed that in the previous occasion also counsel was absent, and however, in the ends of justice, one more opportunity was given, and also made it clear that if the counsel doesn't appear in the next date of hearing, matter petition will be dismissed. In spite of such opportunity, the counsel is not pursuing the matter diligently, and hence dismissed for non-prosecution. Tanuja, MV 323 506 307 ಏನಿದೆ?
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆಯಾ? ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಏನ್ ಮೇಡಮ್?
ನೇಚರ್ ಆಫ್ ಇದು ಚಾರ್ಕೋಲ್ ತಿಂದಿರೋದು ಅಂತ ಪ್ರೀವಿಯಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ he has been discharged.
ಯಾವಾಗ ಡಿಸ್ಚಾರ್ಜ್? ಎಷ್ಟು ದಿವಸ ಇದ್ರು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ?
ಹಾಸ್ಪಿಟಲ್ 10 ದಿವಸ ಏನೋ ಇತ್ತು. 10 ದಿವಸ ಇಲ್ಲ ಸ್ವಾಮಿ, 6 ದಿವಸ ಇತ್ತು. 34ಕ್ಕೆ ಡಿಸ್ಚಾರ್ಜ್ ಆದ್ರು. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ we got admitted in MBJ hospital. ಆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗ he has submitted the saying that he is admitted in the MBJ hospital. Later on we verified the matter and he got discharged on 18/5 ಅಲ್ಲೇ.
18/5 ಎಷ್ಟು ದಿವಸ ಒಟ್ಟಿಗಿದ್ದ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ?
ಇದೊಂದು 8 ದಿವಸ, ಅದೊಂದು 6 ದಿವಸ.
8 6 14 ದಿವಸ. ಮತ್ತೆ ಇಂಜುರಿ ಏನು? ಸ್ಟಮಕ್? Is it not vital part?
ಶೋಲ್ಡರ್ ಗೆ ಮತ್ತೆ ಲೆಫ್ಟ್ knee.
ಲೆಫ್ಟ್ ಶೋಲ್ಡರ್ ಲೆಫ್ಟ್ ನೀ ಏನ್ರಿ ಇದೆಯಾ? 2 days
ಟೈಮ್
ಓಕೆ.
ವಯಸ್ಸಾದ ನೋಡ್ತಾರೆ.
HCGP 6 2 days ಟೈಮ್.
Meanwhile ಇದೊಂದು ಡಿಸ್ಚಾರ್ಜ್
ಆಯ್ತು ಮೇಡಮ್,
ಇದರಲ್ಲಿ
ಎರಡೇ ದಿವಸ ಮೇಡಮ್, ಎರಡೇ ದಿವಸ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಡಿಸ್ಚಾರ್ಜ್ ಮೆಮೊರಿ ಇದೆಯಾ? ನೀವು ಕೊಡೋದು ಅದೇನೆ ತಾನೇ? ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಯಾಕೆ?
ಅಲ್ಲ, ಟೈಪ್ ಮಾಡ್ಲಿಕ್ಕೆ ಟೈಪ್ ಕಾಪಿ ಲಾಂಗ್ ಪಿಟಿಷನ್ ಹಾಕಿದೆ.
MBJ ಈಗ ಆಮೇಲೆ ಫಸ್ಟ್ ಏನು? ಶಾರ್ಪ್ ವೆಪನ್ ನೈಫ್
ಈ ಕಡೆ
ಕಾಣದೇ ಇಲ್ವಲ್ಲ ಮೇಡಮ್? ಇಂಜುರಿ ಕಾಣದೇ ಇಲ್ವಲ್ಲ? ಇದು ಜೆರಾಕ್ಸ್.
ಅದೇ ಜೆರಾಕ್ಸ್ ಅಲ್ಲಿ ಅವರು ಏನು ಕಾರ್ಬನ್ ಕಾಪಿ ಬರ್ದಿದ್ದಾರೆ.
ಆಯ್ತು, ಅವ್ರೇನು ಹಾಕ್ಲಿ ಹೋಗಿ 2 ಸಲ 2 ದಿವಸ ಹಾಕಿ. HCGP 6 2 days time to place the wound certificate and hence list this matter on ಯಾವತ್ತು ಮೇಡಮ್? ಬುಧವಾರ ಗುರುವಾರ? 7th. ಆಯ್ತು ಆಯ್ತು. ಹರೀಶ್ ಭಂಡಾರಿ A1 to 4 ಏನ್ರಿ ಇದು? ವೈಲ್ಡ್ ಲೈಫ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದಾರಾ? ವೈಲ್ಡ್ ಲೈಫ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದಾರಾ? ಹಾಕಿಲ್ವಾ? ಅಂಡರ್ ಸೆಕ್ಷನ್ 55 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು. ಮಾಡಿದಾರಾ ಅಂತ ಕೇಳಿದ್ರು. ಮಾಡಿದಾರಾ? ಆಯ್ತು. ಏನು ಅಫೆನ್ಸಸ್ ಅಲ್ಲಿ?
Decomposed body of the bison, your worship, wild bison.
Bison, found where?
Found in the property of the accused.
Land ಅಲ್ಲಿ. ಆಯ್ತು.
ಬಂದ ಸತ್ಯಜೀವರು ಅದು ಕೊಳೆತು ಹೋಗಿದ್ದು ಅದನ್ನು ಮುಚ್ಚಿದ್ದಾರೆ ಇವರು.
ಕೊಳೆತು ಹೋಗಿದ್ದನ್ನ ಮುಚ್ಚಿದ್ದಾರೆ.
ಇವರು ಸಾಯಿಸಿದ್ದಾರೆ ಅಂತ. ಡಿಕಂಪೋಸ್ ಆಗಿದ್ದನ್ನು ಪೋಸ್ಟ್ಮಾರ್ಟಂ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಅವ್ರು ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರೆ.
ತಿಂದಿಲ್ಲ ತಾನೆ? ಬರೀ ನಿಮ್ ಪ್ರಕಾರ ಬೈಸನ್ ಹೊಡೆದು ಸಾಯಿಸಿ ಮುಚ್ಚಿದ್ದಾರೆ ಅಂತ. ಸತ್ತೋಗಿದ್ ತಗೊಂಡೋಗಿ ಮುಚ್ಚಿರ್ತಾರೆ. ಯಾರು ಹೊಡೆದ ಸಾಯಿಸ್ತಾರೆ ಅದನ್ನ?
ಮೊನ್ನೆ ಸಕಲೇಶ್ಪುರದಲ್ಲಿ ಒಂದು ಆನೆ
ಆನೆ ಎಲ್ಲ ಕಡೆ ಬರೀ ಆನೆ ಕಾಟ, ಇಲ್ಲ ಬೈಸನ್ ಕಾಟ.
ಬೈಸನ್ ಕಾಟ ಯಾರು ಹೊಡೆದಿರ್ತಾರೆ ಅದು ಎಲ್ಲ ಬಂದು ಸಾಯ್ತವೆ.
ಎಲ್ಲ ಕಡೆ ಇದೆ ಬೈಸನ್. ನಮ್ ತೋಟಕ್ಕೂ ಬರುತ್ತೆ
ಬೈಸನ್.
ಅದು ಹೆಜ್ಜೆ ಇಟ್ಟರೆ ಸಾಕು. ಆ ಗಿಡಗಳಿದೆಯಲ್ಲ, ಗಿಡಗಳೆಲ್ಲ ಬುಡ ಎಲ್ಲ
ಪೈಪ್ ಹಾಕಿರ್ತಾರಲ್ಲ,
ದಟ್ ಈಸ್ ದಿ ಮೇನ್ ಪ್ರಾಬ್ಲಮ್. ಹಾಳು ಮಾಡೋದ್ಕಿಂತ ಹೆಜ್ಜೆ ಇಟ್ಟು ಮುಂದೆ ಓಡುತ್ತಲ್ಲ ಅದ್ರ ಸ್ಪೀಡಿಗೆ ಗಿಡಗಳೆಲ್ಲ ಹಾಳಾಗುತ್ತೆ.
ಅದನ್ನೆಲ್ಲ
ನಿನ್ನೆಲ್ಲ ಸ್ಟ್ರೈಕ್ ಮಾಡಿದ್ರು.
ಸ್ಟ್ರೈಕ್ ಮಾಡೋದು ಒಂದ್ ದಿವಸ ಬಿಡೋದು ಅಷ್ಟೇ, ಏನೋ ತಗೊಳಲ್ಲ. ಆನೆ ಕಾರಿಡಾರ್ ಬಗ್ಗೆ ಮಾತನಾಡಿ ಬಹಳ ವರ್ಷ ಆಗಿದೆ ಬಿಡಿ. 10-15 ವರ್ಷ ಆಯ್ತು. ಅವೆಲ್ಲ ಮಾಡಲ್ಲ. ಬೇರೆದೆಲ್ಲ ಮಾಡ್ತಾರೆ. ನೋಡಿ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that a private complaint is filed against the petitioner that he killed the bison and thereafter committed the same and hence invoked the offence punishment section 216, 2 within bracket 16. 9, 51 read with section 55 of Wildlife Protection Act 1972. And court has taken the cognizance. So the complaint will cognizance court has taken the cognizance. The counsel appearing for the petitioner would submit that these petitioners have not killed the bison and false allegations are made against these petitioners. But only on suspicion, making an attempt to ಈಗ ನಿಮ್ಮನ್ನ ಮಾಡಿಲ್ವ ಅಕ್ಯೂಸ್ ನ ಮಾಡಿದಾರಲ್ಲ ಇಂಪ್ಲಿಕೇಟ್ ಅಂತ ಅಪ್ರೈಂಡ್ ದಿ ಪಿಟಿಷನರ್ಸ್ and offense is also not punishable with death or imprisonment for life and these two petitioners are not indulged in committing any such offense as arrest. For counter, the counsel appearing for the state would submit that separate private complaint is filed and comes to know that the bison was killed and thereafter cremated the same in the land belongs to these petitioners. And hence there is a prima facie case. Having got the respective counsel and also on perusal of petition and particularly the accusation made that the decomposed bison was exhumed. Odalla exhumed madidare or exhumed. And the criminal prosecution also initiated by filing the private complaint as envisaged under section 55 of the WLOR Act. And having taken note of the accusation and also the gravity of the offence, it is a fit case to exercise the discretion in favor of the petitioner with conditions to cooperate with IO for the investigation in the matter.
2 days. One certificate ಬಂದಿಲ್ಲ ಸರ್. Head injury ಇದೆ.
D07. HCGP 6 T6 2 days time. HCGP 6 2 days time to secure the wound certificate. And hence this matter on 7th. 7th only ತರ್ಸ್ಕೊತಿರಲ್ಲ 69 ಶಿವಮೂರ್ತಿ.
There is a sale deed executed by impersonation by impersonating one Shanta.
Shanta. Shanta is the petitioner or not?
Shanta is not the petitioner. What they have done, the witness is made as an accused.
You witness, only witness. Advocate ಆಗಿ ವಿಟ್ನೆಸ್ ಆಗೋದ್ರು ಅವರೇ ಡ್ರಾಫ್ಟ್ ಮಾಡ್ಬಿಟ್ಟವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಆ ಗಿರೀಶ್ ಅನ್ನೋನ್ನ ಅವ್ರನ್ನೇನು ಮಾಡಿಲ್ಲ.
ದಿಸ್ ಪಿಟಿಷನರ್ ಇಸ್ ವಿಟ್ನೆಸ್. ಏನ್ ಅಲಿಗೇಷನ್?
What they say in the body of the petition is to the best knowledge of the complainants, the witnesses to the disputed sale were
with the knowledge they have attested ಅಂತ. That is the only allegation.
That is the only allegation.
Good. What the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that sale deed is created by fictitious persons and in that sale deed this petitioner being an advocate. Being an advocate but attested the said fictitious document and hence invoked the offense against this petitioner. Offense punishment 419, 420, 465, 468. ಇದ್ರಲ್ಲಿ ಯಾವ್ದು ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೆ? 419, 418 ಇವ್ರಿಗೆ ಯಾವ್ದು ವಿಟ್ನೆಸ್ ಅಂತ ಅಷ್ಟೇ. The counsel appearing to the petitioner would submit that this petitioner is an advocate and he only attested the document. He was not aware of whether the said document is fictitious document or whether document is forged document by the fictitious persons by impersonating the original owner. And the petitioner is ready to obey the conditions that may be imposed by this court and also undertakes to appear before the IO for the investigation in the matter. For contra, the counsel appearing for the state would submit that this petitioner being the advocate attested the document, knowing fully well that the said document is a forged document and the same is forged by fictitious persons claiming that they are the owners, and hence there is a prima facie case. Having heard the respective counsel and also on perusal of material, the allegation against this petitioner is that he was attested the document of registration, and whether he has got knowledge, and with the said knowledge only he has created the document by the original accused. Matter has to be probed. Only question to be considered with regard to this petitioner is that knowing fully well he attested the document has to be probed during the course of investigation, and hence this petitioner can be enlarged on bail with conditions to cooperate with the IO with regard to the allegation made against this petitioner. Raghavendra K.
Read by a senior counsel to assist your lordship. On a 6 and 4 or 26. Lordship, may we have it any time after
After 2 days illa ivat bitre next week agboda
after 2 days.
After 2 days illa nav ಏನಂದ್ರೆ ಇವತ್ತಿಂದ ಇವತ್ತು ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಕೊಟ್ಬಿಡ್ತೀವಿ ಡೇಟ್. ಓನ್ಲಿ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಅದು ಇದ್ರ ಮಾತ್ರ ಆಯ್ತು. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 11th ಅಲ್ಲ 11th 71 KL ಶ್ರೀನಿವಾಸ್ ಏನ್ ಬೇಕು? ನೋಟಿಫೈ ಆಗಿಲ್ವಾ? ನೋಟಿಫೈ ಆಗಿಲ್ಲ, ಆಗಿರ್ಬೇಕು ನೋಡಿ. ನೋಟಿಫೈ ದಿ ಕಂಪ್ಲೇಂಟ್ ಅಂತೇನೋ ಆಗಿದೆ, ನೀವು ಮಾಡಿದ್ರೆ ಇಲ್ಲ?
ನಾವು ಮಾಡ್ದಂಗೆ
ಮಾಡಿಲ್ಲ, ನಿಮ್ಗೇನ ಮಾಡ್ರು?
ಅಲ್ಲ, ನಾವು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ
ಸ್ಟೇಟ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ನೋಟಿಫೈ ದಿ ಕಂಪ್ಲೇಂಟ್ ಅಂತಿದೆ. ಗವರ್ಮೆಂಟ್ ಲೀಡರ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸ್ಟೇಟ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ನೋಟಿಫೈ ದಿ ಕಂಪ್ಲೇಂಟ್ ಅಂತಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಆಗಿತ್ತು, ಆಮೇಲೆ ನೋಟಿಫೈ ಆಗಿಲ್ಲ ಅಂತ ಗೊತ್ತಾದ್ಮೇಲೆ ನಿಮ್ಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡಿದೀವಿ. Another 2 days, HCCP seeks 2 days time to notify the complainant / victim / informant and list this matter on Friday. Friday ಹಾಕಿ ಯಾವ ತರ್ಸ್ಟೇ? ಈ ತರ್ಸ್ಟೇನಾ? 7th ಆಯ್ತು ನೋಡಿ, ಟ್ರೈ ಮಾಡಿ. ಆಗುತ್ತೆ ಅಷ್ಟೊಳಗೆ 7th. ವಿನಯ್ ಭಟ್.
When the petitioner was arrested on 2019 by the JP Nagar police in connection with the crime number. During the investigation, they find out there's some crimes and jurisdiction of the respondent police, and they have intimated the same thing. The jurisdiction police, that's the annexure here, page number 110 and 11. Based on that, the respondent police taken the petitioner on the body.
15 ಗ್ರಾಮದ ತೂಕದ ಅರ್ಧ ಭಾಗ ಕಿತ್ಕೊಂಡು ಹೋದ್ನಾ? ಅರ್ಧ ಭಾಗ.
They have taken the judicial custody on the body. They have completed the investigation of the crimes and they filed a charge sheet. And in the present time, they have not taken the petition on the body warrant. They showed him as a absconding when he was in the judicial custody and filed a charge sheet. By taking into consideration, the learned magistrate is issued the NPW. All these 4 cases are pending before the same court, 37 ACMM. And he is attending regularly in the 3 cases before the same court, and he is released in all other cases except the present case in Harassment.
ಅವ್ರಿಗೆ ಹೆಂಗ್ರಿ ಗೊತ್ತಾಗುತ್ತೆ ಜಡ್ಜ್ಗೆ? ದಿನಕ್ಕೊಂದು 3,000 4,000 5,000 ಪೆಂಡೆನ್ಸಿ ಇರ್ತದೆ, ನೀವ್ ಹೇಳ್ಬೇಕು.
We are in the judicial custody. You are shown as an absconding in charge sheet.
ಯಾವಾಗ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದೆ ಅವಾಗ?
As per that, the registration F-75 2019, the FIR was registered against the unknown person.
ಆಯ್ತ್ರಿ, 17/5 ಇನ್ಸಿಡೆಂಟ್ 17/5 2019. ಇವನ್ ಕಸ್ಟಡಿ ಇದ್ದಿದ್ದ ಅವಾಗ?
On 21/6/2019, he was taken on the custody by the JP Nagar police.
21/6/19.
Yes.
ಇದಾದ ಇನ್ಸಿಡೆಂಟ್ ಆದ ಒಂದ್ ತಿಂಗಳಲ್ಲಿ ಅಲ್ಲಿ.
Yes, on the different police station. And
how long he was in the police?
He was there in the judicial custody for 14 months, my lord. Till 13/8/2020, he was there in judicial custody on the different.
13/8?
13/8/2020.
20 ಆಯ್ತು.
Yes. After that, he was released on the mail. He was not aware the present case and is regularly attending.
ಆಯ್ತು, ಈಗೇನಾಯ್ತು? ಈಗ ಏನಾರು
Now the whole thing is-
ಇದೇನಾರು ಇದಾಗಿದೆಯಾ? ಪ್ರೊಕ್ಲಮೇಶನ್ ಆಗಿದೆಯಾ?
No, my lord. Only NPW has been issued. The charge sheet is order sheet is produced.
ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವಾಗ ಫೈಲ್ ಆಗಿದ್ದು?
Charge sheet was filed on 19/2/2000. Page number, my lord. 19/2/2020, there is a signature of the magistrate. On that particular day, he was there in the judicial custody.
He was
There in the judicial custody of the initial where he was arrested.
Charge sheet filed on what day?
19/2/2020.
20.
Yes, my lord.
Oh, when he was in custody.
Yes, my lord.
Again,
My lord, petition approached the sessions court also. The petition was rejected by saying that when the charge sheet has been filed, the 438 is not maintained. In view of the Venkatachala and others from state of Karnataka and others, lordship also being considered petition number.
only absconding ಇದ್ರೆ ಮಾತ್ರ ಬರಲ್ಲ ಅಂತ. Absconding ಇದ್ರೆ ಮಾತ್ರ ಬರಲ್ಲ. even charge sheet file ಮಾಡಿದ್ಮೇಲೆ 438 can be filed.
Wakalat was not entered.
ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಮತ್ತೆ ಬರಲ್ಲ.
No, 438 is not maintained.
ಬೇರೆ ಏನಾದ್ರು ಕೇಸ್ ಇದಾವನ್ರಿ ಇವನ್ ಮೇಲೆ? ಎಷ್ಟಿದಾವೆ?
5 ಇದೆ. My lord, ಇದು ಸೇರ್ಸಿ 6.
ಇದ್ರಲ್ಲಿ ರಿಕವರಿ ಅರ್ಧ ಚೈನ್ ಇದೆ, ರಿಕವರಿ ಆಯ್ತಾ?
ಇವನ್ ಕಡೆಯಿಂದ ರಿಕವರಿ
ಯಾರ ಕಡೆಯಿಂದ?
ಅಮೌಂಟ್ ಮಾರ್ಬಿಟ್ಟಿದೆ ಅಂತ ಹೇಳಿ ರಿಕವರಿ.
ಬೇರೆಯವನ್ ಕಡೆಯಿಂದನಾ?
My lord, in view of the
ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಒಂದ್ ನಿಮಿಷ. ಯಾರ ಕಡೆಯಿಂದ ರಿಕವರಿ ಆಗಿದೆ? ರಿಕವರಿ
ಮಾರಾಟ ಮಾಡಿರ್ತಾರೆ,
ಇವ್ರ ಕಡೆಯಿಂದ
ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ರೆ
ಇವನೇ ಯಾವಾಗ ಸಿಗ್ತ? 438 ಅಲ್ವಾ ಇದು? 439
7ಗೆ ಕರ್ಕೊಂಡು
438 ಇದು
body warrant.
ಪೊಲೀಸ್ ಅವರು ಬಂದಲ್ಲಿದ್ದ ಆರೋಪಿ
ಇವ್ರ ಕಡೆಯಿಂದ ರಿಕವರಿ ಹೆಂಗಾಗುತ್ತೆ? 438 ಇದೆ ಇದು. ಇದ್ರದ್ದು ನಾನ್ ಕೇಳ್ತಾರದು ಈ ಕೇಸಲ್ಲಿ ಅರ್ಧ ಚೈನ್ ಕಿತ್ಕೊಂಡು ಹೋದ್ರಲ್ಲ, ಅದು ರಿಕವರಿ ಆಗಿದೆಯಾ? ಬೇರೆದ್ ಯಾವ್ದು ಬಿಟ್ಬಿಡಿ, ಈ ಕೇಸಲ್ಲಿ ಆಗಿದೆಯಾ ಅಂದೆ.
My lord, in view of the section 2 of the Habitual Offender Act, he has to be convicted at least 3 times in the last period of 5 years. I have already.
And also there are judgments of Supreme Court has to see the antecedents of an accused.
My lord, before registration of
Habitual offender ಅದು ಬೇರೆ.
before registration of this case, there is no other case also. My lordship is very clear. Once a person is been arrested.
ಇದಲ್ದಲ್ಲ ಬೇರೆ ಕೇಸ್ ಆರಿದಾವೆ ಅಂತ.
No, my lord, let them produce because we have already mentioned all the cases.
ನಿಮ್ ಪ್ರಕಾರ ಪೊಲೀಸ್ ಕಸ್ಟಡಿ ಇದ್ನಲ್ಲ ಅವನು.
No, there are 4 cases. When they are taken on body warrant, I have all the list of the cases. I have already mentioned in the petition also. What and all the cases is pending. Other than that,
ಎಷ್ಟು ಕೇಸ್ ಇದೆ ಅಂತ?
there are 4 cases, including the present case.
ಹೌದು.
ಆಯ್ತು, ಇವ್ನು ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾಗ ನೀವು ಅಬ್ಸ್ಕಾಂಡೆಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ ತೋರಿಸಿ ಹಾಕಿದ್ರಿ. ಈಗ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ, ಹೌದಾ? ವಾರೆಂಟ್ ಇನ್ನೂ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿಲ್ಲ. ವಾರೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇದೆ, ಪ್ರೊಕ್ಲಮೇಶನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಹೌದಾ? What the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that this petitioner, who has been arraigned as accused number 1, along with accused number 2, on 17/5/2019 at 5 p.m. in between 5 to 5:15 p.m. came in the two-wheeler, and when CW1 was proceeding in front of the house of 236/16, A2 accused was driving the vehicle and came from backside and snatched the chain. And accused number 1 caused the injuries, and half of the chain was broken and remaining half was with the CW1, and the same is worth of rupees 1,10,000. And hence case has been registered against the unknown persons at the first instance, and thereafter initiated the matter and filed the charge sheet. The counsel appearing for the petitioner would submit that the incident was taken place according to the prosecution on 17/5/2019, and this petitioner was in custody from 21/6/2019 in another case, and he was in custody from 21/6/2019 to 13/8/2020. And in the meanwhile, charge sheet was filed on 19/2/2020, showing this petitioner is absconding. And subsequently, non-bailable warrant was issued against the petitioner, and this petitioner was not aware of he has been arraigned as an accused. The counsel also submit that The trial court has dismissed the bail application only on the ground that charge sheet already been filed and not entitled for anticipated bail. Per contra, the counsel appearing for the state would submit that chain was snatched. And there are other 4 cases against this petitioner. And he is an habitual offender and his presence is required. But ಏನಾಗಿದೆ chain ವಾಪಸ್ recovery ಆಗಿದೆ ಇಲ್ಲ ಯಾರ ಕಡೆ
JP Nagar police, my lord, in their plan number they have recorded. Actually, they have to transfer it to the BM. Then these people have to do
ಈ ಅರ್ಧ chain ಬೇರೆ ಕಡೆ recovery ಆಗಿದೆ ಬೇರೆ claim.
JP Nagar, when they are initially they arrested, time they are recovered. And they are
ಆವಾಗ ಇದನ್ನು recovery ಆಗಿದೆ.
they are released also to the complainant.
Habitual offender and his presence is required and he would commit the similar offence if he has been released on bail. Having heard the respective counsel and also on perusal of material and also taking into note of incident was taken place on 17/5/2019. Apart from that, he was in custody from 21/6/2019 to 13/8/2020. And in the meanwhile, charge sheet was filed. And no summons was served on him after filing of the charge sheet and a non-bailable warrant was issued. And mere filing of charge sheet itself is not a ground to reject the bail petition. The court has to take note of the accusation made in the complaint as well as the recovery already made in connection with other criminal case. So the other criminal case, and when judging the case, whether this petitioner had indulged in such act is a matter of trial, and this petitioner can be enlarged on bail with conditions to appear before the trial judge without seeking any exemption, and if the petitioner indulge in committing of similar offence, then the state can approach this court for cancellation of in view of the discussions made up by pass the following order. Bail petition is rejected. A condition on that in case similar offence if he commits. Remaining matters at 2:30.
With Malad's permission, may I mention item 86?
86, 1 second. 86. Yes, counsel.
This is a matter, Malad, on first. Malad had noted our request that we want to go for mediation, and
Yes.
the complainant was permitted to move an IA to implead himself. Now that IA is on record, but it is under objections, Malad. So if Malad, subject to them removing the objections, if the matter could be referred to mediation, they are present.
You are appearing for the de facto complainant. What are the objections? Office objection raised on IA2 for assist the prosecution and objections filed by the advocate only. Objections and the application. Already they have served the copy.
No, Willis, we have not received the copy. I have talked to my
Not
local
received the
counsel.
copy. Then who have filed the objections? Office objection raised on IA2/22 for assist the
So
prosecution.
they have filed the complainant has filed.
Objections filed by the advocate for complainant along with IA. Office objections are there. Why you are not complied with? Whether counsel on behalf of you any local advocate.
Willis, Mr. Vinay is there.
Office objections here, madam. Only.
Mr. Vinay Kuttappa is there, Malad.
Yes. He is present before the court.
He's one.
Only is not serve the copy in Tana. Affidavit ಹಾಕಿದಿರಾ ಯಾವಾಗ day before yesterday ತರ್ಸ್ಕೊಳ್ಳಿ ನೋಡಿ ಇದ್ರೆ ಹಾಕಿದ್ರೆ ಆಯ್ತಾ only that is affidavit ಹಾಕಿಲ್ಲ ಅಂತನಾ the counsel appearing for the de facto complainant submits that he has filed the affidavit day before yesterday and hence office is directed to put up the same, and also now the copy of the application is served on the counsel on record. Are you going to file any objections or
No, Malad, we don't
only
want to file.
limited scope. I will allow the application with limited scope.
Malad, in fact, if Malad will remember, I said after Jagjeet Singh Malad, it's up to Malad to allow or
Anyhow,
disallow.
now I will allow the application to assist
Yes.
the
Certainly, Malad.
CGP. That's all.
Please.
Heard the respective counsel and also peruse the application and the reasons assigned in the affidavit. Hello, madam. Affidavit and ತರ್ಸ್ಕೊಳ್ಳಿ. Affidavit and the de facto complainant is permitted to assist the prosecution as sought in the application. The matter is also referred to mediation, and both the complainant as well as the petitioner appear before the mediation on what date?
Malad may have it for any date, 7th, 11th, because Malad, my humble view is this: Malad knows that mediation will not happen in a day.
Counsel, I will refer the matter to the 7th or 8th.
7th, 8th, anything, Malad.
7th, okay. Both appear before the mediators. Agboda.
Malad, I had only one request. Malad, while the complainant has been good enough to come forward to try and settle the matter with us, since her counsel is present in court, I'm making a statement at the bar. Every day the police is visiting the house to arrest me, obviously. So, Malad, in case their intention is also bona fide, Malad, I'm requesting that only for the limited purpose.
Not to precipitate till 7th of Madi. 7th, no, we will consider it. Matter is referred to the mediation and both directed to appear before the mediation center on 7th at 2:30. 2:30, better that is better 2:30. Aita, papers in only petitioner 4:38. Bekagilla. Why? Ato kalsadar kalsbudi. The registry is directed to send the copies of the petition to the mediation center.
And Malad ordered them not to
precipitate this matter on Monday.
Right, Malad.
Monday 11th.
Right. Malad have asked them not to precipitate the matter.
Already I have given instructions to the HCGP that he would inform the concerned police not to precipitate. To hear you. Petitioner counsel seeks permission of this court to withdraw the petition on the ground that charge sheet already filed and going to and liberty may be given to approach the trial court. So that and hence permitted to withdraw with liberty. Petitioner counsel seeks time list this matter on 11th. Shall
ಸಂದೇಶ ನಿಮ್ದು ಬಂದಿಲ್ಲ ಮಾಡಿ ಚಲೋ
ಅಶೋಕ್ ಪ್ಲೀಸ್. ಇಲ್ಲ ನಾ ಅಮಿತ್ ಕೇಳಿಸ್ತಾ ಇದಲ್ಲ.
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಎಷ್ಟನೇದೈತಿ ನಿಮ್ದು?
ಕೇಳ್ತಾ ಇದೆ.
ಸರಿ, ನಾನು ಇವತ್ತು ಸರ್
ಸೌಂಡ್ ಬರ್ತಾ ಇದೆ, ನಾನೇನ ಇಲ್ಲ
ಸರ್ ಕೋರ್ಟಾಲಕ್ ಬರುತ್ತೆ. ಇದು ಮಾಡ್ಯಾರ ಸರ್, ನೀವು ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕರೀರಿ ಸರ್, ಗೊತ್ತಾಗುತ್ತೆ. ಫೈಲ್ ಹಾಕಿ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿ
ಮಾಡಿ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲಲ್ಲ.
ಮಾಡ್ತೀನಿ. ಆಯ್ತು.
ಕಲಬುರ್ಗಿ 230 ಅಂತ ಹಾಕಿದ್ದೀವಿ. ಅದು ತಗೋಬಿಡಿ.
Permission, serial number 18. It was posted for settlement, password ಆಗಿತ್ತು. This honorable court had asked the presence of respondent so that when he joined, respondent is present. However, the petitioner's mother is unwell, so his advocate just requested me to. I will take the signature of the respondent, my lord, next person.
ಬೇಕಾಗಿಲ್ಲ, ಬಟ್ ಪ್ರೆಸೆನ್ಸ್ ಇರ್ಬೇಕಲ್ಲ both. ನೀವು next time you keep present. Respondent counsel submits that petitioner counsel mother is not keeping well. Petitioner's mother. Petitioner's mother is not well and hence could not keep the parties present before the court to file the joint memo. Hence it's time. Now, when do you want? 7th. This matter on 7th. Ashok, this counsel.
This is petition section 439 of CH.
Successive bail petition.
Yes, please, Lord. Earlier 438 petition. He has arrested. He has been arrested, and since 7/2/2022, he is in judicial custody. Earlier was 438.
Earlier it was 438 or 439.
438.
438.
Yes, please.
Yes. Now scope is different.
Yes, please.
Yes, counsel. What are the grounds?
As far as the after rejection of the order by this honorable court, and the petitioner has also approached before the apex court also, he has not succeeded, and he has surrendered before the police also. Since from 7/2/2022, he is in JC.
Where is the earlier order? Where is the earlier order passed by this court?
At case number 119. 119 in criminal petition number 201414/21.
119. Earlier order under section 438.
Yes, please.
Thereafter went to the Supreme Court also. Supreme Court also not granted anticipatory bail.
Yes, please.
Now he has been arrested.
Arrested, my lord. 7/2/2022, he is in JC.
Paragraph number 7. Earlier.
Yes, please.
Observation.
Yes, please.
ಇಲ್ಲ ಸರ್, ಸೌಂಡ್ ಬರ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಮಾತ್ರ ಮೊಬೈಲ್ ಚಾಲು ಮಾಡಿ ಸರ್. In my case, the complaint is present, sir. The victim there, CR.
Yes, now scope is 439.
Yes. So the offences 204, 409, 420, that will 34. These all offences are triable by magistrate court. Accused 2 and 3 have been enlarged and anticipatory bail by this honorable court. But the petitioner has cooperated with the investigation and charge sheet is filed. He has also suffering with gangrene. Gangrene.
Any documents are placed before the court?
Yes, my lord, sir. Not only that, stunt has been also 2 stunts have been prior to surrendering itself. In jail also, he is very much suffering with that leg. That is probably the doctor has allowed to remove one of the leg. That serious consequences as far as the leg is concerned.
Where is the charge sheet now?
Charge sheet, yes, page number 26.
26.
Yes, please, no. Column number 17 is at page number 29.
It's on the page number 29 and 30.
Yes, my lord. So column number 17. May I?
Yes,
Please.
read.
ಮಾನ್ಯರವರು ನಿವೇದಿಸಿಕೊಂಡಿದ್ದಾರೆ ಘನ ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಯ ಬಿ-ಗುಡಿ ಪೊಲೀಸ್ ಠಾಣೆಯ ಸರಹದ್ದಿಯ ಪೈಕಿ ಸರ್ಕಾರಿ ಪ್ರೌಢಶಾಲೆ 2015-19 ಅವಧಿಯಲ್ಲಿ ಈ ಕುಶಲ ಪತ್ರ ಕಾಲಂ 12 ನಮೂದಿಸಿದ ಆರೋಪಿ ನಂಬರ್ 4ನೇದವರು ಅನಧಿಕೃತವಾಗಿ ಗೈರು ಹಾಜರಾಗಿದ್ದು ಈ ಅವಧಿಯಲ್ಲಿ ಅವರು ಗೈರು ಹಾಜರಾಗಿದ್ದು ತಿಳಿದು ಅವರಿಗೆ ವೇತನ ಮಂಜೂರು ಮಾಡಿಸಿ ಅವರಿಗೆ ಮತ್ತು ತನಗೆ ಅನುಕೂಲ ಮಾಡಿಕೊಳ್ಳುವ ಉದ್ದೇಶದಿಂದ ಆರೋಪಿ ನಂಬರ್ 1ನೇದವರು ಅವರ ವೇತನದ ಮಂಜೂರಾತಿಗೆ ಹೆಚ್ಚುವರಿ ಬಿಲ್ಗಳನ್ನು ತಯಾರಿಸಿ STOಗೆ ಸಲ್ಲಿಸಿ ಬಿಲ್ಲಿನ ಹಣ ರೂಪಾಯಿ 9.19 ಲಕ್ಷ ರೂಪಾಯಿ ಹಣವನ್ನು ಮಂಜೂರು ಮಾಡಿಕೊಂಡು ಅದರಲ್ಲಿ 8.24 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಆರೋಪಿ ನಂಬರ್ 4ನೇದವರ ಖಾತೆಗೆ ಜಮಾ ಮಾಡಿ ಇನ್ನುಳಿದ ಹಣವನ್ನು ಅದರ PF ನಂಬರ್ 4/2022 ಕ್ರಮ ಸಂಖ್ಯೆ 1 ರಿಂದ 3ನೇದವರೆಗಿನ ಆರೋಪಿ ನಂಬರ್ 4ನೇದವರ ವೇತನದ ಹಣ STO ಅವರಿಂದ ಮಂಜೂರು ಆಗಿ ಬಂದ ನಂತರ PF ನಂಬರ್ 10/22 ನಮೂದಿಸಿದ 11 ಕ್ರಮ ಸಂಖ್ಯೆ 11, 12, 13, 14ನೇದವುಗಳನ್ನು ಆರೋಪಿನ 4ನೇದವರ ಹೆಸರು ಮತ್ತು ಬ್ಯಾಂಕ್ ಖಾತೆ ನಂಬರ್ ಅನ್ನು
Now amount is 24,548 is stated by him.
Headmaster, he misused his official capacity.
Investigation ಆಯ್ತು ಒಳಗಿದಾನೆ ಆಯ್ತು ಎಲ್ಲ ಮುಗಿತು ಆಯ್ತು heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner being the headmaster had indulged in misappropriating the amount, and in total amount of rupees 9,19 lakhs, 8,24 lakhs was transferred to the account of accused number 4. Remaining amount was got it transferred to his account, that is 5 months salary to the tune of rupees 94,548, and committed an offence of criminal breach of trust, and hence invoke the offence punishment 409, 420, regulation 34 of IPC. The counsel appearing to the petitioner would vehemently contend that accused number 2 and 3 already granted bail invoking section 438 of CRPC, and subsequently, and this petitioner also approached this court by filing a petition under section 438 of CRPC, and the same is rejected by this court by order dated 10th day of November 2021, criminal petition number 201414 of 2021. The petitioner also has approached the apex court also rejected the same. Now the petitioner was taken to custody, and investigation is also conducted, and this petitioner cooperated with the IO for the investigation of the matter and filed the charge sheet. The counsel would submit that the allegation is with regard to using of salary amount of the other employee to the tune of rupees 94,548, and the same is got it transferred to his account and misappropriated the same. The investigation has already been completed, and the records are also collected by the IO during the course of investigation, and no need of further custodial investigation. For counter, the counsel appearing for the state would submit that the petitioner being the headmaster of the institution, he himself indulged in committing criminal breach of trust and also committed fraud on the institution, and hence this court earlier rejected while exercising the powers of 438 of CRPC and not entitled for bail. Having heard the respective counsel and also on perusal of material available on record, particularly specific allegation against this petitioner is that he had indulged in committing an offence of criminal breach of trust and misused the amount and committed fraud against the government. And this court no doubt earlier rejected the petition under section 438 of CRPC, and thereafter he had also approached the apex court. The apex court also rejected the same. However, the petitioner appeared before the IO, and during the course of investigation of the concerned relevant documents for having committed an offence of criminal breach of trust, secured the records, and the investigation has been completed and charge sheet is also filed, and hence taking into note of the accusation made in the charge sheet as well as the offense of committing criminal breach of trust. The same is triable by magistrate and not punishable with death or imprisonment for life, and further custodial trial is not required, and hence it may be enlarged on bail with conditions.
Please.
Excuse me, I want 2 days time. There was direction to conclude trial. I will ascertain and submit.
After the trial, they have come up before the court.
3 ತಿಂಗಳಲ್ಲಿ ಮುಗಿಸ್ಬೇಕು ಅಂತಿತ್ತು. ಅದೇನ ಇನ್ನು ಕನ್ಕ್ಲೂಡ್ ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಮತ್ತೆ ಹಾಕಿ.
ಏನ್ರಿ ಆಗಿದೆಯಾ ಟ್ರಯಲ್ ಅಥವಾ ಇಲ್ವಾ? ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
This is a success.
ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಏನು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ.
ಅಫೆನ್ಸ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ. And complainant
ಅವ್ರ ಪ್ರಕಾರ ಆಗಿಲ್ಲ ಅಂತ. ಆಯ್ತು, HCP 2 days time to verify whether trial has been commenced or not. Else this matter on. Sorry madam, ಯಾವತ್ತು? 11th at 2:30. Next week 11th at 2:30. Sorry madam, 2:30 ಯಾವ್ದು ಇಟ್ಕೊಂಡ್ವಲ್ಲ ತಗೊಳ್ಳಿ 15.
Lordship said someone the service record of ADGP and I think an SP. Ali secretary ಅವರು
not SP. I sought only the ADGP.
They thought both of them. Anyway, but now what they have said is they have given the list of where he was posting. But service record I'm told is the accountant general. But I have asked them to inform the accountant general before Lordship's price. It will be available. Let's inform that. ಇವ್ರ ಕಡೆ DPR ಅವ್ರ ಕಡೆ ಇರೋದಿಲ್ಲ. What they have is only
DPR ಮೇಂಟೈನ್ ಮಾಡೋದಲ್ಲ, ಯಾರು ಪೋಸ್ಟಿಂಗ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಒಬ್ಬ ಆಫೀಸರ್ಗೆ ಪೋಸ್ಟಿಂಗ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಎಲ್ಲ ನೋಡೋದಲ್ಲ ಯಾರು? DPR ಒಂದೇ ನೋಡೋದು. ಮತ್ತೆ
ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ ಅವ್ರದೆಲ್ಲ confidential remarks, all that is accountant general. So they will summon, they'll get it. By 4 PM we'll produce.
What about deputy commissioner? Deputy commissioner.
This is what they have.
Deputy commissioner. I summoned the document of appointment of A2. On what date he was appointed?
A2 is private person.
A2 is a private contract person appointed by deputy commissioner. ದುಡ್ಡು ರಿಸೀವ್ ಮಾಡ್ದವನ ಯಾರ್ರಿ? ಪ್ರೈವೇಟ್ ಪರ್ಸನ್ ದುಡ್ಡು ರಿಸೀವ್ ಮಾಡ್ದವನ ಯಾರು? ಅವನೇ ತಾನೆ. Where is the order? Where is the order of appointment? Okay. How he can come and collect an amount on behalf of the deputy commissioner?
ಇರ್ಬೇಕು ನೋಡು, ನಾನು ಹಂಗೆ ಓಪನ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದೆ ಆ ಕೆಳಗಡೆ.
What is going on? AG?
ಅಲ್ಲ ನಾನು ಬೆಳಿಗ್ಗೆ ನನಗೆ we are also greatly pained, lords, and we want to share this with your lords. ತಮ್ಮ ಒಂದ್ ನಿಮಿಷ please.
How a private person can come and collect an amount of ₹5 lakhs on behalf of the deputy commissioner?
Private secretary.
No. Private secretary is different. I will tell you what had happened.
Yes.
The complainant against appeal is filed before the assistant commissioner of police. Assistant commissioner of police passed an order in favor of the complainant because someone claimed the property of the complainant. Aita, that was dismissed. Against that order, an appeal is filed before the deputy commissioner. Deputy commissioner heard the matter and reserved the matter on 30/3/2022. He has not passed an order. Then complainant has approached the deputy commissioner. The deputy commissioner in turn, what I am making all records.
I know, understand. No, I understand.
Records of not ACB.
Yes.
When he goes with him and discuss with the case, he recollect the memory of one person. Respondent number 3 is Biresh, and also his father name or someone's name is someone else. Oh, case. Then he says he go and meet the personal assistant of the deputy commissioner, and also come and see tomorrow the complainant. And then he go to the personal assistant of the deputy commissioner, that who is an accused number 1, who is the present before the petitioner. He bargains with from 15 lakhs to 5 lakhs rupees. ಅವನ ಹೆಸರಿನಲ್ಲ ಚೀಟಿನಲ್ಲ ಅವನ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಲ್ಲ ಇದೆ. ಅದು 15 ಲಕ್ಷದಿಂದ 3 ಲಕ್ಷಕ್ಕೆ ಬಂತು, ಎಲ್ಲ ನಡೀತು. ಆಮೇಲೆ ಆಯ್ತು ದುಡ್ಡು ಕಲೆಕ್ಷನ್ಗೆ ದಿಸ್ ಮ್ಯಾನ್
Private person.
Private person. How a private person can access the office of DC? And also A2 says, A1 says, go and make the payment with this man, Chandu or alias Chetan Kumar. I read each point. Each point I have read. And then that is one thing. Second thing is the case worker is one Sandeep of the deputy commissioner. While this was recorded in the mobile. And also he says, party barli bido, namen madbaku. Party bandmel nodana. Yavat barli nadi. Ee tarad conversation was also recorded in the phone. Then this man went and collected the amount as per the instruction of accused number 1. An amount of rupees 5 lakhs. 2,000 ರೂಪಾಯಿ ನೋಟು 200. 500 ರೂಪಾಯಿದು 200 ನೋಟು. Along with details, he was red-handedly apprehended. But case not registered against the deputy commissioner. But they bring only the personal assistant and this man, private person. How he can access, how he can collect an amount of rupees 5 lakhs without the role of a deputy commissioner. And what they say is, when this court noticed all these things, then arrest the deputy commissioner as accused number 3. Serious matter.
No, of course.
And then they have issued a notice, cognizable offense under section 7A. Issued a notice under section 41A and facilitated him to approach this court. But this court rejected the bail petition, the petition filed under section 482 for quashing of 41A. Then he had approached the court by filing a petition 482, quashing of arraying him as an accused. That is also not granted any relief. Why all these things are going on?
This can't be viewed so lightly. And Lordship's observations, they told
I minutely
take it towards the right spirit.
I minutely. That is one thing.
Now, I'll be with your Lordships for all records. I told whatever is there, I want to make a statement before whatever Lordships will summon, will produce. I told ADCP has come, I have called. I've told Manmohan, I think they have some of you should not hold back anything from the court.
Other day I dictated orders to summoning up documents. He intervened and he only undertaken that he will produce the same. Now he comes and says that the matter is before the division bench.
No, but what is correct? Division bench is of the ACB.
I want to
Validity of the argument, judgment has been reserved. Only one sentence I want. For one is concerned, I must vote for him. He's one of the finest counsels.
That's why I told him, you are the future of this institution.
I will not no longer appear for ACB.
Because this very object in
definitely
bringing we have to see the object in bringing the enactment of Prevention of Corruption Act. But when these people are protecting such officers,
no question. It should not happen. Now, Lords, we will completely assist your Lordship. Every bit of record relating to ACB will be placed before your Lordship. Lordship may record my statement. Advocate General records. We will ensure that all things come. Number one.
I to produce because when as officer, he is also a part of this institution. Officer, when he makes the submission before the court, they are going to produce. And also he says, how he told
he has not.
That's why I said, you are wearing black coat. Don't do that.
Lordship may not remark against the council. Papa, we are all together. Now, ultimately, we have no personal interest. Anyway, Lord, I do not want
personal interest. Non-personal
Yes.
Stage cancer ಒಂದು ಎರಡನೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಎರಡನೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ. ನಾಲ್ಕನೇ ಸ್ಟೇಜ್ ಗೆ ಬಿಟ್ರೆ ಇದು ಹೋಲ್ ಸೊಸೈಟಿ ಹೋಲ್ ಸೊಸೈಟಿಗೆ ಆವರಿಸ್ಕೊಬಿಡ್ತದೆ.
Will be with your Lordships. Will be with your Lordships. Entire B reports, every record will be placed before your Lordships. ನಮ್ಮಿಂದ ಆ ರೆಸಿಸ್ಟೆನ್ಸ್ ಬರುತ್ತೆ ಸರ್. Otherwise, Lordships, whatever on merits, Lordships, whatever Lordships needs to pass an order,
we'll accept it on the appeal application, but we have nothing to say.
Only we are concerned about the public.
Certainly, certainly.
When the object is to
Tama anxiety, I appreciate the anxiety, but we are
corruption.
in fact.
That's why I have taken pain also. I only served all these judgments also because he had mentioned other day that nan kannu muchkondu bari bail application order baribeku anta avaru helidru. Adike
No, it is not about that. It is ultimately concern of.
That is not the role of a constitutional court. High Court and Supreme Court has got powers in order to secure the ends of justice. Court can summon any of the documents.
But Lordships are aware. We are.
That's why
I only can say. No, one statement. We will salute Lordships' concern and anxiety for anti-corruption. We will be with your Lordships. But one statement, only administration, government, ACB, all of us will be with your Lordships, aiding Lordships. For a moment, Lordships do not think we are representing. Anything more, we will submit.
I think service records ಎಷ್ಟೊತ್ತಿಗೆ ಬರ್ತದೆ 4:30 ಒಳಗೆ ಬರುತ್ತಾ 4:45 ಒಳಗೆ 4:30 where is the DPR secretary under secretary ಆಯ್ತು ಪರವಾಗಿಲ್ಲ ಯಾರಾದ್ರೂ ಹೋಗ್ಲಿ let the material be placed before the court. I never insist for higher officers to come before the court. I never insist for the only to assist the court, that's all.
He'll come anyway. He's here only. But I think he went to call up that accountant general. Nane kalsde immediately kalsbitu. Tanni 4:30. It will be placed before 4 p.m. It will be placed. Court officer ಕೊಟ್ಟು ಅಥವಾ ತಮಗೆ ಕೊಟ್ಟು will mention and.
ಅಲ್ಲ court officer ಕೊಡ್ಲಿ ನಾನು ಇಲ್ಲಿ sit up to 4:45. ಬೇರೆ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಏನ್ರಿ ಮನೋಹರ್ ಮತ್ತೆ ಚಾರ್ಟ್ ಏನ್ರಿ ಚಾರ್ಟ್ ಇನ್ನೊಂದ್ ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆಯೋ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಬಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ರೆಡ್ ಹ್ಯಾಂಡ್ ಆಗಿ ಹಿಡಿದವ್ರನ್ನು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿ ಬಿಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ ಏನ್ರಿ ಇದೆಲ್ಲ ಇಟ್ ಶೋಸ್ ದಟ್ ದಿ ಬೇಲಿನೇ ಹೊಲ ಮೇಯೋದು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅದು. ಅಷ್ಟೇ ಅಲ್ಲ ಇನ್ನೂ ಹೇಳ್ತೀನಿ ಸರ್ಚ್ ವಾರೆಂಟ್ ಗಳು ತಗೊಂಡವ್ರೆ ಸರ್ಚ್ ಮಾಡೋದಿಲ್ಲ. ಸರ್ಚ್ ವಾರೆಂಟ್ ತಗೊಳ್ತಾರೆ ಸರ್ಚ್ ವಾರೆಂಟ್ ಮಾಡೋದಿಲ್ಲ. ಸರ್ಚ್ ವಾರೆಂಟ್ ನ ತೋರಿಸಿ
I understand. ಹೇಳ್ತಾರದು ಅರ್ಥ ಆಗ್ತದೆ.
Once the court has granted permission to make search warrant, why they have not conducted the search?
That should not happen. How can that? It is something which is.
It shows that.
Search warrant issue madana. How can this?
How an office private person can come and in DC office can collect 5 lakh rupees?
I'm told that this undersecretary has gone to accountant general's office.
Let him come at 4:30 but place the documents.
Records
ಯಾವಾಗ ಕೊಡ್ತಾರೆ ಕೇಳಿ ಅವರಿಗೆ ಕೇಳ್ಬಿಡಿ. ನಾನು 5 ದಿವಸ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಮೊನ್ನೆ ಎಲ್ಲ ಏನೇನ್ ಸಂಬಂಧ ಮಾಡಿದೆ not only B reports.
ಏನೇನ್ B reports and
ಆಯ್ತು ಸರ್ಚ್ ವಾರೆಂಟ್ ತಗೊಂಡಿದ್ರಲ್ಲ ಎಷ್ಟರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದಿರಿ ಆಯ್ತಾ ಇದು ಏನು B ರಿಪೋರ್ಟ್ ಎಷ್ಟರಲ್ಲಿ ಹಾಕಿದಿರಿ ಬಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲ ಅದರಲ್ಲೂ ಕಲೆಕ್ಷನ್ ಮಾಡಿ ರಿಕವರಿ ಮಾಡಿದಾಗ ಅದನ್ನ ಹೆಂಗೆ ನೀವು ಬಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಇಸ್ ಇಟ್ ನಾಟ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್? ನೀವೇ ಹೇಳ್ಬಿಡಿ ಅವ್ರು ಯಾಕೆಂದ್ರೆ ನಾನೀಗ ಮನ್ಮೋಹನ್ ನಂಬಂಗಿಲ್ಲ because he came out ಇಲ್ಲ ನಾನು when I dictated the order he intervened at the instance of the IO and he has given an undertaking and now he ಹೇಳಿದ turned hostile ಅಂತ
ACB ಅವ್ರು ಬಂದಾಗ ನಾನೇ ಮಾಡಿ ಬಿಸಿ ಇನ್ ಸಿವಿಲ್ ವರ್ಕ್ ಇಲ್ಲ ಇದು ಪಬ್ಲಿಕ್ ಸರ್ವಿಸ್ ಪ್ಲೀಸ್ ಅಪಿಯರ್. Very difficult. It's very sensitive.
ಇದೊಂದೇ ಮ್ಯಾಟರ್ ಅಲ್ಲ ACB ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆಯೋ ಗೊತ್ತಿಲ್ಲ. ಮತ್ತೆ ಇನ್ನೊಂದು ಅರವಿಂದ್ ಜಾಧವ್ ಕೇಸಲ್ಲಿ 66 ಎಕರೆ ಲ್ಯಾಂಡ್ ಫಾರ್ಮರ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಮಾಡಿದ್ರು. ನಾನೇ ಅವ್ರಿಗೆ ಮಾನಿಟರ್ ಮಾಡಿ ಆಕ್ಚುಲಿ ಅದು ಕೇಸು ಹಿಂಗೇನೆ ಏನ್ ಮಾಡಿದ್ರು ಗೊತ್ತಾ? ಅರವಿಂದ್ ಜಾಧವ್ ತಾಲೂಕ್ ಆಫೀಸಲ್ಲಿ ಅವನ ಪಾಪ ಮನೆಯವನು ಇರ್ತಾನಲ್ಲ ಅವ್ನು ಕಂಪ್ಲೇಂಟ್ 2016 2016 ಇಂದ ಏನು ಮಾಡಿರ್ಲಿಲ್ಲ. ಯಾವ್ದೋ ಒಬ್ಬನ್ ಕೇಸ್ ತಳದಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ ಯಾರೋ ಕೂತಿರ್ತಾನಲ್ಲ ತಾಲೂಕ್ ಆಫೀಸರ್ ಅವ್ನು ಮಾತ್ರ ಕೇಸ್ ಮಾಡಿರ. ದಟ್ ಮ್ಯಾನ್ ಕೇಮ್ ಟು ಕೋರ್ಟ್ ಫಾರ್ ಕ್ವಾಶಿಂಗ್ ಆಫ್ ದಿ ಅದರಲ್ಲಿ ನಾನೇ ಮಾನಿಟರ್ ಮಾಡಿ ಐ ಸೆಡ್ ಇಟ್ ಈಸ್ ದಿ ಡ್ಯೂಟಿ ಆಫ್ ದಿ ಸ್ಟೇಟ್ ಟು ಪ್ರೊಟೆಕ್ಟ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ದಿ ಸ್ಟೇಟ್. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ದಟ್ ಆಲ್ಮೋಸ್ಟ್ 1.5 year ಇಂದ ಮಾನಿಟರ್ ಮಾಡಿದ್ಮೇಲೆ ಈಗ ಫಾರ್ಮರ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ's mother, the property stands in the name of former chief secretary, deputy commissioner, assistant commissioner, ಇವರೆಲ್ಲ ಈಗ ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಮೊನ್ನೆ ಸೆಂಡಿಂಗ್
After Lordship's intervention.
This court can monitor.
Correct.
This court can monitor when there is a state property is
Lordship, I won't say ಬೇಜಾರ್ ತಾವು ಮನಸ್ಸಿಗೆ ನೋಯಿಸ್ಕೋಬೇಡಿ. We will get hurt. Ultimately, Lordships with so much of strain try to do justice from morning to evening. I have seen what is judge's life. But ತಮಗ್ ನೋವು ಆದ್ರೆ ನಮಗೆಲ್ಲ ನೋವಾಗುತ್ತೆ. ತಾವು ದಯವಿಟ್ಟು take it notes. We will ensure that we will assist you. Only for that reason I'm making this. Because I feel not I'm an officer of the court. We are like family. ತಮಗ್ ಮನಸ್ಸಿಗೆ ನೋವಾದ್ರೆ ನಮಗೇನು ಖುಷಿ ಆಗೋಲ್ಲ. Because Lordships and we are ultimately cooperating for dispensing justice.
ಅದ್ರ ಜೊತೆಗೆ ಒಂದು ಇಂಡೈರೆಕ್ಟ್ ಥ್ರೆಟ್ ಬರ ನಮಗೆ.
All these things, yes, very, very unfortunate, I would say. But that's
why it is my duty to see that independence of judiciary has to be protected.
Of course, certainly.
I am not identified with any political party. Judge should not have the ideology of any political party. Judge should affiliated to only the constitution.
I have seen a judge's life from the, but I need not elaborate from how it is. What is a judge's life? I will deeply respect lots of feelings and sentiments. We will provide everything. Lots of a service report, whatever it is there.
Let them place it
before. In matter, lots of hear words. I do not want to intervene. Main application, bail application.
ಅಲ್ಲ ಬರ್ಲಿ ಅದು ಬರ್ಲಿ ಈಗ ಅದಕ್ಕೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅವ್ರೊಂದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನು ಅಂದ್ರೆ ಈ ಫೈಲ್ ಇಟ್ಕೊಳಕ್ ಬರಲ್ಲ. ಅವ್ರೊಂದು 2020 ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಎಲ್ಲ I will consider together. Nothing will happen. ಒಂದ್ ದಿವಸದಲ್ಲಿ ಏನ್ ಪಾಪ ಅವ್ರು ಏನು ಆಗೋದಿಲ್ಲ ಏನ್ರಿ. ಒಂದ್ ದಿವಸಕ್ಕೆ ಏನಾರು ಆಗ್ತದೇನ್ರಿ? Court is I will pass orders on merits only. ಒಂದ್ ದಿವಸದಲ್ಲಿ ಏನಾಗ್ತದೆ? Nothing will happen. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿ if time permits. ಈವನ್ ಬೇಕಾದ್ರೆ 6 ಗಂಟೆವರೆಗೂ ಕೂತ್ಕೊಂಡು ನಾನು ಕೇಳ್ತೀನಿ. ಅಷ್ಟು ನೀವು ಅಂತ ಎಕ್ಸಿಜೆನ್ಸಿ ನಿಮ್ಗಿದ್ರೆ I will sit and hear the matter. Even let them place the material.
ಈ ರಿಪೋರ್ಟ್ಸ್ ಅವರು ಕಲೆಕ್ಟ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ 4 to 5 days.
ಅದು ಅವತ್ತೇ ನಾನು 5 ದಿವಸದಿಂದನೇ ಹೇಳಿದ್ದೆ.
ಮಾಡಿದ್ದಾರೆ ಸ್ವಲ್ಪ ತಪ್ಪಾಗಿ ಕೊಡುವಾಗ
ನನಗೆ ನನ್ನ ಹತ್ರ ಇದೆ. I have the details also. In which cases they have filed B report also.
ನಾವು ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟು ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಡ್ಬೇಕು. ಇಂಡೆಕ್ಸ್ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು.
But ಏನಂದ್ರೆ it is unfortunate. ಒಬ್ಬ IAS ಆಫೀಸರ್ ಮನೆಯಲ್ಲಿ 4,22,00,000 ರೂಪಾಯಿ ಸಿಗುತ್ತೆ. ಮನೆಯಲ್ಲಿ ಕ್ಯಾಶ್. ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಹೇಳ್ತೀನಿ, ಬೇಕಾದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ನೇಮ್. I don't have any hesitation to make a mention on all this. 5 kg ಚಿನ್ನ ಸಿಗುತ್ತೆ. ಆ ಕೇಸಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ, ಲೋಕಾಯುಕ್ತ ಮ್ಯಾಟ್ರು. ಆಮೇಲೆ when the B report was filed, the earlier judge given notice to the IO. That PO is got it transferred and given the posting of different judge. ಆಮೇಲೆ 18th ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಆಗ್ತದೆ. Officer who has been in charge of the particular court. Order was passed on 24th accepting the B report. These are the things are going on. Why this court has to set the eyes.
This is which one
record ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ ನಿಮಗೆ. 18ನೇ ತಾರೀಕು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ. ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ಮೇಲೆ ಜಡ್ಜ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ಹೋಗ್ತಾರೆ. Earlier PO issued notice to the investigating officer on what basis you have filed the B report ಅಂತ. I can mention the name of even the threat made to me and also even mention the person. 4.5 crores in the house of an accused, and he was let off. These are the things. These are the things pains us. You get the records. I dealt with PC Act, more number of cases, PC Act cases.
As a trial
judge.
Sessions judge, yes, obviously.
25 ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ. 50ರಲ್ಲಿ ಅಷ್ಟೇ ಅಲ್ಲ, 700 ಡಾಕ್ಯುಮೆಂಟ್ಸ್, 30 ಜನ ಡಿಫೆನ್ಸ್ ವಿಟ್ನೆಸ್, ಪ್ರಾಸಿಕ್ಯೂಷನ್ 50 ಜನ ವಿಟ್ನೆಸ್. I took the pain. I delivered the judgment. ಆಮೇಲೆ ಇವನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ದಿಲ್ದಂಗೆ ನೋಡ್ಕೋತಾರ್ರಿ. ACB ನಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ದಂಗೆ ಈಗ ಜಡ್ಜ್ ಇಂಥವ್ರು ಇದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಾರ್ದು ಅಂತ. ದೆನ್ ಐ ಕಾಲ್ಡ್ ದಿ SP at Mysore. Till August, they have filed only 2 charge sheets, waiting for my transfer. I was due for transfer. Then when I called and SP, Lokayukta, why you have not filed the like this? I have got the information.
I understand.
Then immediately within 3 months they have filed 13 charge sheets. How could it be? 13 charge sheets. While coming out after my transfer, only I kept only 6 cases. I cleared 25 years of Lokayukta matters pendency before the. Because all we see, but these are the things are going on now. It is incurable.
We will not do our best. Whatever with your lordships, I try.
ಇದೇನೋ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಡೇಟ್ ಚಾರ್ಟ್ ಆಫ್. ಈಗ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದು ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ. ಈಗಲೂ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದು ಈವನ್ ಜೂನ್ ತಿಂಗಳಲ್ಲೂ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ ರೀ. ಜೂನ್ ತಿಂಗಳಲ್ಲೂ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ. ಐ ವಿಲ್ ಗಿವ್ ದ ಡೇಟ್, ಬಿ ರಿಪೋರ್ಟ್ ಡೇಟ್ including crime number and what date B report is filed and what date B report is accepted. I will give the details of the crime. Kodi. Half-hearted attempt bada. You give. ಆಯ್ತು ಒಂದು 3-4 days ಯಾವತ್ ಬೇಕು ಹೇಳಿ. ಈಗಾಗಲೇ 5 days ಕೊಟ್ಟಿದ್ದೀನಿ, ಮತ್ತೆ 5-4 days ಇಲ್ಲ. ಈ ವೀಕ್ ಒಳಗೆ ಕೊಡಿ. I will consider his bail matter this week only. I am concerned about the liberty of a person also. Article 21. ಬೇಡ ನನಗೆ ಅದೆಲ್ಲ ಬೇಡ. ಈಗ ಕೊಡಿ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ. ಈಗ ADGP ಬಂದ್ಮೇಲೆ ಎಷ್ಟು ಮಾಡಿದ್ರಿ ಕೊಡಿ. ಯಾವಾಗ ಬಂದಿದ್ದೀವ್ರಿ ADGP? 8 months ಆಯ್ತಾ? 1.5 year. ನಿಮ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಬಂದಿದೆ ಯಾವಾಗ ಬೆಂಗಳೂರಿಗೆ? ಅವರು 1.5 year. 1 year 5 months. ಹೌದಲ್ಲ? Why you people are allowing such people, IAS and IPS lobby? Paid. I will pass total order on merits and also I will give some directions also. 7th Thursday ಆಗ್ಬೋದಾ? ಆಯ್ತು.
ನನ್ನ ಬಗ್ಗೆ ಯೋಚನೆ ಮಾಡ್ಬೇಕು.
ಅದೇನಾ, that's what I am asking. That's why I am telling him the Article 21 also to be looked into. But ಕೋರ್ಟಿಗೆ ಬರೀ ಇದ್ರ ಕಲ್ಸಲ್ಲ, ಎಲ್ಲ ನೋಡ್ಬೇಕು. Interest of the accused as well as the investigating agency duty also. See that 7th? 8th inconvenience ಇದೆ ಅಂತಲ್ಲ ಅವ್ರಿಗೆ. I am giving other 3 days ಅಲ್ಲ.
ಒಂದು ದಿವಸ ಇದೆ 8th ಗಾಗೋ 7th ಸೈಕಲ್ ಆಗಿ
7th ಅದು ಇದೆಯಲ್ವಾ, ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಬೋತ್ ಆರ್ ದಿ ಸೊಸೈಟಿ ಇಂಟ್ರೆಸ್ಟ್. ಈಸ್ ಆನ್ಸರಬಲ್ ಟು ಹಿಸ್ ಕ್ಲೈಂಟ್, ಹೌದಿಲ್ಲ? ಮತ್ತೆ ವೈ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ಲೇಸ್ ದಿ ಮೆಟೀರಿಯಲ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಇವನ್ ದೋ 5 days ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ಟೈಮ್ ಅಲ್ವಾ? ಈಸ್ ಆನ್ಸರಬಲ್ ಟು ಹಿಸ್ ಕ್ಲೈಂಟ್. ಮತ್ತೆ ತೊಗೊಳ್ಳಿ. This court in the previous date, considering the material on record that corruption is a cancer, instead of spreading the same to the society and the same cannot be cured, if it is reaches the whole society, and in order to see the very object in bringing the special enactment of Prevention of Corruption Act, when notice the material that investigation is not proceeding in a proper way, since The allegation against the deputy commissioner is that through his personal assistant and also through a private person who is alleged agent of him, collected an amount of 5 lakhs, which is a demand of 15 lakhs scaled down to 5 lakhs, and hence summoned the ADGP before the court. Since the matter involves the public interest, and also this court is conscious about investigation is the domain of the IO, and also in certain matters, and it requires monitoring by court, which doesn't mean supervision by court. Public interest is the sole consideration, and a constitutional court monitors an investigation only when circumstances compel it to do. Found that this is a case compelled the court with regard to the public interest is the sole consideration, and constitutional court monitors an investigation and hence directed when about to dictate the orders to summoning of the information from the ACB, which is set up under the notification to prevent the corruption as anti-corruption cell alla bureau, sorry, ACB bureau. And hence, while dictating the orders in the middle of the proceeding, midst of the dictation, the special counsel.
Sorry, but now that we have agreed, now my request is I leave it to your orders, but Avashkadila, we will anyway, we are now some mainly my request. It's a request by me.
The special first starting in ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಕಮೆಂಟ್ಸ್ ಮಾಡಿದ್ನಲ್ಲ ಅದೊಂದು ನಿಮಿಷ ಬೇಡ ಅದು ಹೇಳ್ಬಿಡಿ ಬೇಡ after considering the material when this court ಅದು ಬೇಡ ಅವ್ರನ್ನ ಹೇಳೋದೇ ಬೇಡ ಅಂತಲ್ಲ ಆಯ್ತು the counsel appearing for the ACB, that is special counsel, undertaken to place the material before the court which is sought regarding filing of the B report and obtaining of search warrant and not conducted search based on the search warrant, and also submit the report regarding accepting of the B report from the date of setting up of ACB. The special counsel today in the morning expressed his inability to place on record, place the same before the court. Now the Advocate General in the afternoon appeared before the court, but instructed ACB to place all material before this court and seeks 3 days time. 3 days time, and hence matter is adjourned to 7th of July, and this court is also having about the liberty of a person who has approached this court invoking the jurisdiction under section 439 of CRPC. ಆಯ್ತಾ ಏನಾಯ್ತು ಈಗ ಡಿಸಿ ಆಫೀಸ್ ಏನಾಯ್ತು ಬರ್ಲಿಲ್ಲ ಡಿಸಿ ಆಫೀಸ್ ಇಂದ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಒಂದು ಅದೇ ಎಲ್ಲ ಡೆಸ್ಟ್ರಾಯ್ ಆಗೋಯ್ತು ಅದನ್ನು ಎಲ್ಲಿ ನಿಮ್ಮ ಡಿಸಿ ಅಲ್ಲಿ ಬ್ಯಾಂಗ್ಳೂರ್ DC, ಇನ್ಚಾರ್ಜ್ DC. ಇನ್ಚಾರ್ಜ್ DC ಗೆ ನಿಮ್ಗೆ ಹೇಳಿದ್ನಲ್ರಿ ಬೆಳಗ್ಗೆ. ಹೌದು, ಏನಿದೆ ರಿಪೋರ್ಟ್, ಬಟ್ how they made the payment salary to him? How they made the salary ಏನ್ರಿ? How they made the salary to him? Salary ಅದನ್ನು ಸಮನ್ ಮಾಡ್ಬೇಕಾ? How they made the salary to him, paid the salary to him? ಏನ್ರಿ, why you are closing your mouth? Have you made the payment or not? Whether the deputy commissioner has made the payment or not?
The instructions also is not an employee, not on contract.
Contract employee alva?
He's not, there is one more person. Chandru ಅಂತ ಇನ್ನೊಬ್ಬ contract ಅಂತ.
ಇವನೇ ಚಂದ್ರು
ಚಂದ್ರು ಎಲ್ಲ ಸೇರ್ತಾರೆ.
ಅಲಿಯಾಸ್ ಮಾಡಿದ್ರಾ?
ಕಾಂಟ್ರಾಕ್ಟ್ ನಲ್ಲಿ ಬೇರೆ ಇರ್ತಾರೆ, ಅಷ್ಟೇ ಜಾಸ್ತಿ ಇರ್ಬೇಕು.
ಅಕ್ಯೂಸ್ ಮಾಡುವಾಗ ಏನಂತ ಮಾಡಿದಿರಿ? ಕಾಂಟ್ರಾಕ್ಟ್ ಎಂಪ್ಲಾಯ್ ಮಾಡಿದಿರಾ ಅಥವಾ ಏನಂತ ಮಾಡಿದಿರಿ? ಕೊಡಿ ಫೈಲ್ ಕೊಡಿ. He says in his statement that the A1 only instructed him to collect the money. That's what I read. I underlined it everywhere. Even points also noted. 1, 2, 3, 4, 5, 6 like. A1, A2. ಆಯ್ತು, A1 ಕಾನ್ವರ್ಸೇಷನ್ ಅಲ್ಲಿ ಹೇಳ್ತಾನೆ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ತಗೋಬಾ ಅಂತ ಅಲ್ವಾ? ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಏನು? ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಏನ್ರಿ? DC ಕಡೆಯಿಂದ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಅಂತಾನೆ, ಹೌದಿಲ್ಲ? ಮತ್ತೆ ಯಾಕೆ ನೀವು why you are not taken coercive steps against A2? Why you people are hiding him? This is the conversation I noted here. ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಅಂತ he demanded 15 lakhs and scaled down to the 5 lakhs. ಇಲ್ಲಿದೆ ಕಾನ್ವರ್ಸೇಷನ್ ಇದೆ ನೋಡಿ. These are the things are material are available before the court. ಹೌದಲ್ಲ? ಹೇಳಿದಾನಿಲ್ರಿ? ಅಯ್ಯೋ ನೀವೇನಾ? ಅರೆಸ್ಟೆಡ್ ನಂಗೆ ಗೊತ್ತು ರೀ, ಅವನು ಅರೆಸ್ಟೆಡ್, ಅವ್ನು ರಿಲೀಸ್ ಆದ. ಯಾಕೆ ಅಂತಂದ್ರೆ ಪಾಪ ಅವನು ಇವ್ರಿಗೋಸ್ಕರ ಅವನು ಬಲಿಪಶು ಆದವನು. ಇವ್ರು ಮಾಡ ಕೆಲ್ಸಕ್ಕೆ ಅವನು ಬಲಿಪಶು ಆದವನು. ಕಾನ್ವರ್ಸೇಷನ್ ನೋಡಿ. ಚಂದು ಕೋರ್ಟಿಗೋ ಬಳಿ ಕೊಡುವಂತೆ ಚಂದು ಎಬ್ಬನನ್ನು ಕೊಡಿಸಿಕೊಡುವುದಾಗಿ ತಿಳಿಸಿದ್ದು. ಅದರಂತೆ ನಾನು ಹಾಲ್ನ ಪಕ್ಕದಲ್ಲಿರುವ ಪೋರ್ಟಿಗೋ ಬಳಿ ನಿಂತುಕೊಂಡಿದ್ದಾಗ ನನ್ನ ಬಳಿ ಹಸಿರು ಬಣ್ಣದ ಶರ್ಟ್ ಧರಿಸಿದ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಬಂದು, ನೀವು ಅಜಂ ಪಾಷಾರವರ ಎಂದು ಪರಿಚಯಿಸಿಕೊಂಡು ಕಂಪ್ಲೇನೆಂಟ್ ಮಹೇಶ್ ಅವರು ನನಗೆ 5 ಲಕ್ಷ ರೂಗಳ ಲಂಚದ ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ಬರುವಂತೆ ಸೂಚಿಸಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿ ಬಂಚನಾಮೆಯ ಕಾಲದಲ್ಲಿ ಬಿನಾಪ್ತನಿಂದ ಕೂಡ ಹೆಚ್ಚಿನ 5 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಂದ ಇದೆಲ್ಲ ಕಾನ್ವರ್ಸೇಷನ್ ಇದೆ ನೋಡಿ. ಆಲ್ಸೋ ಸೇಸ್ he will get it done the work from the deputy commissioner. ಮತ್ತೆ why you are allowing, why you are leaving the deputy commissioner? Yeah, because he is an IAS officer ಅಂತನಾ? Statement has been recorded. That's what I am. Conversation ಇದೆ. ಯಾಕೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಆಮೇಲೆ ಬಿಡಿ, ಅಕ್ಯೂಸ್ 1 and 2 ಅವರೆಲ್ಲ ಹೇಳ್ತಾರೆ ಎಲ್ಲ ಅಲ್ಲ ಚೈನ್. ಕಾನ್ವರ್ಸೇಷನ್ ಇದೆಯಲ್ಲ, ಪ್ರೈಮಾ ಫೇಸಿ ಮೆಟೀರಿಯಲ್. ನೀವ್ ಯಾಕೆ, ಐ ಡೋಂಟ್ ನೋ ವೈ ಯು ಆರ್ ಪ್ರೊಟೆಕ್ಟಿಂಗ್ ಹಿಮ್. ಇಷ್ಟೆಲ್ಲ ಆಗ್ತಾ ಇದೆ, ಸ್ಟೇಟ್ಗೆ ಅವಮಾನ ಆಗ್ತಾ ಇದೆ, ಆದ್ರೂ ಯು ಆರ್ ಪ್ರೊಟೆಕ್ಟಿಂಗ್ ಹಿಮ್. ಅಲ್ಲಿ ದಟ್ ಶೋಸ್ ದಟ್ ಸ್ಟೇಟ್ ಇಸ್ ಆಲ್ಸೋ ಎ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಕ್ರೈಮ್ ಅಂತ, ಹೌದಿಲ್ಲ? State is also a part of the crime ಅನ್ನಕ್ಕೆ ಇದೊಂದು ಎಕ್ಸಾಂಪಲ್. I don't know why you are protecting ADGP as also the IAS officers. ಎದುರುಗಳ ಹಾಕೊಳ್ಳಕ್ ಗೈ ಇಲ್ವಾ ಸರ್ಕಾರಕ್ಕೆ? ಬೇರೆ ಏನೇನ್ರಿ? ಅವ್ರನ್ನೇ ಬಿಟ್ಬಿಡಿ, ಬ್ಯೂರೋಕ್ರಾಟ್ಸ್ ದರ್ಬಾರ್ ಮಾಡ್ಲಿ ಸ್ಟೇಟ್ ಅಲ್ಲಿ. ವೈ ಡೆಮೋಕ್ರಾಟಿಕ್ ಸೆಟಪ್? ಏನಾಯ್ತು ಮೇಡಮ್? ಅರ್ಜೆಂಟ್ ಮಾಡೋದ್ ಬೇಡ, ಅವ್ರೇನೋ ಸಂಜೆಗೆ 4:15 ಅವಳಿಗೆ ಕೊಡ್ತೀನಿ ಅಂತಾರಲ್ಲ ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ಸ್. ಕೊಡಿ ಆಮೇಲೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀನಿ. ಆಯ್ತು. ಬೇರೆ ಮ್ಯಾಟರ್ಸ್, ಅದರ್ ಮ್ಯಾಟರ್ಸ್. 73 na.
Here, 149.
498 306 114 A1. ಏನು 306 ಇನ್ವೋಕ್ ಮಾಡಕ್ ಏನಿದೆ? What is the material?
No material, my lord. My lordship, there is no material, my lord. Marriage happened 10 years before, my lord. Children there, my lord. All the children.
ಪ್ರಾಕ್ಸಿಮಿಟಿ ಟು ಕಾಸ್ ಆಫ್ ಡೆತ್. ಅವ್ನು ಏನ್ ಎಕ್ಸ್ಟ್ರೀಮ್ ಸ್ಟೆಪ್ ತಗೊಂಡ ಸಾಯಕ್ಕೆ, ಅದಕ್ಕೆ ಏನಾದ್ರು ಪ್ರಾಕ್ಸಿಮಿಟಿ ಟು ಕಾಸ್ ಆಫ್ ಡೆತ್ ಏನಾರು ಇದೆಯಾ? ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ ಏನ್ ವಾಟ್ ದೇ ಸೇಸ್?
Kindly minute page number 20, my lord.
ಹಾಕಿದೀರಾ?
Sessions court judgment ಅಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ರು.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ ಡೆತ್ ನೋಟ್? ಎನಿ ಪ್ರೀವಿಯಸ್ ಇನ್ಸಿಡೆಂಟ್?
Page number 20, my lord.
ಎಲ್ಲರೂ ಚೆನ್ನಾಗಿರಿ, ನನ್ನ ಸಾವಿಗೆ ನಾನೇ ಕಾರಣ, ಇದಕ್ಕೆ ಯಾರು ಹೊಣೆ ಇಲ್ಲ, ನನ್ನಿಂದ ಎಲ್ಲರಿಗೂ ತೊಂದರೆ, ಇವಾಗ ಯಾವ ತೊಂದರೆ ಇಲ್ಲ, ಇತಿ ನಿಮ್ಮ ಲಕ್ಷ್ಮಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅಷ್ಟೇ ಅಲ್ಲೇನ್ರಿ? ಆಯ್ತು, ಈಕೆ ಬೇಕು ತಾನೆ? ಏನ್ರಿ ಡೆತ್ ನೋಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರೆ?
Any findings on death note, my lord?
Nobody was responsible for her death. The same is reproduced as under.
And also itself, my lord, there is no previous incidents regarding the dispute between the husband and wife, my lord.
ಏನಿದೆ? ವಾಟ್ ಇಸ್ ದರ್ ಪ್ರಾಕ್ಸಿಮಿಟಿ ಟು ಕಾಸ್ ಆಫ್ ಡೆತ್?
ನನ್ನ ಮಗನಾದ ನೀಲಪ್ಪನ ಜೊತೆ ವಿಶ್ವರಾಗಿ ಅವಳ ಮನೆಗೆ ಪ್ರವೇಶಿಸುತ್ತೇವೆ.
15/2ಕ್ಕೆ.
16 ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ 2022 ಬೆಳಿಗ್ಗೆ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು ನನ್ನ ಮಗನಿಗೆ
ಮನೆಗೆ ವಾಪಸ್ಸು ಬಿಟ್ಟು ಬೆಳಗ್ಗೆ 10 ಗಂಟೆಗೆ ಆಕೆನ್ ಬಿಟ್ಟು ದುಡ್ಡು ಕೊಟ್ಟು ಕಳ್ಸಿರೋದಾ?
ತಂದೆ ಕುಮಾರ್ ನನ್ನ ಮಗನಿಗೆ ಕಾಲ್ ಮಾಡಿ ಇನ್ನೊಂದಲ್ಲಿ ನೇಣು ಹಾಕಿಕೊಂಡು ಸತ್ತು ಹೋಗಿದ್ದಾಳೆ ಅಂತ ಹೇಳಿದೆ. ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಆಗ ಸುಮಾರು 10 ರಿಂದ 11
But she has left the death note. ಇಲ್ವಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನೋ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರೆ ನೋಡಿ ಇಲ್ಲಿ ಆರ್ಡರ್ ನಲ್ಲಿ. ಈಗ 15,000 ಹಿಂದಿನ ದಿವಸ ಕೊಟ್ಟರು.
first time allegation by the mother of the victim, my lord, after the death of the victim, my lord. In past 10 years matrimonial life, there is no allegation against them.
ಹಿಂದೆ ಏನಾರು ಪಂಚಾಯತ್ ಏನಾರು ಆಗಿದೆಯೇನ್ರಿ? ಇಲ್ಲೋ ಫೈಲ್ ಇಲ್ವಾ? ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕ್ಲಾ? Third in part, HCP 6, 2 days time, and then this matter day after tomorrow. Kumara KG 448 to 307, 323, 504, 506, 307 ಏನಿದೆ ರೀ?
ಕಲ್ ತಗೊಂಡು ಎತ್ತಾಗ್ತದ ಅಂತ ಅಲಿಗೇಷನ್, ಬಟ್ ನಾನು ತಪ್ಪಿಸ್ಕೊಂಡೆ. ಕಲ್ ತಗೊಂಡು ತಲೆ ಮೇಲೆ ಹಾಕಕ್ ಬಂದ ನಾನು ತಪ್ಪಿಸ್ಕೊಂಡೆ.
ಇಂಜುರಿ ಏನಾಗಿಲ್ವಾ?
ಸ್ವಲ್ಪ ಆಪರೇಷನ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಹೇಗಾಗಿದೆ?
ಆಪರೇಷನ್ ತಲೆಗೆ ಸ್ವಲ್ಪ ಇಂಜುರಿ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. He himself who went to the police station and logged.
Who went himself?
Injured person.
Complainant ಅವನೇ ಹೋಗಿದಾನ? ಆಯ್ತೇನ್ರಿ? ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ಏನ್? ಬಟ್ ನಿಮ್ಗೆ ಏನಾರು ಇದೆಯಾ ದಾಖಲೆ ನಿಮ್ಮ ಹತ್ರ? ಸರ್ಟಿಫಿಕೇಟ್ ಏನಾರು ಇದೆಯಾ? ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ಏನಾರು ಇದೆಯಾ? ಕಂಪ್ಲೇಂಟ್ ಅದನ್ನೇ ಹೇಳಿದಾನ? ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾನೆ?
ಲಾಸ್ಟ್ ಫೈಲ್ ಆಗಿದೆ.
ಹಿಡಿದುಕೊಂಡು ನೆಲಕ್ಕೆ ಕೆಡವಿ ಎಲ್ಲರೂ ಕಾಲುಗಳಿಂದ ತುಳಿದರು. ಅಷ್ಟರಲ್ಲಿ ಸುಮಾಳ ತಮ್ಮ ಅನುಕುಮಾರನ್ನು ಮಣಿಗೆ ಕಟ್ಟಲು ತಂದು ಇಟ್ಟಿದ್ದ ಒಂದು ಸೈಜ್ ಕಲ್ಲನ್ನು ಎರಡೂ ಕೈಗಳಿಂದ ಎತ್ತುಕೊಂಡು ನನ್ನನ್ನು ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಕೆಳಗೆ ಬಿದ್ದಿದ್ದ ನನ್ನ ಮೇಲೆ ಇವತ್ತು ಇದನ್ನು ಮುಗಿಸಿ ಬಿಡುತ್ತೇನೆಂದು ಕಲ್ಲನ್ನು ಎತ್ತಿ ತನ್ನ ತಲೆಯ ಮೇಲೆ ಹಾಕಿದ್ದು ನಾನು ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಪ್ರಯತ್ನಿಸಿದಾಗ ನನ್ನ ಹಣೆಯ ಬಲಭಾಗಕ್ಕೆ ಕಲ್ಲು ತಗುಲಿ ರಕ್ತ ಗಾಯವಾಯಿತು. ನಾನು ತಪ್ಪಿಸಿಕೊಳ್ಳಲಿಲ್ಲ ಎಂದು ನನ್ನ ತರ ತೀವ್ರವಾಗಿ ಸಾಯುತ್ತಿದ್ದೇನೆಂದು ಅಷ್ಟರಲ್ಲಿ ಅಕ್ಕಿಗೆ ನನ್ನ ಹೆಂಡತಿ ಗೀತಾ, ನನ್ನ ಚಿಕ್ಕಪ್ಪ ಸರ್ ಇದಾದ ನಂತರ ಸುಮಾ ಮತ್ತು ಆಕೆಯ ತಮ್ಮ ಅನುಕುಮಾರನು ಜನ ಬಂದು ನಿನ್ನನ್ನು ಬಚಾವ್ ಮಾಡಿದ್ದಾರೆ, ಇನ್ನೊಮ್ಮೆ ಸಿಗು, ನಿನ್ನನ್ನು ಯಾರು ಕಾಪಾಡುತ್ತಾರೋ ನೋಡುತ್ತೇನೆ ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿ ಹೊರಟು ಹೋದರು.
ನಂತರ ನಾನು KR ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡು ಈ ದಿವಸ ಬಂದಿರುತ್ತೇನೆ. 23 ಇನ್ಸಿಡೆಂಟ್
ಅವರ್ 23rd 24th ಬಂದವನಂತೆ ಅವನು. ನೋಡಿ not the petitioner, counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution on 23/5/2022 there was a quarrel in the early morning at 10 a.m. and on the same day at 7:30 p.m. suddenly these petitioners trespassed the house of complainant. This is a petition by whom? Accused number 1. This petitioner and other accused persons and abused in a filthy language and assaulted with their hands. And when he tried to escape from the clutches, he fell down at that time. Yunena, this petitioner took out the side stone and dropped on him on his head. But in the process of ward off his head blow, he had sustained injury to his head. And hence he went to hospital and took treatment and given the complaint for the petitioner who suffered that. Incident was taken 23/5/2022 and complaint was given on the next day on 24/5/22 and complainant.
Hello. ಬೆಳಿಗ್ಗೆ ಮಾತಾಡ್ತಾ
and there was no any intention to commit the offense, and also counsel would submit that this petitioner has been apprehended and he is in custody from 35/2022 and no need of further custodial investigation. For account of the counsel appearing to the state would submit that this petitioner made an attempt to take away the life by dropping the stone on his head and the victim escaped from the said act of the petitioner. And they had sustained the injury. Then there is a prima facie case against the petitioner. Having heard the respective counsel and also on perusal of material, particularly taking into note of the incident which had taken place earlier and subsequently in the evening, an assault was made. And apart from that, the injury is also simple in nature, and the injured himself went to the police station on the next day after taking the first aid at CH hospital. And hence, considering the accusation made in the complaint, it is a fit case to exercise the discretion in favor of the petitioner by which conditions. ಯಾವಾಗ ಹಾಕಿದಿರಿ? ಇವತ್ತು ಬೆಳಗ್ಗೆ. ವಾಟ್ಸ್ ಯುವರ್ ಗುಡ್ ನೇಮ್? Prasanna Kumar. Counsel Sri Prasanna Kumar submits that on behalf of the de facto complainant, he has filed an application on 301 of CRPC in the office, and hence office is directed to put up the application and list this matter day after tomorrow. 2 days ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ, day after tomorrow. ಏನು ಫೈಲ್ ಮಾಡಿರೋದಾರ ವೆಂಕಟೇಶ್ ಪ್ರಸಾದ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ವೆಂಕಟೇಶ್ ಪ್ರಸಾದ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಗಿರೀಶ ಜೆಟಿ. 33 ನ ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು ಮನ್ಮೋಹನ್ ಇದಾರ? ಬಿಬಿ ಪಾಟೀಲ್ ಒಂದ್ರಲ್ಲಿ ಬಿಬಿ ಪಾಟೀಲ್ ಅಂತ ಇದೆ, ನಿಮ್ದ್ರಲ್ಲಿ ಯಾರ್ದಿದೆ?
Lordship, kindly.
Yes.
Lordship, serial number 76.
Are you ready? What matters?
My lord, I need to file objection, my lord. Serial number 33 arises out of same crime number, my lord. It may be clubbed up and taken up together, my lord. I'll file my objection, please. I need some time to file my objection, my lord.
Have you filed the objections in other matter?
Yeah, definitely, my lord. I have filed objections in all the matters, my lord.
Serial number 76 ಅಲ್ಲಿ ನೀವು objections ಹಾಕಿದೀರಾ?
No, my lord. 76 and 33. Just
ಎರಡರಲ್ಲೂ objections ಹಾಕಿಲ್ವೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ. I'll file, my lord.
ಇದರಲ್ಲಿ already court has given an opportunity to you to file objections. Why you have not filed?
My lord, it was listed for non-compliance of office objection. That time
non-compliance ಆದ್ಮೇಲೆನೆ directions ಕೊಟ್ಟಿದೆ ನೋಡಿ.
Yes, my lord. I
madam order sheet 76 ಅಲ್ಲಿ. Then I will hear the matter 76 ಮತ್ತೆ Direct counsel for the petitioner directed to send the copy of the petition forthwith ಅಂತಿದೆ ಅಷ್ಟೇನಾ ಮೇಡಮ್? ಅಲ್ಲ directed to accept the notice for the respondent ಅಂತ ಆಯ್ತು. ಆಯ್ತು. Special counsel seeks time to file objections in both the matters. The office ಹಾಕಿದಾರ? ಮತ್ ಮನಮೋಹನ್ ಹಾಕಿದಾರಂತಲ್ಲ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ, ನಿಮ್ ಕೇಸಲ್ಲಿ ಆಯ್ತ್ರಿ. ಯಾಕೆ ಮಾಡಕ್ಕಲ್ಲ? ಇಬ್ರು ಅಡ್ವೊಕೇಟ್ ಇದ್ರೆ ಇಬ್ರು ಬರ್ಲಿ, ನಮ್ಗೆ ನಾವೇನ್ ಮತ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಏನ್ರಿ? ನೀವು ಅದರ್ ಕೇಸಲ್ಲೂ ನಿಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯೇನ್ರಿ?
ಪ್ಲೀಸ್ my lord, I'll file my objection, my lord.
ಅದರಲ್ಲೂ ಇದೀರಾ ನೀವೇನೆ?
ಹೌದು ಸ್ವಾಮಿ, ಈ ಕೇಸಲ್ಲಿ ನಾವು ಇದೀವಿ.
ನೀವು MA ಹಾಕ್ಬೇಕಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಅಲ್ಲಿ.
30.
But now MA is filed by the Manmohan.
Yes, please.
Manmohan.
33 ಅಲ್ಲಿ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, 76 ಅಲ್ಲಿ ನಾವು ಫೈಲ್ ಮಾಡಿದೀವಿ.
ನೀವು ಫೈಲ್ ಮಾಡ್ತೀರೇನ್ರಿ? MA ಫೈಲ್ ಮಾಡ್ತೀರಾ 33 ಅಲ್ಲಿ?
I'll file, my lord.
The counsel Sri BB Patil submits that in criminal petition number 5889 of 22 is going to file MA on behalf of the respondent and also seeks an adjournment. The counsel also seeks adjournment in serial number criminal petition number 5659 of 22 to file the objections. And hence 3 days time given to file objections. Miss this both the matters. The office is directed to club both the matters. ಅಂತ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. 77 ಮಂಜುನಾಥ್ MR. 307 ಇದೆ. ಏನ್ ಇಂಜುರೀಸ್ ಏನು? 120B A9. A7 ಗೆ ಆಲ್ರೆಡಿ ಬೇಲ್ ಆಗಿದೆಯಾ? 33 ನಲ್ಲ 36 ಇದೆ, 35 ಇದೆ, 4 to 5 ಅಲ್ಲಿ ಇಲ್ಲ ರೀ. ಪೇಜ್ ಕಮೆಂಟ್ಸ್ ಆಗದೆ 35 ಅಲ್ಲಿ. ನಿಮಗೆ ಕೊಟ್ಟಿರೋದೇ ಒಂದು ಪೇಜ್, ನಮ್ಗೆ
ಅಲಿಗೇಷನ್ ಪೇಜ್ ನಂಬರ್ 33 ನಲ್ಲಿ ಇದೆ ಅಂತ ಅಗೇನ್ಸ್ಟ್ ಪಿಟಿಷನರ್
33 ಅಲ್ಲ
ನಲ್ಲಿ ಕರ್ಕೊಂಡ್ ಬಂದು
ಏನೇನು ಅಲ್ಲಿಲ್ಲಲ್ಲ, ಮುಂದೆ ಇಂಜನ್ ಮೇಲೆ ಮಾತ್ರ ಇದೆ. ಹರೀಶನ ಹರೀಶ ಬರುತ್ತಾ. ಓಪ್ಪೋ N Pro ಕಂಪನಿಯ ಟಚ್ ಸ್ಕ್ರೀನ್ ಮೊಬೈಲ್ ಫೋನ್ ಅಂತೇನೋ ಇದೆ.
ಇದರಲ್ಲಿ
A1 and A3 ನ ಕರ್ಕೊಂಡು ಹೋದ್ರು ಇವ್ನು ಕರೆಸ್ತಾ
ಇವನ್ ಮೇಲೆ ಇವನು ಹರೀಶ್ ಅಲ್ಲ ಇವನ್ ಮೇಲೆ ಎಲ್ಲಿದ್ದಾರೆ ಇವನ ಹೆಸರು ಎಲ್ಲ ಇಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ ಟ್ರೈನಿಂದ ಅಲ್ಲೇ ಮಾಡಿದ್ದಾಗಿ
ಬಟ್ ಅದು ಇಲ್ಲಿ ಇವನು ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ವಿಕ್ಟಿಮ್ ಪೇಜ್ ನಂಬರ್ 23 ಮೇಡಮ್ ಪೇಜ್ ನಂಬರ್ 23 ನಲ್ಲಿ ಅವನು ಅಲ್ಲ
ಒಂದೇನ್ ಕೈಲಿಂದ ಮಾಡಿದಾನೆ ಅಂತನಾ ಇವನು ಆಯ್ತು ಇವನ್ ಯಾರು ನೋಡಿ ಮೇಡಮ್ ಇದು ಒಂದು ಸಿಗ್ತದೆ ಪಿಟಿಷನ್ ನಿಮಗೆ ಪೇಜ್ ನಂಬರ್ 35 ಅಲ್ಲಿ 4251 ಆಫ್ 22 ನಲ್ಲಿ ಆಲ್ರೆಡಿ ಎಲ್ಲಾ ನನ್ನ ಬೇಲ್ ಅಫೆನ್ಸಸ್ ಎಲ್ಲ ಸೇಲ್ ಇದೆ ದ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ವುಡ್ ಸಬ್ಮಿಟ್ ದಟ್ ಹೇಳ್ಬಿಡಿ ನೀವು this petitioner is in custody the same ಇದೆ ರೀ 19-3 same and only allegation against this petitioner is that
ಕರ್ಕೊಂಡು ಬಂದ ಅಂತ ಅಷ್ಟೇ
he only brought the injured ಅಲ್ಲ injured brought the injured to the spot for contra ಅದೆಲ್ಲ ಹೇಳಿ ಮೇಡಮ್ ಅಷ್ಟೇ ಸೇಮ್ the reasons only against this ಇಲ್ಲ ಕರ್ಕೊಂಡು ಬಂದ ಅಲ್ಲ ಕಿಡ್ನಾಪ್ ಹೆಂಗೆ ಅಂತ
A1 ಅಂತ ಕಿಡ್ನಾಪ್ ಮಾಡ್ತಾರೆ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಗೆ ಇವನು ಆಟೋ ಓನರ್ ಕಡೆಯಿಂದ ಇವನು ಕರೆಸ್ತಾ ಅಂತ
ಆತನಿಗೆ ಕೈಯಿಂದ ಅಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲೇ ಮಾಡ್ತಾರೆ
for contra the council appearing for the state would submit that the injured was brought to Yashwantpura police station and he was subjected to assault by their hand by this petitioner with hands and mobile phone was also recovered at the instance of this petitioner. So, having heard the respective counsel and also on perusal of material, the allegation against this petitioner that he only brought the victim to railway station and thereafter he assaulted with his hands. And taking into note of the gravity of the offense and also accusation made against this petitioner that he assaulted with his hands, it is a fit case to exercise the powers of 439 of CRPC since this petitioner is in custody from 19/3/2022 with conditions. So,
10,000 rupees is the price.
ಯಾವ್ದಂದ್ರೆ ಮಾಡಿದೀವಲ್ಲ
Even ಗಿಂತ ಕೊಟ್ಟಿದ್ದೀನಿ. Even was it was allowed in investigation.
this petitioner only received the amount.
On behalf of even received 5,000 rupees. Remaining 7,000 rupees ಗೆ ಟ್ಯಾಪ್ ಮಾಡುವಾಗ 2A2 to be given to A1. A1 to it was allowed on 30th June.
ಯಾರು ಇರಲಿಲ್ಲ ಅದರ್ ಸೈಡ್ ಯಾರು ಇಲ್ವಾ
Lord, please my lord.
ಹೇಳ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾತ್ರ ರಿಲೀಸ್ ಮಾಡಿದ್ದಲ್ಲ ಏನ 7,000
connected same
ಒಂದು ಆರ್ಡರ್ ತಗೊಳ್ಳಿ ಚೇಂಜ್ ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಅಷ್ಟೇನೆ ಅದ್ರ A1 ಮೇಲೆ he already collected an amount of rupees 5,000 and instructed this petitioner to collect the balance amount of rupees 7,000 and this petitioner was trapped while accepting an amount of rupees 7,000 ಅಂತ ಬಾಕಿದೆಲ್ಲ ರೀಸನ್ಸ್ ಎಲ್ಲ ಗ್ರಾವಿಟಿ ಆಫ್ ದಿ ಅಫೆನ್ಸ್ ಮಾಡಿದ್ದೀನಿ 7,000 ಒಂದು ಪಿಟಿಷನ್ ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ 5620 of 2020 dated June ಗೊತ್ತಾಗ್ತದೆ ಏನಾರಿದ್ರೆ ಕೇಳಿ ಕಾಪಿ ಇದೆಯಾ ರಿಲೀಸ್ ಆಗಿಲ್ವಾ ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರೋದು ಇನ್ನೂ ರಿಲೀಸ್ ಆಗಿಲ್ವಾ ಯಾವತ್ರಿ ಫ್ರೈಡೇನಾ ಫ್ರೈಡೆ ಬೆಳಗ್ಗೆಲ್ಲ ಕರೆಕ್ಷನ್ಸ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ವಿ ಮೋಸ್ಟ್ಲಿ ಬೆಳಗ್ಗೆ ಆಗಿರುತ್ತೆ ಮೋಸ್ಟ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗಿರಲ್ಲ ನೋಡಿ ಕಾರಿಯಪ್ಪ NA and HP ಯೂನಿಕ್ ಕಂಪನಿ ಪಾಸ್ ಓವರ್ ಇನ್ನಾವಲ್ರಿ ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಸುಬ್ಬಾರೆಡ್ಡಿ KN A4 ಹೌದು 506 504 384 392 ಏನ್ರಿ ಏನೋ ನೀವು ಏನೋ ಹೇಳಕ್ ಹೋದ್ರಿ ಯಾವ ಕೇಸಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಆಯ್ತು ಇದ್ರಲ್ಲಿ 504, 506 ಬಿಟ್ಬಿಡಿ 384 extortion ಎಷ್ಟು ದುಡ್ಡು ಎಷ್ಟು?
There was no recovery made from this petition, my lord.
Ah.
Also, my lord, what has been the allegation against this petitioner is that he acted as a police person and he tried to extort money. But the allegation, my lord, there is
ಇಲ್ಲ he pretended as he is the police officer ಅಂತ ಹೌದಾ?
one the allegation is that the person, there is no recovery, there is no, they were not even in uniform. My lord. The allegation is made that they are made to believe as a police and they had taken gold ring and chain. And there is no recovery from this petition because the recovery has been made from accused number 3. My lord, the entire allegation is that accused number 1 and accused number 3 in conspiracy had extorted certain money from the complainant for getting admission to a medical seat, my lord, about 66 lakhs. Thereafter, my lords, when the complainant asked to repay the said money, the accused number 1 and accused number 3 kept on delaying it. So at one point of time, the month of January 2022, they asked the complainant to come down to Bangalore. At that point of time, the accused number 1 and accused number 3, who is the owner of that lodge, and where the accused number 4 is a DJ player in that lodge, asked him to go. Perhaps what has happened is that 2 girls have been sentenced in that room where the complainant was staying. The accused number 3 had told accused number 4 to go take this. On that information, it was not in the knowledge of the accused number 4 that this was happening, but there was no recovery from the accused number 4, and also he was a DJ player in that premises, at the time of the incident when it has happened. After 4-5 months, the complaint was lodged on the accused number 1-3. The main allegation is entirely on accused number 1. Accused number 4 does not have much role in this. And only for the reasons that he was present and the allegation is that he had acted as a police officer. He has been arrested. From the date of arrest, he is the judicial custody. From 18/5 to 20.
When he was arrested?
18/5/2022. And thereafter, on 21/6, he was remanded to judicial custody, and hence from thereon he is in judicial custody. There is no criminal antecedents, and he's been a resident of the Bangalore. Is ready to abide by any conditions imposed.
50 lakhs.
Guys, sir, we will secure a medical seat to his daughter. Present petitioner.
Medical seat. ಆಯ್ತು.
ಅದ ಮೆಡಿಕಲ್ ಸೀಟ್ ವಾಪಸ್ ಕೇಳಿದಾಗ ಈ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಅವನ ಹತ್ರ ಮತ್ತೆ 50 ಲಕ್ಷ
ದುಡ್ಡು ವಾಪಸ್ ಕೇಳಿದಾಗ
That is all those allegations are with respect to A1 and A3. A4 is nowhere involved in those aspects of the.
But allegation against you that you have collected an amount of rupees 50 lakhs.
Collected any amount. The police,
police anta ಹೆದರಿಸಿರೋದು.
Police have stated that the accused number 1 and 3 were the one who have collected the money and not accused. There is no allegations with respect to this.
ಯಾವಾಗ ಅರೆಸ್ಟ್ ಆಗಿದ್ದಾವೆ?
18/5/2020.
18/5 ರಿಕವರಿ ಆಗಿಲ್ಲೇನ್ರಿ ಮತ್ತೆ?
No recovery from this petition.
18/5 ಇಂದ ಮತ್ತೆ
not even a single rupee.
When you are not recovered the amount, why his presence is required?
Acted like police officer, not as a
don't. What the petitioner counsel? He is in custody from 18/5. So why you have not recovered if really the amount of rupees 50 lakhs was paid? ಹೋಗ್ಲಿ ಏನು ಎಲ್ಲಿದ ದುಡ್ಡು ಏನ್ ಮಾಡ್ದ ಅಂತ ಏನಾರು ಹೇಳಿದಾನ ನಿಮ್ಮ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟೈಮ್ ಅಲ್ಲಿ? ಮತ್ತೆ how we can believe that he collected an amount of rupees 50,000? There must be some material. What he did after collecting an amount of rupees 50 lakhs. So, third, the petitioner counsel and also the counsel appeal to the state. The factual matters of the case of the prosecution is that the complainant in the complaint stated that he is having a clinic and his elder daughter scored 80% of marks, and in order to get the seat for MBBS, pursuing the same at that time, accused number 1 Nagaraj Tane, And accused number 1 promised that he would get the seat in MS Ramaya Medical College. And he had collected an amount of rupees 66 lakh. But he didn't get the job, the seat. And when demand was made, and room was got booked in Majestic UT Lodge. And when he was along with the said accused number 1 in different room, in the early morning at 3 o'clock, some unknown person came and knocked the door. And when he removed the opened the door, unknown persons came and threatened that raid was conducted and made the girls to stand by the side of him and snatched the gold chain, ring, and also cash of rupees 35,000. And this, and accused number 1 called one Om Prakash. And in reply, he told that he will talk to the police and demanded an amount of rupees 70 lakhs. And circumvented him to depart with money of rupees 50 lakhs. And hence he gave an amount, I agreed to give an amount of rupees 50 lakhs. And he adjusted the money and gave the money by borrowing the said amount by availing the loan. And hence case has been registered against the petitioner and also the other accused persons. The counsel appearing to the petitioner would submit that according to the prosecution, the incident was taking place in the month of January, and this complaint is given in the month of May. And there was a delay of 5 months in lodging the complaint, and hence the very case of the prosecution is doubtful. And this petitioner is in custody from 18/5/2022. The investigation almost completed and he may be enlarged on bail. The court of the counsel appearing to the state would submit that. ಈಗ ಅಲ್ಲಿಗೆ 50 ಪ್ಲಸ್ 66 ಲಕ್ಷ. ಒಳ್ಳೆ ಪ್ಲಾನ್ ಮಾಡಿದಾರ್ರಿ.
It's all A1 and A3 gross, very clear circumstances. They have recovered even certain money from
A3.
But not with respect to A4. A4, one day thing was, he was working in the place where A3 is the owner.
A3?
A3 is the owner of the lodge, my lords, where A4 is working. He's a DJ player in that lodge, my lords. So at that point of time where the incident where it happened.
Lodge belongs to A3. ಎಲ್ಲ ಲಾಡ್ಜ್ ಓನರು ಎಲ್ಲರೂ ಸೇರ್ಕೊಂಡು ಮಾಡಿರೋದು to extract the money. ತೊಳಿ okay. Let madam. The council also would submit that this petitioner was working as a DJ player in the lodge. ಹೌದಾ? Lodge run by ಆಯ್ತು full time ಬೇಡ in the A3 lodge. ಹೌದಾ? A3 lodge. And hence he may be enlarged on bail. Per contra, the council appearing to the state would submit that in all collected an amount of rupees 1 lakh 16 lakhs. And at the first instance, accused number 1 collected an amount of rupees 66 lakhs in order to get a seat in MS Ramaya College. And when the amount was, when he was insisted to pay the refund the amount, he only took this the accused number 4, complainant to the lodge and pretended that this petitioner was a police officer, and fake raid was conducted and made circumvented the complainant to part with the money of rupees 50 lakhs. And hence there is a prima facie case. Having heard the respective counsel and also on perusal of material, specific allegation is made against accused number 1 that he had collected an amount of rupees 66 lakhs in order to get the job, get the seat in MS Ramaya Medical College, and did not get the any seat. And when the demand was made to refund the amount, along with this petitioner, all of them hatched a plan, and a fake raid was conducted in the night, wherein The very same lodge, the accused number 1 was also staying on that day, and this petitioner was also in the same lodge, and by impersonation as police officer, again collected an amount of rupees 50 lakhs from complainant. In all, complainant suffered an amount of rupees 66 lakhs as well as 50 lakhs, and circumvented him in parting with money as well as the gold chain, gold ring, and also 35,000 cash was also collected. When such being the case, it is not a case for enlarging the petitioner during the crime stage, and the matter has to be probed and recovery has to be made at the instance of this petitioner also, and hence not a case for granting bail during crime stage. KV Satish Chandra. Yes. ಏನ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಲ್ಲ ಆದಂಗಿದೆ
ಅಲ್ಲ ಇದು ಕರ್ನಾಟಕ ಇದು ಅಡ್ಮಿಟ್ ಆಗೋಗಿದ್ದಾರೆ ಸ್ಪಿಟ್ ಅಪ್ ಚಾರ್ಜ್ ಶೀಟ್ ಟೈಪ್ ಆಫ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಸ್ಪಿಟ್ ಅಪ್ ದಿ ಕೇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಅಕ್ಯೂಸ್ಡ್
ಆಯ್ತು ಕೇಸ್ ಯಾವಾಗ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ
2016 ಇವಾಗ
2016 ಆಮೇಲೆ ಏನಾಯ್ತು ಆವಾಗಿಂದಲೂ ಇವ್ನು ಸಿಕ್ಕೇ ಅಲ್ವಾ
ಅದಾದ್ಮೇಲೆ ಇದು ಕಮಿಟಲ್ ಇದರಲ್ಲೇ ಅವನಿಗೆ ಸ್ಪಿಟ್ ಅಪ್ ಆಯ್ತು
ಕಮಿಟಲ್ ಬೇಡ ಮೊದಲು ಬೇಲ್ ಆಯ್ತು ಅವನಿಗೆ
ಮೊದಲೇ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್
ಬೇಲ್ ಆಗಿತ್ತು ಹೌದಾ ಯಾವಾಗ ಬೇಲ್ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು
ಅದು ಹಳೆದು ಬೇಲ್
ಗೊತ್ತಿಲ್ವಾ ಯಾವಾಗ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಆಯ್ತು ಆಮೇಲೆ ಈಗ ಬೇಲ್
ಆಯ್ತು ಸ್ಪಿಟ್ ಅಪ್ ಆಯ್ತು
ಸ್ಪಿಟ್ ಅಪ್ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ನೋಟಿಸ್ ಹೋಗಿರುತ್ತೆ ಏನಾಯ್ತು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರಲ್ವಾ
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಇವನಿಗೆ ನಾಲೆಡ್ಜ್ ಗೆ
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಅಪಿಯರ್ ಆದ್ನ ಇವನು ಇಲ್ವಾ ನೀನ್ ಎಷ್ಟು ಅಕ್ಯೂಸ್ ನಂಬರ್
ಇವನು ಒರಿಜಿನಲಿ A4 ಆಮೇಲೆ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಆಯ್ತು ಕಮಿಟ್ ಆಯ್ತು ಕಮಿಟ್ ಅಲ್ಲಿ ಕಂಡಕ್ಟರ್
ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿ ವಿಲ್ಸಿ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ಎಕ್ಸರ್ಸೈಸಿಂಗ್ ದಿ ಡಿಸ್ಕ್ರಿಷನ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಯಾವಾಗ ಬೇಲ್ ಆಯ್ತು ಎಷ್ಟು ಎಲ್ಲಿವರೆಗೂ ಅಪಿಯರ್ ಆದ ಆಮೇಲೆ ಯಾವಾಗ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರ್ತದೆ ಆರ್ಡರ್ ಶೀಟ್ ಕಾಪಿ ಹಾಕಿ ಕನ್ಸಿಡರ್ ಇಟ್ petitioner counsel is directed to place the order sheet ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕೌನ್ಸಲ್ 10 days ಬೇಕಾ ಒಂದು ಆರ್ಡರ್ ಕಾಪಿ ತಗೊಳಕ್ಕೆ ಯಾವ ಊರು ಶಿವಮೊಗ್ಗ ಆಯ್ತು ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರೆ ತರ್ತಾರೆ ಆಯ್ತು ನಿಮ್ಗೆ ಬೇಕು 10ನೇ ತಾರೀಕಿಗೆ ಕೊಡೋಣ ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಹಂಗ್ ಮೂವ್ ಮಾಡಕ್ಕಲ್ಲ ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ ಅವತ್ತು ಆಗ್ಲಿಲ್ಲ ಅಂತ ಟೈಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 11th ಹಾಕಿರ್ತೀನಿ 11th ಗೆ ಮಂಡೆ ಒಳಗೆ ತರ್ಸ್ಕೊಂಡು 84 ಶ್ರೀಧರ ಕೆ
439 offense under section 307 injuries on only
427 injuries
only on in the right wrist and lacerated wound over the elbow and injuries are simple in nature. Accused number 1 is already advised by the Honorable Court on 27 June 2022.
ನೀವನ್ನ ಕೊಡಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ
against unknown persons. Page number 4, para 6.
ಸೇಮ್ ಆರ್ಡರ್ ಓನ್ಲಿ ಇದು ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 4 to 7 ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನು
Second number 2 my last.
A2 ನಾ ಈಗ A1 ಎನ್ಲಾರ್ಜ್ ಆಗಿದೆ ಅದನ್ನ ಹೀಗೆ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್ ದೀಸ್ ಟೂ ಪಿಟಿಷನ್ಸ್ ಆರ್ ಫೈಲ್ಡ್ ಬೈ ಅಕ್ಯೂಸ್ ನಂಬರ್ 4 to 7 and accused number 2 and seeks regular bail in respect of crime number so and so in madam now 41 of 22. The factual matters of the case of the prosecution is page number 3. Current counsel was submit that case was registered against unknown persons and these petitioners have been falsely implicated in the case. The counsel also submit that accused number 1 already granted bail in petition number 5094 of 2022 and only an allegation that while proceeding in the vehicle galata has taken place and no nature of any no motive to take away the life of the complainant and the injuries are also simple in nature and just for count of the counsel appearing to the state which submits that The allegation is very clear that they were holding deadly weapons like iron rod and also long gun. Though they were unsuccessful in taking away the life from her, they made a to take away the life with deadly weapons. Hence there is a prima facie case. ಬಾಕಿದೆಲ್ಲ reasons ಅದೇ ಸೇಮ್ ಮಾಡ್ಕೊಳ್ಳಿ. And also this court already granted bail in favor of appeal number 1 in petition number 5094 of 22, wherein an observation is made that the nature of injuries are also simple in nature and medical only they try to inflict injury on the complainant. Baki reasons are the same with conditions. I think simple injuries again. Petitions are allowed with conditions. 85, ಹೇಳಿ 85. Criminal petition. ಏನು interlocutory application ಇದೆ, recalling the order dated 18/4/22.
Prakash was appearing, my lord. He was not well, my lord. He could not appear. This court appointed Allah, Mrs. Allah as amicus curiae.
ಏನ್ರಿ ಅವರು ಸೋನಿಗಳನ್ನು ಬರ್ತಾ ಇಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಲೆಟ್ ಹಿಮ್ ಗಿವ್ ಅಸಿಸ್ಟೆನ್ಸ್ ಅಷ್ಟೇ. But the petitioner counsel and also the counsel appearing to this state. When an application is filed on 482 of CRPC to recall the order dated 18/4/22 appointing Srimati Swani Holla as amicus curiae, the counsel will submit that advocate on record Mr. K.N. Jayaprakash is not in a position to attend court in view of his ill health. And hence he could not appear before the court. And this court appointed amicus curiae. ನೀವೇ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲಿ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದರಲ್ಲಿ ಹಾಕಿದ್ದೀವಿ.
The counsel also on record had filed wakalat along with an affidavit, and having taken note of the reasons assigned in the application, he is allowed and earlier order dated so is thereby recalled. And the petitioner counsel is permitted to assist the court and list this matter on ಯಾವ ತರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಏನಕ್ಕೆ ಇದು 439?
Was is accused number 2, my lord.
ಅಷ್ಟೇ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. ಐ ಇಸ್ ಅಲೌಡ್. ಈಗೇನು ರೆಡಿ ಇದೀರಲ್ಲ ಇಬ್ರು? ಏನಿಲ್ವಾ? IML ಅಂತ ತಂದಿಲ್ವಾ? ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಫಾಸ್ಟ್ ಓವರ್ ಇದೆಯಾ? 43 ಶಂಕರಪ್ಪ ಪಾಟರ್ಡ್. ಏನ್ರಿ ಇದು ಪಾಟರ್ಡ್? ವೈ ಇಟ್ ವಾಸ್ ಪಾಟರ್ಡ್? ಬೋಗಸ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಆಸ್ ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಅಂಡ್ ಗ್ರ್ಯಾಂಡ್ ಡಾಟರ್ ಅಂತ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಟ್ಸ್ ಏನಾರು ಇದೆಯಾ ನೋಡಿ. ಪಿಟಿಷನರ್ 420. Right, anyhow, we will give one more opportunity. ಇನ್ನು ಯಾವ್ದಾರು ಇದೆಯಾ ಮೇಡಮ್ ಬೇರೆ? ನೋಡಿ, petitioner counsel absent in the early morning and also in the afternoon, and in the early previous occasion matter was urgent and on his request, and hence one more opportunity is given to the petitioner counsel. If counsel doesn't appear in the next date of hearing, matter will be dismissed for non-prosecution. This matter on 11th July. Dr. Shiva Prasad, yes. ಯಾವ್ದು ಬರೋದಿಲ್ಲ ಬಿಡಿ. 376 ಪೋಕ್ಸೋ. ಏನಾಗಿದೆ ಇದು ಮೇಡಮ್? Petitioner counsel is absent and this matter is called twice in the this matter is called twice. This matter is called twice in the early morning and also in the afternoon. No representation on behalf of the petitioner. The counsel was also absent in the earlier date of hearing on 27/6/22. ನೋಟಿಸ್ ಆಯ್ತಾ? ಹೇಳಿ ಸಫಿಶಿಯಂಟ್ ಆಗಿದೆ. ಆಯ್ತು ತಗೊಳ್ಳಿ. However, in the ends of justice, one more opportunity is given to the petitioner counsel.
Support ಇದೆ ಅದಕ್ಕೆ
ಇದಕ್ಕೆ ಬಂದಿಲ್ಲ. ಆಯ್ತು. List this matter on 11th. ಚೇತನ್ ಹೇಳ್ರಿ.
Case number 1, my lord. But offense is petitioner is 364, 376, 504, 506, and provisions of POCSO Act, Child Marriage Act. But the victim age, my lord, the date of police incident is, my lord, 17 years, 8 months. But as per the 164 statement also, my lord, page number 46, they knew each other, my lord, since page number 46. Chidananda, my lord, they knew each other from past 4 years, and according to our statement, my lord, she was love with her. ಮದ್ವೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಮದುವೆ ಆದ್ಮೇಲೆ ಮದುವೆ ಮಾಡ್ಕೊಬಿಟ್ಟವ್ರ? ಇಲ್ಲೇನೋ ಹೇಳ್ತಾನ್ರಿ. ಆತ ನಾನು ಕರೆದುಕೊಂಡು ತುರುವೇಕೆರೆ ತಾಲೂಕಿನ ಮಾಚನಹಳ್ಳಿ ಗ್ರಾಮದ ಕೆರೆಕೋಡಿ ಬಸವಣ್ಣ ದೇವಸ್ಥಾನಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋದನು. ನಾವು ಹೋದ ನಂತರ ಆತನ ಚಿಕ್ಕಪ್ಪ ಕಾಂತರಾಜು ಮಾವಂದಿರಾಜು ಬಂದರು. ಚಿದಾನಂದ ನನಗಾಗಿ ಸೀರೆ, ಬಳೆ, ಕಾಲುಂಗರ ಮತ್ತು ತಾಳಿಯನ್ನು ತಂದಿದ್ದನು. ನಾನು ಸೀರೆ ಉಡುತ್ತಿದ್ದರೆ ನಾವಿಬ್ಬರು ಕೆರೆಗೆ ಹೋಗಿದ್ದು ಸಾಯೋಣ ಎಂದು ಹೇಳಿದಾಗ ನಾನು ಭಯದಿಂದ ಸೀರೆ ಉಟ್ಟು ಬಳೆ ತೊಟ್ಟು ಹೂ ಮುಡಿದುಕೊಂಡೆನು. ಕೋರ್ಸ್ ಅಂತ ಆಯ್ತು ನನಗೆ. ನಂತರ ಚಿದಾನಂದ ನನ್ನ ಕೋಡ್ಲಿಗೆ ತಾಳಿ ಕಟ್ಟಿ ನನಗೆ ಕಾಲುಂಗರ ಧರಿಸಿ ನಾವು ಪರಸ್ಪರ ಹೂಹಾರ ಬಳಸಿಕೊಂಡು ಮದುವೆ ಆದೆವು. ಆ ದೇವಸ್ಥಾನಕ್ಕೆ ಕೆಲವು ಬೇರೆ ಜನ ಬಂದಿದ್ದವರೆಗೂ ಭಯ ಹುಟ್ಟಿಸಿದರು. ದೇವಸ್ಥಾನಕ್ಕೆ ಕರ್ಪೂರ ಹಚ್ಚಲು ಬಂದಿದ್ದ ಯಾರೋ ಒಬ್ಬ ಗಂಡಸಿನಿಂದ ತಾಳಿ ಕಟ್ಟುವ ಮತ್ತು ಹೂಹಾರವನ್ನು ಬದಲಾಯಿಸಿಕೊಳ್ಳುವ ಫೋಟೋ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಬಲವಂತವಾಗಿ ಕೂರಲು ಹೇಳಿದಾಗ ನಾನು ಕಾರಿನಲ್ಲಿ ಕುಳಿತೆನು. ನಾನು ಜೋರಾಗಿ ಹತ್ತಾಗ ನನಗೆ ಕುಡಿಯಲು ಜ್ಯೂಸನ್ನು ನನಗೆ ಕೊಟ್ಟರು. ನಾನು ಅದನ್ನು ಕುಡಿದಾಗ ನಿದ್ದೆ ಜಾರಿದೆ. ನಾನು ನಿದ್ದೆಯಿಂದ ಕಣ್ಣು ಬಿಟ್ಟು ನೋಡಿದಾಗ ಯಾವುದೋ ಒಂದು ಕೋಣೆಯಲ್ಲಿದ್ದರು. ಸದರಿ ಕೋಣೆಗೆ ಬೀಗ ಹಾಕಲಾಗಿದ್ದು. ಬೀಗ ನನ್ನ ಕೋಣೆಯಲ್ಲಿದ್ದನು. ಅದನ್ನು ಕೂಡ ಹಂಗೆ ಹೇಳ್ತಾನ. ಫೋರ್ಸ್ಫುಲಿ ಮ್ಯಾರಿಡ್ ಅಂತ ಮೆಡಿಕಲ್ ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದಾರ? ಅಟ್ಟ ಮುಂದೆ ಹಾಗೆ ಹೇಳಿದ್ದಾನೆ.
ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ರಂತ.
ಅಸಾಲ್ಟ್ ಆಲ್ಸೋ. Victim went with accused in bike. So. Kodi Basavanna temple. Forcefully married. Bangalore on 28/21. Poisoned. Prisoned. Yenadu home prison. Assaulted for 1 week and with hand and verbally abused. Victim returned home on 25/21 and parents lodged complaint on 22/10/21. Patient has changed. Parents, my lord, both of families, my lord, they have even in the voluntary statement also, my lord. But she says that, my lord, ಮದ್ವೆ ಆಗೋಗಿದೆ, ಇನ್ನ ಜೀವನ ಇದು ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದೆ, my lord. It is part of page number 48. No, you see where she is. Lord, she is ready to go.
ಎಲ್ಲಿದ್ದಾರೆ?
No, where she is in the matrimonial home or
parental house.
Parental house. ಮತ್ತೆ ಪೇರೆಂಟ್ಸ್ ಎಲ್ಲ ಇಟ್ಕೊಡ್ತಾರೆ, ಈಗ ಕರ್ಕೊಂಡಿದಾರ?
Since he is in judicial custody.
ಅವನು ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ ಇರ್ಲಿ, ಇವನ್ನ ಇಟ್ಕೊಳ್ಳಿ ಮತ್ತೆ ಅಷ್ಟೊಂದಿದ್ರು ಮನೆಯಲ್ಲಿ.
Monday it may be taken up.
ಅಲ್ವಾ?
Monday.
ಮತ್ತೆ ಈಗ ಅವ್ನು ಹೊರಗ್ ಬಂದ್ಮೇಲೆ ಕೈ ಎತ್ತಿರೋ ಅವನಿಗೆ ಅಲ್ವಾ? Our intention is to see that let them live happily. Anyhow they have committed the blunder, but let them live with peaceful mind. ಅಲ್ವಾ? ಹೊರಗ್ ಬರೋವರೆಗೂ ಒಂಥರ ಮಾಡಿ ಆಮೇಲೆ ಇದ್ ಮಾಡೋದಲ್ಲ. ನಿಮ್ಮ ಕರ್ಕೊಂಡೋಗಿ ಇಟ್ಕೊಳ್ಳಿ ಮನೇಲಿ, ಆಮೇಲೆ ಕಲ್ಸಿದಾರೆ ಆಗ್ಬೋದಾ? ನಮ್ ಕೆಲಸ ಏನಾದ್ರು ಒಟ್ಕೊಡ್ಸೋದು, ಬೇರೆ ಮಾಡೋದ್ ಬೇಡ. ಬಟ್ ಇಲ್ಲಿ ಅಲಿಗೇಷನ್ ಇದೆ, ಫೋರ್ಸ್ಫುಲ್ ಮ್ಯಾರೇಜ್. If no such allegation, then I would have. ಯಾವ್ದು 11th ಹಾಕೋಣ? 13th part. ಮೇಲ್ಗಡೆ ಇರಲಿ. 13 part dismiss matter on 11th. 58 ಯಾವ 58 ಇದ್ರದ್ದ ಕೊಟ್ರ ತಂದ್ರ ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ ಅಂದ್ರೆ ACR ಎಲ್ಲ ಇದೆ ತಾನೇ ಅದರಲ್ಲಿ? ACR ಎಲ್ಲ ಇದೆ. ACR ಅಲ್ಲಿ ಏನಿದೆ ನಿಮ್ ಪ್ರಕಾರ? ಅರ್ಲಿಯರ್ ಇದೆ ಹೇಳಿ. SP ಆಗಿದ್ದಾಗಿದೆ ನೋಡ್ರಿ ಇಲ್ವಾ? CBI ರೈಡ್ ಆಗಿದೆ ನೋಡಿ, ಆಗಿದೆಯಿಲ್ಲ ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ ಹೇಳಿ, ನೀವೇ ಹೇಳಿ ನೋಡೋಣ. ನೋಡ್ಕೊಂಡೆ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ, ನಾನು ಫ್ರೀಯಾಗಿ ಕುತ್ಕೋತೀನಿ ಒಂದು ಅರ್ಧ ಗಂಟೆ, ನಿಮ್ಮ ಬಾಯಿಂದಲೇ ಕೇಳೋಣ ಅಂತ. ಫಸ್ಟ್ ಯಾವ್ದು? ಅಸ್ಮತ್ ಪಾಸ್ ಅವ್ರದ್ದು ಒಂದು ಇದೆಯಾ? ಅದನ್ನ ಕೇಳ್ತಾ ಇರೋಣ. ಯು ವೆರಿಫೈ and submit with regard to what are all his antecedents, ಏನೇನಾಗಿದೆ ಅಂತ ಆಯ್ತಾ? ಅಲ್ಲ ಅವ್ರದಲ್ಲ, ಅಸ್ಮತ್ ಪಾಸದಲ್ಲ, ಅವ್ರದ್ದು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನೋಡಿ ಎಲ್ಲ ಹೆಂಗಿದೆ ಅಂತ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೀ ಇಸ್ ಎ ಟೈಂಟೆಡ್ ಪರ್ಸನ್. ಏನೇನಿದೆ ನೀವೇ ಓದಿ ಹೇಳಿ ನೋಡೋಣ, ತಿಳಿಸಿ. ನೀವು DPRನರ ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಲ್ವ? ಒಬ್ಬರನ್ನ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕಾರೆ ಆಫೀಸರ್ನ, ಈಗ ಯಾರು ಒಬ್ಬರನ್ನ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಒಂದು ಪೋಸ್ಟ್ಗೆ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ACB ಇದೆ, ಆಂಟಿ ಕರಪ್ಷನ್ ಬ್ಯೂರೋ, ಹೌದಲ್ಲ? ಆಂಟಿ ಕರಪ್ಷನ್ ಬ್ಯೂರೋನಲ್ಲಿ ಮನುಷ್ಯ ಬಹಳ ಸ್ವಚ್ಛವಾಗಿದ್ದನು, 200% ಚೆನ್ನಾಗಿದ್ದನ್ ಬೇಕು, ಹೌದಲ್ಲ? ಯಾಕೆ ವೈ ಯು ಪೀಪಲ್ ಆರ್ ನಾಟ್ ಎಕ್ಸಾಮಿನಿಂಗ್ ದಿಸ್? DPR ನಲ್ಲಿ ಇದನ್ನೆಲ್ಲ ನೋಡ್ತಿರ್ತಾನೆ ಬಿಫೋರ್ ಪೋಸ್ಟಿಂಗ್. ನಿಮ್ಮೇಲೆ ಮಾಡೋಣ ಪೊಲಿಟಿಕಲ್, ಅದೇ ಹೇಳಿದ್ದು, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಅಂತವ್ರನ್ನ ಯಾಕೆ ಬಿಡ್ಬೇಕು ನಾವು? ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಪ್ರೆಷರ್ ಇರ್ತದೆ, ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ. ಇವ್ರ ಪಾಪ ಏನ್ ಮಾಡ್ತಾರೆ? ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ ಏನೇ ಇದ್ರು. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ನೋಡಿ, ಸ್ವಲ್ಪ ರಿಪೇರಿ ಮಾಡೋಣ, ವ್ಯವಸ್ಥೆ ಸರಿ ಮಾಡಕ್ ಪ್ರಯತ್ನ ಮಾಡೋಣ. ನಮ್ ಕೈಲಾಗಿದ್ದು. ಯು ಆಲ್ಸೋ ಅಸಿಸ್ಟ್ ರಿಪೋರ್ಟ್, ಯು ಗೋ ಥ್ರೂ ದ ಫೈಲ್, ಅಡ್ವರ್ಸ್ ಏನೇನಿದೆ ನೋಡಿ. ಈಗಿಲ್ಲ, ರೀಸೆಂಟ್ ಆಗಿಲ್ಲ. ರೀಸೆಂಟ್ ಆಗಿದ್ರೆ ಈ ಮ್ಯಾನೇಜ್ ಎವ್ರಿಥಿಂಗ್. ಹಿ ಇಸ್ ವೆರಿ ಪವರ್ಫುಲ್ ಅಂತ ನಾರ್ತ್ ಇಂಡಿಯಾ. ಇವನ್ ಹಿ ಕ್ಯಾನ್ ಗೆಟ್ ದಿ ಟ್ರಾನ್ಸ್ಫರ್ ದಿ ಜಡ್ಜ್ ಆಲ್ಸೋ. ನೋಡಿ ಸಬ್ಮಿಷನ್ ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ ನೋಡೋಣ. ಪವರ್ಫುಲ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಥವಾ ಅವನ ಅಂತ ನೋಡೋಣ. ಹೇಳಿ 79 ರೆಡಿನಾ? ಡಿವಿಷನ್ ಬೆಂಚ್ ನೀವೇ ಮಾಡಿ ಸಾಕು, ನಮ್ಗೇನ್ ಸೀನಿಯರ್ ಬೇಡ. ಅಫೆನ್ಸ್ ಏನಿರು 406, 409, 420 ಅದ. ಕಾರ್ಯಪ್ಪ ಅಂಡ್ HP ಯೂನಿಕ್. ಯಾರಿದು ಕೌನ್ಸಲ್? ಅಸ್ಮತ್ ಪಾಸ್ ಅವ್ರದ್ದು. ನೀವು ಓದ್ಕೊಂಡು ನೀವೇ ಹೇಳಿ. ಕೇಸ್ ಇದ್ರೆ ಕೊಡೋಣ, ಇದ್ದವ್ರು ಇಲ್ಲ. ಸೀನಿಯರ್ ಬಂದ್ರೆ ಆರ್ಡರ್ ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ. ವೈ ಯು ನಾಟ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್? 406, 409 ಕೊಡಿ ನೋಡೋಣ ಏನಿದೆ ಅಂತ. ಸೀರಿಯಸ್ ಇದೆಯೇನ್ರಿ? ಅದಕ್ಕೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. ಇದು 439 ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ. ಅಂಬೇಡ್ಕರ್ ಅಭಿವೃದ್ಧಿ ನಿಗಮನ? He himself has transferred the amount from the corporation amount. ಅಂಬೇಡ್ಕರ್ ಇವ್ರ ಅಕೌಂಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿರೋದು. ಟೋಟಲ್ ಟು ದಿ ಟ್ಯೂನ್ ಆಫ್ ₹5 crores. ಟ್ರಾನ್ಸ್ಫರ್ಗೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ? Now it is crime stage. He is in custody from which state? ಯಾರು ಎಸಿದ್ಯಾರ? ಇನ್ನು ತಗೊಂಡಿಲ್ವಲ್ಲ, ಆಮೇಲೆ ಬರಲಿ. ಫಲಾನುಭವಿಗಳಿಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ. 22 persons. They are not the real beneficiaries. ಒಟ್ಟು ಮೊತ್ತ 4 crores 20 lakhs 23,872. Within 1 year. Why you have not read the papers? Whether your senior permits you to read the papers or not? Huh? What is this? Huh? Huh. No other beneficiaries are also made as accused. Like 90 lakhs was seized. It was in the account. Now it is freezed. Around 3 crores 30 lakhs. Good. Petitioner counsel seeks time this matter on. Next time ಕೇಳಿದ್ರೆ ಕೊಡೋದಿಲ್ಲ. Last time ಏನಾಗಿದೆ ನೋಡಿ ಆಟೋ ಶೀಟ್ ಮೇಡಮ್. Last time time ಕೇಳಿದಾರ first time. Right, petitioner counsel the junior counsel seeks time on the ground that senior counsel is engaged in other court and hence list this matter on 11th. ಮುಗೀತಾ ಮೇಡಮ್? ಎಲ್ಲ ಮುಗೀತಾ? ಎಲ್ಲರೂ ಹೋಗಿ ಒಳಗಡೆ ಹೋಗಲ್ವ ಅಂತ ತಲೆಗೆ? ನೋಡಿ ಏನನ್ರಿ ಮನ್ಮೋಹನ್ ಅವ್ರು ನೋಡ್ತಾ DPR ನವರೇ ನೋಡ್ತಾವ್ರ? As an advocate, sir, when you are a special counsel, you should advise them properly. Alva? ನಿಮ್ಗೆ ಯಾವ್ದೋ ಸೆಕೆಂಡ್ ಟೈಮ್ ಇದು, ಇನ್ನೊಂದು ಯಾವಾಗ್ಲೋ ಯಾವ್ದೋ ಒಂದು ಮ್ಯಾಟರ್ ಏನೋ ಹಿಂಗೆ ಆಗಿತ್ತು. ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಓಡ್ ಬಂದ್ರು, ಅವ್ ಯಾವ್ದೋ ಒಂದು ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಓಡ್ ಬಂದ್ರು, ಯಾವ್ದೋ ಒಂದು ಮ್ಯಾಟರ್ ಮೋಸ್ಟ್ಲಿ ನೀವೇ ಅಪಿಯರ್ ಆಗಿದ್ರಿ ಯಾವ್ದೋ ಕೇಸ್. ಹಾಗೆ ಆಯ್ತು. ಅದ್ ಯಾವ್ದೋ ಒಂದು ಎಂತದೋ ಒಂದು ಕೇಸ್ ಇತ್ತು ನೋಡಿ, ಯಾವ್ದೋ 5 ಕೇಸ್ ಹಾಕಿದ್ರಲ್ಲ ಯಾರ್ದೋ ಒಬ್ಬನ ಮೇಲೆ. ಅದ್ರಲ್ಲೂ ಹಂಗೇನೆ ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಮಾಡಿ ಸ್ಟೇ ಆಗಿ, ಕನ್ಸೆಂಟ್ ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟು ಸ್ಟೇ ಆಗಿ, ಆಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ತಗೊಂಡೋಗಿ ಏನೇನ್ ಆಯ್ತಲ್ಲ ಅದು. ಆ ತರದ್ದು ಎನ್ಕರೇಜ್ ಮಾಡಬಾರ್ದು. ಈಗ ನೋಡಿ ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ, ನೀವು ಒನ್ಸ್ ಯು ಹ್ಯಾವ್ ಗಿವನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಯು ಆರ್ ಬೌಂಡ್ ಬೈ ಇಟ್. ಮತ್ತೆ ಅದರ್ವೈಸ್ ಯು ವುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಗಿವನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅಲ್ವಾ? ಈಗ ನಾವು ಯು ಆರ್ ದಿ ಸಾರಿ ಸ್ಟೇಟ್ ಆಫ್ ಅಫೇರ್ಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ನೋಡ್ರಿ ನನಗೂ ಏನ್ ಪರ್ಸನಲ್ ಇದೇನಿಲ್ಲ. ಏನೂ ಇಲ್ಲ, ನಮ್ ಕೈಲಿ ಆಗಿದ್ದನ್ನು ಒಂಚೂರು ಸಮಾಜದಲ್ಲಿ ಸರಿ ಮಾಡೋಣ ಅಂತ ಪ್ರಯತ್ನ ಬಿಟ್ರೆ ನಾನು ನೋಡ್ರಿ ಕೋರ್ಟ್ ಕೇಸ್ ಆದ್ಮೇಲೆ ಅದ್ ಮರ್ತ್ಬಿಡ್ತೀನಿ. ನಾನು ಅದನ್ನ ಇಟ್ಕೊಳ್ಳೋದೇ ಇಲ್ಲ ತಲೆಗೆ. ಅದರ್ವೈಸ್ ಐ ವಿಲ್ ಬಿಕಮ್ ಮ್ಯಾಡ್. If anything is happened in my court, if he carries that, I will become mad. ಹೋಗಿಲ್ಲ ನಮ್ಗೇನು ಅಂದ್ರೆ ನನಗೂ ಏನು ಅಂದ್ರೆ ಹಂಗ ಆಗ್ಬಾರ್ದು. ಯಾಕೆ that's why other day itself I gave a hint to you. You are all upcoming advocates, including you, Pannan and all. Now he has stage 1 level. But ಆದ್ರೂನು ಮ್ಯಾಟರ್ ಆಫ್ ಸೊಸೈಟಿ ಅಲ್ವಾ? ನಮಗೆ ಸೊಸೈಟಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನಿಲ್ಲ. ಓನ್ಲಿ ಸೊಸೈಟಲ್ ಇಂಟ್ರೆಸ್ಟ್, ದಟ್ಸ್ ಆಲ್. ನಾಟ್ ಎನಿ ಅದರ್ ಇದಿಲ್ಲ ನಮ್ಗೆ. ಏನಂದ್ರೆ ಇಂಥ ಕೇಸ್ಗಳು ಬಂದಾಗ ನೀವು ಸೂಕ್ಷ್ಮವಾಗಿ ವೈ ಕೋರ್ಟ್ ಈಸ್ ಟೇಕಿಂಗ್ ಪೇನ್ ಅನ್ನೋದನ್ನ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ಅಲ್ವಾ? ನನಗೇನ್ ಕೂತ್ಕೊಂಡು ಇವೆಲ್ಲ ಓದಿ ಮಾಡಿ ತರೋಂಥದ್ದು ನನಗೇನಿಲ್ಲ. ಆಕ್ಚುಲಿ ದಟ್ ಈಸ್ ಯುವರ್ ಜಾಬ್. ದಟ್ ಈಸ್ ಯುವರ್ ಜಾಬ್, ACB ಜಾಬ್. ಯು ಶುಡ್ ಸೇ ದಿಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಗಾಟ್ ಪವರ್ಸ್ ಟು ಡೂ ಆಲ್ ದಿಸ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಯಾಕೆಂತಂದ್ರೆ ಇಟ್ ಈಸ್ ಎ ಡಿಸೀಸ್ ಟು ದಿ ಸೊಸೈಟಿ. ನಾವು ರಿಪೇರಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ ಆಗ್ತದೆ. ಇಟ್ ವಿಲ್ ಬಿ ಕಂಟ್ರೋಲ್ ಆಗಲ್ಲ. ಇನ್ಆಕ್ಷನ್ ಇದ್ದಾಗ ಯು ಶುಡ್ ಸಪೋರ್ಟ್ ದಿ ಕೋರ್ಟ್. ದಟ್ಸ್ ವಾಟ್ ಐ ಎಕ್ಸ್ಪೆಕ್ಟ್. ಇಲ್ಲ ಹಂಗಿದ್ರೆ ನೀವು ಹೇಳ್ಬೇಕು, ನಾನು ಐ ಆಮ್ ನಾಟ್ ಸೂಟಬಲ್ ಟು ಯು ಅಂತ ಹೇಳ್ಬೇಕು. ಐ ಆಮ್ ನಾಟ್ ಸೂಟಬಲ್ ಟು ACB ಬಿಕಾಸ್ ಆಫ್ ಯು ಪೀಪಲ್. ಇಲ್ಲ ಐ ಲಾಸ್ಟ್ ಮೈ ಕ್ರೆಡೆನ್ಸ್ ಅಂತ ಹೇಳ್ಬೇಕು. ದಟ್ ಶುಡ್ ಬಿ ದಿನ್ ಅಡ್ವೊಕೇಟ್. ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಗೊಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಟ್ಟೆ. ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಅದಕ್ಕೆ ನಿಮ್ಗೊಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಟ್ಟೆ. ನಾನು ಬಿಗಿನಿಂಗ್ ಆಫ್ ಕರಿಯರ್ ನಾನು ಐ ವಾಸ್ ವಿತ್ ಸೀನಿಯರ್ ಅಬೌಟ್ 7 years. ನಾನು ಸೀನಿಯರ್ ಆಫೀಸಿಂದ ಹೋದಾಗ ನನಗೆಲ್ಲ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಬರ್ತೀನಿ ಬ್ರೀಫ್ಸ್ ಅಂದ್ರು. ನಾನು ಅದಕ್ಕೆ ಹೇಳಿದೆ, ನೋ ಐ ವಿಲ್ ನಾಟ್ ಫೈಲ್ ಎನಿ ಸಿಂಗಲ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಫ್ರಮ್ ಮೈ ಸೀನಿಯರ್ ಆಫೀಸ್ ಅಂತ ಹೇಳಿ, ನಿಮ್ಗೆ ಅಷ್ಟು ನಂಬಿಕೆ ಇದ್ರೆ ನನ್ನ ಮೇಲೆ ಕೇಸ್ ತಗೊಬನ್ನಿ ಅಂತ ಹೇಳಿದೆ. ಅದಕ್ಕೆ ಬಿಗಿನಿಂಗ್ ಆಫ್ ಮೈ ಕರಿಯರ್ ವಿತಿನ್ ನಾನು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಎಕ್ಸಾಮ್ 10ನೇ ತಾರೀಕು ಬರ್ದು 17ನೇ ತಾರೀಕು ನಾನು ಆಫೀಸ್ ಓಪನ್ ಮಾಡಿದವನು. ಅವತ್ ನನ್ನ ಸೀನಿಯರ್ ಬಂದು ಹೇಳ್ಬಿಟ್ರು, ಯು ವಿಲ್ ನಾಟ್ ಬಿ ಹಿಯರ್ ಫಾರ್ ಕೆ ಅನಂತರಾಮಯ್ಯ ಅಂತ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಅಟ್ ಹಾಸನ್ ಅಂತ ಹೇಳೇ ಬಿಟ್ರು. ಇಲ್ಲ ಯು ವಿಲ್ ನಾಟ್ ಬಿ ದೇರ್ ಇನ್ ದಿಸ್ ಆಫೀಸ್ ಫಾರ್ ಲಾಂಗ್ ಟೈಮ್ ಅಂತ ಹೇಳಿದ್ರು. ಎಕ್ಸಾಮ್ ಬರ್ದು ನಾನು ಆಫೀಸ್ ಮಾಡಿದ್ದೆ 10ನೇ ತಾರೀಕು ಒಂದ್ ಸಂಡೇ ಎಕ್ಸಾಮ್ ಬರ್ದೆ. 17th ನಾನು ಆಫೀಸ್ ಓಪನ್ ಮಾಡಿದೆ ಮಲ್ಲೇಶ್ವರಂ ಅಲ್ಲಿ. ಬಂದಾಗ ಅವರೇ ಆಗಂತ ಹೇಳೋದ್ರು. ನನ್ಗೂ 6 ತಿಂಗಳಲ್ಲಿ ಯಾರೋ ನನಗೆ 7 ಬ್ರೀಫ್ ಇತ್ತು ಕ್ಲೈಂಟ್ ಇಂದ. ಅವ್ನು ಬಂದು ಹೇಳ್ದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವೆಲ್ಲ ಕೇಳಿದ್ರಿ. ನಾನು ಅದಕ್ಕೆ ವಾಪಸ್ ಐ ಸೆಂಟ್ ದಿ ಆಲ್ 7 ಫೈಲ್ಸ್ ವಾಪಸ್ ಕಳಿಸ್ಬಿಟ್ಟೆ. ಈ ತರದ ಬ್ರೀಫ್ ನಂಗೆ ಬೇಡ ಅಂತ. ನನ್ಗೆ ಅನ್ಸದ. ಬಟ್ ಈಗ ಏನಾಗ್ತದ ಗೊತ್ತೇನ್ರಿ, ಈ ತರದ್ ಮಾಡಕ್ ಕೆಲ್ಸಗಳಿಂದ, ಇವ್ರು ಮಾಡಕ್ ಕೆಲ್ಸಗಳಿಂದ ನಿಮ್ಮ ರೆಪ್ಯುಟೇಷನ್ ಅಲ್ವಾ? ನಿಮ್ಗಳ ರೆಪ್ಯುಟೇಷನ್ ಹೋಗ್ತದೆ. ನೀವು ಮುಂದೆ ಒಳ್ಳೆ ಬ್ರೈಟ್ ಫ್ಯೂಚರ್ ಇರೋರು ಮಾಡ್ಬೇಕು. ಯಂಗ್ಸ್ಟರ್ಸ್ ಶುಡ್ ಸಪೋರ್ಟ್ ದಿ ಕಾಸ್ ಆಫ್ ಜಸ್ಟಿಸ್. ಕಾಸ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ನಾವೇನ್ ಓದ್ಕೊಂಡು ಹೋಗಲ್ಲ, ಹೋಗುವಾಗ ಬರುವಾಗ ಬೆತ್ಲೆ, ಹೋಗುವಾಗ ಬೆತ್ಲೆ. ಏನಾರು ತಗೊಂಡೋಗ್ತೀವ? ಇಲ್ಲ, ಏನಾದ್ರು ಸಮಾಜಕ್ಕೆ ಕೊಟ್ಟು ಹೋಗ್ಬೇಕಷ್ಟೆ. ಅಲ್ವಾ? ನಾವೇನ್ ತಗೊಂಡೋಗೋದಿಲ್ಲ. ಈಗೆಲ್ಲ ಸುಮ್ನೆ ಹೊಡಿತಾರಲ್ಲ ಕೋಟಿ ಗಟ್ಲೆ, ಏನ್ ಹೊಡೆದ್ ಹೊತ್ಕೊಂಡ್ ದಿವ್ಸ ತಗೊಂಡೋಗ್ತಾರ. ಎಲ್ಲ ಇಲ್ಲಿ ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ. ಮಕ್ಳು ಮರಿ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಎಂಜಾಯ್ ಮಾಡ್ಲಿ ಅಂತ. ಅದಲ್ಲ, ಮಕ್ಳು ಮರಿಗೆ ಒಳ್ಳೇದ್ ಕಲ್ಸ್ಬೇಕು, ವಿದ್ಯೆ ಕೊಡ್ಲಿ, ಸಂಸ್ಕಾರ ಕೊಡ್ಲಿ, ಸಾಕು. ಅವ್ರಿಗೆ ವಿದ್ಯೆ ಕಲ್ಸ್ಬಿಡ್ಬೇಕು. ಕೆರ್ಕೊಂಡ್ ತಿನ್ನೋಪ್ಪ ನೀವೇ ಅಂತ ಬಿಟ್ಬಿಡ್ಬೇಕು. ಕೆರ್ಕೊಂಡ್ ತಿನ್ನೋದಂದ್ರೆ ಶ್ರಮ ಮಾಡಿ, ಹಾರ್ಡ್ ವರ್ಕ್ ಮಾಡಿ, ಹಾರ್ಡ್ ವರ್ಕ್ ಇಂದ ಮೇಲೆ ಬನ್ನಿ ಅಂತ ಹೇಳ್ಬೇಕು. ಐ ಡೋಂಟ್ ನೋ ವೆದರ್ ಯು ಆರ್ ಸೆಕೆಂಡ್ ಜನರೇಷನ್ ಅಡ್ವೊಕೇಟ್ ಆರ್ ಫಸ್ಟ್ ಜನರೇಷನ್ ಅಡ್ವೊಕೇಟ್. ಸೆಕೆಂಡ್ ಜನರೇಷನ್. ನಿಮ್ಗೆ ಪೊನ್ನಣ್ಣ ಇಂಥವ್ರಿಗೆಲ್ಲ ಕಷ್ಟ ಆಗಲ್ಲ. ಇವನ್ ವಿವೇಕ್ ಕೂಡ ಮೊನ್ನೆ ಬಂದಿದ್ರು, ಅವ್ರಿಗೆಲ್ಲ ಕಷ್ಟ ಆಗಲ್ಲ. ಫಸ್ಟ್ ಜನರೇಷನ್ ಅಡ್ವೊಕೇಟ್ ಬಹಳ ಕಷ್ಟ. ಯಾಕೆ ನಾನು ಫಸ್ಟ್ ಹಾಸನಲ್ಲಿ 2 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ ಬೆಂಗಳೂರಿಗೆ ಬಂದು ನಮ್ದೇ ಆದ ಜೀವನ ಕಟ್ಕೊಂಡಿದ್ದಿಲ್ಲಿ. ಬೆಂಗಳೂರಿಗೆ ಬಂದಾಗ ಸ್ಟವ್, ಸಿಮೆಂಟ್ ಸ್ಟವ್ ಹೊಡ್ಕೊಂಡು 7 ವರ್ಷ ನಾನು ನನ್ನ ರೂಮಲ್ಲೇ ಅಡುಗೆ ಮಾಡ್ಕೊಂಡು ಓದ್ಕೊಂಡು ಇವತ್ತು ಇಲ್ಲಿ ಬಂದಿದ್ದೀನಿ ಅಂತಂದ್ರೆ ಮೈ ಎಫರ್ಟ್. ನನಗೆ ಯಾವ ಗಾಡ್ ಫಾದರ್ ಇಲ್ಲ. ಐ ಕ್ಯಾನ್ ಟೇಕ್ ಮೈ ಡಿಸಿಷನ್. ಏನು ಅಂದ್ರೆ ಇವೆಲ್ಲ ಒಂದ್ ಸ್ವಲ್ಪ, ನೀವು ಸೆಕೆಂಡ್ ಜನರೇಷನ್ ಅಡ್ವೊಕೇಟಿಗೆ ಏನ್ ಕಷ್ಟ ಆಗಲ್ಲ ಬೆಂಗಳೂರು ಸರ್ವೆ. ನೀವೆಲ್ಲ ಕಾನ್ವೆಂಟ್ ಅಲ್ಲಿ ಓದ್ ಬಂದಿರ್ತೀರಿ. ಅಲ್ಲ, ನೀವೆಲ್ಲ ಕಾನ್ವೆಂಟ್ ಅಲ್ಲಿ ಓದ್ ಬಂದಿರ್ತೀರಿ. ನಾವೆಲ್ಲ ಹಂಗಲ್ಲ. ನಾವು ಸರ್ಕಾರಿ ಶಾಲೆಯಲ್ಲಿ PUC ವರೆಗೂ ಕನ್ನಡ ಮೀಡಿಯಂ, SLC ವರೆಗೂ ಕನ್ನಡ ಮೀಡಿಯಂ. ಆಮೇಲೆ ದೆನ್ ಐ ಸ್ವಿಚ್ ಓವರ್ ಟು ಇಂಗ್ಲಿಷ್ ಮೀಡಿಯಂ ವಿತ್ ಎನ್ ಇಂಟೆನ್ಷನ್ ಟು ಲಾ, ಜಾಯಿನ್ ಲಾ. ಯಾಕೋಸ್ಕರ ಮಾಡಿದೆ ಅಂದ್ರೆ 84-85 ನಂದು SSLC. ಆವಾಗ 84-85 ಅಲ್ಲಿ 5 year ಕೋರ್ಸ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು. 5 year ಕನ್ನಡ ಮೀಡಿಯಂ ಅಲ್ಲಿ ಇದ್ದವನು ಲಾ ಮಾಡಕ್ಕೋಸ್ಕರ ಇಂಗ್ಲಿಷ್ ಮೀಡಿಯಂ ನಾನು ಜಾಯ್ನ್ ಆದೆ. ಐ ಲಾಸ್ಟ್ ಮೈ ಫಾದರ್ ಅಟ್ ದಿ ಏಜ್ ಆಫ್ 8. ಜಾಯ್ನ್ ಆಗಿ ನಾನೇ ಆಮೇಲೆ ಬಂದು PUC ಜಾಯ್ನ್ ಆಗಿ, PUC ಆದ್ಮೇಲೆ ಬಂದು 5 year ಕೋರ್ಸ್ LLB ಜಾಯ್ನ್ ಆಗಿ, ಐ ಆಮ್ ದಿ ಫಸ್ಟ್ ಎಂಟ್ರೆಡ್ ಫ್ರಮ್ 5 year ಕೋರ್ಸ್ ಟು ಜುಡಿಷಿಯರಿ ಸ್ಟೇಟ್ ಅಲ್ಲಿ. Within a span of 6 months, I have delivered death sentence. That has been confirmed in High Court also. That is also a history in Karnataka judiciary. ಏನು ಅಂದ್ರೆ, it pains us because we work hard with an intention to at least save the society. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ಯಾವ್ದಾದ್ರು ಒಂದು ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಮೆಟೀರಿಯಲ್ ಎಗೇನೆಸ್ಟ್ ಆಗಿ ನಾನು ಆರ್ಡರ್ ಬರ್ದಿದ್ದೀನಿ ಅಂದ್ರೆ ಅವತ್ತ ಐ ವಿಲ್ ಕ್ವಿಟ್ ಮೈ ಜಡ್ಜ್ಶಿಪ್. ಒಂದು ಕೇಸಲ್ಲಿ ಮೆಟೀರಿಯಲ್ ಎಗೇನೆಸ್ಟ್ ಆಗಿ ಆರ್ಡರ್ ಬರ್ದಿದ್ದೀನಿ ತೋರಿಸ್ಬಿಡಿ. ಸಾರಿ, ನಾನು ಆಲ್ಸೋ ಯೂಸ್ ಸಮ್ harsh words. Sorry. Because of only I am concerned with society. I am concerned with society. ಯಾರು ಏನ್ ಮಾಡ್ತಾರೋ ಅದು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಬಟ್ ನೋಡಿದ್ರ ಇದಾರ ಬಂದ್ರ? ನಿಮ್ಮ ಸ್ಟೇಟ್ ಕೌನ್ಸಿಲ್ಗೆ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ. This is only a lesson to the state as well as the ACB to place the persons who are having 100% integrity in this place. ನನಗೇನ್ ಪರ್ಸನಲ್ ಅಜೆಂಡಾ ಇಲ್ಲ. ನಾನು ಯಾವ್ದನ್ನು ಕರ್ಸಿ ಆಫೀಸರ್ಸ್ ಕರ್ಸ್ಕೊಂಡು ಕೆಲಸ ಮಾಡಿಸ್ಕೊಳ್ಳೋ ಬುದ್ಧಿ ನಂಗಿಲ್ಲ. ಆಯ್ತಾ, ನನ್ಗೆ ಯಾವ ಕೆಲ್ಸನೂ ಇಲ್ಲ ನಂದು. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನಾನು ಕರ್ಸೋದೇ ಇಲ್ಲ ಯಾರು, ನನ್ಗೆ ಯಾವ್ದು ನೋ ಪರ್ಸನಲ್ ದಟ್ ಇದು. ನೋಡ್ಲಿ ಪರವಾಗಿಲ್ಲ, ಅಕ್ಕ ಅಷ್ಟೊಂದು ನೋಡ್ಲಿ.
ಹ್ಞೂ ಸರ್.
ಹೇಳಿ ಮನ್ಮೋಹನ್, ಏನ್ ಹೇಳಿ? ಇದಲ್ಲ ನಾನ್ ಕೇಳಿರೋದು ನಿಮ್ಗೆ ಅದು ಬೇಕು. ಅಲ್ಲ, ಎಲ್ಲ ಮಟೀರಿಯಲ್ ಇಟ್ಕೊಂಡೆ ಕೇಳೋಣ ಬಿಡಿ, ಯಾಕೆ ಅರ್ಧಂಬರ್ಧ ಕೆಲಸ ಮಾಡ. ಫುಲ್ ಪ್ಲೇಟ್ ವರ್ಕ್ ಇವನ್ ಬೇಕಾದ್ರೆ ಐ ಕ್ಯಾನ್ ಸಿಟ್ ಅನದರ್ 1 hour ಎಕ್ಸ್ಟ್ರಾ. ನೋಡಿದಿರ ನೀವು 482 ಕೂತಾಗ 6:45 ಮಾಡಿದ್ದೀನಿ. In two roster, I have disposed of 1,300 cases. In 2 roster. If need arises, I will even sit another 1 hour. ಫ್ಲಾಪ್ ಹಾಕ್ಬಿಡಿ, ಎಲ್ಲೇನೆ ಫ್ಲಾಪ್ ಹಾಕಿ ಬೆಟ್ರೆ ಫ್ಲಾಪ್ ಹಾಕಿ. ಏನಿಲ್ಲ, ಅಡ್ವಾನ್ಸ್ ಬರ್ದಿಲ್ಲ ಅಷ್ಟೇ, ಬರ್ದಿಲ್ಲ. ಬಟ್ ಇನ್ನು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಇದೆ ನೋಡಿ. CBI ರೈಡ್ ಆಗಿದೆ, ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು ನಂಬ್ತೀವ? when he was an SP at ಇಲ್ಲೆಲ್ಲಿದೆ ನೋಡಿ, ಇಡಿಲ್ಲೂ ಇದೆ ನೋಡಿ, ಇಡಿನಲ್ಲೂ ಇದೆ ನೋಡಿ.
Warning also expresses some afternoon also because we are concerned that as you are not something is some corner. All these things are also this what the act is going on. I don't have to all these. Now, in each and every media, or in the print, this is what you are not expressed all these concern about it. And in the headlines, they have very attractive, they have printed it. Day before yesterday,
Day before yesterday.
Now, express for example.
ಯಾವ್ದ್ರ ಬಗ್ಗೆ ಇದ್ರದ್ದು PSI ಸ್ಕ್ಯಾಮ್ ಇರ್ಬೇಕು.
ಎಲ್ಲಾ ಕಡೆ ಎಲೆಕ್ಷನ್ because we are also interested to know all this. Not only concerned with this this court and the media association also interested. You want to know it. And your lordship has expressed it. I will put it on
record.
We wanted to know who are on those. The transparency is also to be maintained. We will also take the action. Because your lordship knows it very well. I am saying, they have taken it very seriously and we have passing some resolution against it. Today, the same advocate as Justice
same attitude. Huh?
He expressed what about this and I said not the legal aid assistance, want the medical aid first. See how the standard of
ಏನಾಗ್ತದೆ, ultimate effect is on the institution. The advocates behaving like this, ultimate effect on the institution. That's why.
Anybody can see and also they will correct. This is what we are also previous body
ಏನ್ ಮಾಡಕ್ಕಾತ್ರಿ, ಕೆಲವು ಅಡ್ವೊಕೇಟ್ಸ್ ಆರ್ಡರ್ ಆದ ತಕ್ಷಣ ಐ ಆಮ್ ನಾಟ್ ಹ್ಯಾಪಿ ವಿತ್ ದಿ ಆರ್ಡರ್ ಅಂತಾರೆ, ಹಿಂಗೆಲ್ಲ ಮಾತಾಡ್ತಾರೆ. ಏನ್ ಮಾಡೋದು ಹೇಳಿ? ಅದಕ್ಕೆ ಆನ್ ದಟ್ ಡೇ ಇಟ್ ಸೆಲ್ಫ್ ಐ ಸೆಡ್ ಐ ಆಮ್ ನಾಟ್ ಸಿಟಿಂಗ್ ಹಿಯರ್ ಟು ಮೇಕ್ ಯು ಟು ಹ್ಯಾಪಿ ಅಂತ ಐ ರಿಯಾಕ್ಟೆಡ್. ಏನ್ ಮಾಡ್ತೀರಿ? when an order has particularly 482 ಬಂತು, SC/ST ಆಕ್ಟ್ ಇತ್ತು. SC/ST ಆಕ್ಟ್ ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ ಇತ್ತು, ಕ್ಯಾಶ್ ತಗೊಂಡು ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ರು, ಬೈದ್ರು ಅಂತ. ದಟ್ ಈಸ್ ಎ humiliation in front of the general public. I did not entertain 482. Immediately after passing an order, the reaction of the advocate, I am not happy with the order. Then I said, I am not here sitting here to make you to happy. Yet ಮಾಡೋದು. And also other day ಯಾರ ಹೇಳಿದ್ರು, immediately I said that I am not affiliated to any political party. I am not having any such only I also hails from this bar. Though I am born at Hassan in my senior office, but actually I practiced here for more than 8 years. I was there at two and a half years at Hassan. Then I shifted my practice to Bangalore. I was with my senior almost 7 years. That's what I said. It will not be a difficult to Ponnanna and Manmohan and also the Vivek Reddy. But especially ನಾವೆಲ್ಲ ಹಳ್ಳಿಲಿ ಬಂದು ಬೆಂಗಳೂರು ಸರ್ವೈವ್ ಆಗಬೇಕು ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. ಹೌದು, ನಾವೆಲ್ಲ ಉಪ್ಪಿನಕಾಯಿಲೆ ನಮ್ಮ ಅಮ್ಮ ಉಪ್ಪಿನಕಾಯಿ ಮಾಡ್ಕೊಟ್ರೆ ಆ ಉಪ್ಪಿನಕಾಯಿಲೆಲ್ಲ ತಿಂದು ಬದುಕ್ತಾರ ನಾವು. ಉಪ್ಪಿನಕಾಯಿ ಕೊಡೋರು ಒಂದ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿ, ಯಾವ ಅರ್ಜೆಂಟಿಗೆ ಸಾರು ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅನ್ನ ಉಪ್ಪಿನಕಾಯಿ ಇಲ್ಲ ಮೊಸರನ್ನ. ಏನು ಮಾಡೋಣ, ನಮ್ ಕೈಲಾಗಿದ್ ಮಾಡೋಣ. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು, even at the cost of my judgeship, I will not budge to any threat ಅಂತ. ಸೊಸೈಟಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಷ್ಟೇ. ಬಟ್ ಇಲ್ಲ, ನಿಮ್ಗೆ ನೀವು ನೋಡಿ, ನಾನು ಹೇಳೋದು, ಐ ಆಮ್ ಆಲ್ಸೋ ಎ ಸನ್ ಆಫ್ ಎನ್ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್. ಬಟ್ ನೀವು ಹೋಗಿ ಯಾವೊಬ್ಬ ರೈತನ ಮಗನೇ ಆಗ್ಲಿ, ಎಲ್ಲಿಗೆ ಹೋಗ್ಲಿ, ಒಂದು ಆಫೀಸ್ಗೆ ಹೋಗ್ಲಿ, ಎಷ್ಟು ರಕ್ತ ಒಂದ್ ಕುಡಿಯಲ್ಲ, ಇನ್ನೆಲ್ಲ ಮಾಡ್ತಾರೆ ಎಲ್ಲ ಆಫೀಸಲ್ಲಿ. ರಕ್ತ ಒಂದ್ ಕುಡಿಯಲ್ಲ ಆಫೀಸ್ಗಳಲ್ಲಿ, ಇನ್ನೆಲ್ಲ ಮಾಡ್ತಾರೆ. ಈಗ ಎಲ್ಲ ಹಂಗೆ ಆಗ್ತದೆ, ಎಲ್ಲ ಹಂಗೆ ಆಗ್ತದೆ. ಅದು ಈಗ ಹೆಂಗ್ ಗೊತ್ತಾ, ನಿಮ್ಗೆ ಎಕರೆ ಲೆಕ್ಕ ಕೇಳೋದು. ಒಂದ್ ಎಕರೆ ಇದ್ರೆ ಇಷ್ಟು, 2 ಎಕರೆ ಇದ್ರೆ ಇಷ್ಟು, 3 ಎಕರೆ ಇದ್ರೆ ಇಷ್ಟು ಅಂತ ಹಿಂಗ್ ಮಾಡ್ಕೊಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ ಅದೇ ಹೇಳಿದ್ದು, ಈಗ ಎಕರೆ ಕಾನ್ಸೆಪ್ಟ್. ಈಗ ಮೊದ್ಲೇನೋ ಒಂದ್ ಕೆಲ್ಸ ಆಗ್ತಿತ್ತು, ಏನೋ ಒಂದು ಜನನು ಅವಾಗ ಏನೋ ಇದ್ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ. ಈಗ ಏನಾಗ್ಬಿಟ್ಟಿದೆ, ಜನಗಳಿಗೆ ಹಿಂಸೆ ಕೊಡಕ್ ಶುರು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಹಲವಾರು ಕಾರಣಗಳು ಇದೆ. Out of 10 out of 10 out of ಯಾರೊಬ್ರದ್ದು ರಿಪೋರ್ಟ್ ಇದೆ ನೋಡ್ರಿ, ಆಗಿನ IPS ಆಫೀಸರ್ ಅಂತ ಒಂದು ರಿಪೋರ್ಟ್ ಇದೆ ನೋಡಿ, ನನಗೆ ಕೊಡಿ, ನಾನೇ ಓದ್ಕೋತೀನಿ. ಬಟ್ ಏನಂದ್ರೆ ಅಲ್ಲಿ ತಂದಿರೋದ್ ಪೂರ್ತಿ ಎಂಟೈರ್ ಇರ್ಬೇಕು, ಹೈಡ್ ಮಾಡಿರ್ ಕುಡುದು. ಹೈಡ್ ಮಾಡಿದ್ರೆ DPR ವಿಲ್ ಫೇಸ್ ದಿ ಮ್ಯೂಸಿಕ್. ಅದು ಕೇಳಿದ್ದು. IPS ಆಫೀಸರ್ದ ಒಂದು ರಿಪೋರ್ಟ್ ಇದೆ ನೋಡಿ. I can name the IPS officer also who gave the report. ಹೆಂಗಿರೋ ಜನ ಆಗ್ತದೆ. ಆಲ್ರೆಡಿ 70 ಯಾವತ್ತು 7th ಗೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ವಿ. ನಿಮ್ ಕಸ್ಟಡಿ ಕೊಟ್ಟಿರ್ತೀನಿ, ನಮ್ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ನಿಮ್ ಕಸ್ಟಡಿ ಕೊಟ್ಟಿರ್ತೀನಿ. You read and ಮಾಡಿ ನಮ್ಮಂಗೇನೆ ಸ್ವಲ್ಪ. I know that you are coming to office at 7:30 doing some homework. ಹೌದಲ್ಲ? ಅದಕ್ಕೆ ಹೇಳಿ ಮಾಡಿ ಸರಿ. You also assist the court. ನಿಮ್ಗೂ ನಮ್ಗೇನೆ ಕಷ್ಟ ಗೊತ್ತಾಗೋದು, ಯಾಕೆ ನಾವೆಲ್ಲ ಯಾವ್ದೋ ಮೂಲೆಯಿಂದ ಬಂದಿರ್ತೀವಿ. ಬೆಂಗಳೂರಲ್ಲಿ ಸರ್ವೈವಲ್ ಆಫ್ ಫಿಟೆಸ್ಟ್ ನಮ್ಗಳಿಗೆ, ಹೌದಿಲ್ಲ? ನೋಡಿ, DPAR ಬೇಡ, ಇದೇನೋ ಬೇಡ ಅಂದ್ರಲ್ಲ, ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡೋದು ಬೇಡ ಅಂದ್ಬಿಟ್ರು ಅವರು. ಯಾಕಂದ್ರೆ ನಾಳೆ ಪೇಪರ್ ಇದು ಬಂದ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ ಮತ್ತಿನ್ನು. ಅದು ಕೇಳಿದ್ವಿ. So, the special counsel Sri Manmohan undertakes to produce material before the court which is sought regarding the filing of the B report and details with regard to obtaining of such warrant and not conducted the search based on the search warrant, and also submit regarding the acceptance of the B report from the date of setting up of KCB. The the Advocate General also appeared before the court and has instructed the ACB to place all the materials before this court. He seeks 3 days time and hence matter adjourned to 7th of ಅಷ್ಟೇ ಸಾಕು, ಜಾಸ್ತಿ ಏನ್ ಬೇಡ. 7th of the DPR secretary na ಅಥವಾ deputy secretary na ಏನ್ ನೀವು deputy secretary Sri Anand placed the service records of ADGP before the court. In fact, and hence list this matter on 7th. 2:30 ಬೇಕಾ? ಆಯ್ತು, 2:30. List this matter. Yes, ಇದು 7th ಗೆ ಇದೆಯಾ? ಆಯ್ತು ಬಿಡಿ. ಅಲ್ಲ, ಅದ್ರಲ್ಲೂ 5 ಬೇಲ್ ಪಿಟಿಷನ್ಸ್ ಏನೋ ಇದೆ. ಈಗ 5 ಏನೋ ಇದೆ. ಮತ್ತೆ ಯಾವ್ದಾದ್ರು ಫೈಲ್ ಆಗಿದೆಯಾ? ಗೊತ್ತಿಲ್ಲ. ಆಗ್ಲಿ ಬಿಡಿ, ಹಾಕ್ಲಿ. ಅದ್ರಲ್ಲಿ ರಿಪೋರ್ಟ್ ಏನೋ ಕೇಳಿದೀನಿ. ಮೋಸ್ಟ್ಲಿ OMR ಶೀಟ್ ಅಂಡ್ ಆಲ್ಸೋ RFSL ರಿಪೋರ್ಟ್. OMR ಶೀಟ್ಸ್ ಎಷ್ಟೊಂದು ಟ್ಯಾಂಪರ್ ಆಗಿದೆ ಅಂತ ಅಲ್ಲ? ಅರೆಸ್ಟ್ ಆದ್ರ ಇಂಥದ್ದು ಅಮೃತ್ ಪಾಲ್ ತಾನೆ? ಪೊಲೀಸ್ ಕಸ್ಟಡಿ. ಹೌದಾ? ಅರೆಸ್ಟೆಡ್. ಇದೆಲ್ಲ ಕೋರ್ಟ್ ಮಾಡ್ಬೇಕೇನ್ರಿ? ಅವರೇ ಮಾಡ್ಬೇಕು. ನನ್ನ ಪ್ರಕಾರ ಅವರೇ ಮಾಡ್ಬೇಕು. Who are in the helm of affairs, they should do it for the state, in the interest of the public, not by court by monitoring all this. 545 ಪೋಸ್ಟ್, ಮೋಸ್ಟ್ಲಿ 400 ಪೋಸ್ಟ್ ವ್ಯಾಪಾರ ಆಗಿರೋದು. ನೀವು ವ್ಯಾಪಾರ ಆಗಿರೋದು 400 ಪೋಸ್ಟ್. ಅವ್ರು ಬಂದು ಏನ್ ಮಾಡ್ತಾರೆ ಇಲ್ಲಿ? PSI ಗಳಾಗಿ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡಿರ್ತಾನೆ, ಇಲ್ಲಿ ಬಂದು ವಸೂಲಿ ಮಾಡ್ತಾನೆ, ಜನರ ಜೀವ ತಿಂತಾನೆ ಅಷ್ಟೇ. ಇನ್ನೇನ್ ಬೇರೆದೇನಾಗಲ್ಲ. ಜನರ ರಕ್ತ ಕುಡಿಯೋದು ಇಲ್ಲಿ ಬಂದು ಅಷ್ಟೇನೆ. ಬೇರೆ ಏನಾಗ್ತದೆ ಹೇಳಿ? ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತ್ರಿ? ಅಲ್ಲಿಗೆ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು, ವೆರಿ ಸಿಸ್ಟಮ್, ಸೊಸೈಟಿ ಎಲ್ಲ ಕರಪ್ಟ್ ಆಗ್ತಾ ಇದೆ ಅಂತ. ಇದು ಇವತ್ತಲ್ಲ ಇದು. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು, ಈಗ ನಾವು ಫಸ್ಟ್ ಸ್ಟೇಜ್, ವಿ ಆರ್ ಇನ್ ಸೆಕೆಂಡ್ ಸ್ಟೇಜ್. ಅದು 3rd or 4th ಏನೋ ಶಾರ್ಟ್ಲಿ ಏನೋ ರೀಚ್ ಆಗ್ತೀವೇನೋ. ಅಟ್ಲೀಸ್ಟ್ ಈಗ್ಲಾರು ಒಂಚೂರು ಕ್ಯೂರ್ ಮಾಡೋಣ ಅಂತ. I don't know how much hurdles I have to face, but I will face it. ನಂಗೆ 500 ರೂಪಾಯಿಲು ಜೀವನ ಮಾಡಿ ಗೊತ್ತು, 5,000 ರೂಪಾಯಿಲು ಜೀವನ ಮಾಡಿ ಗೊತ್ತು. I will face it, no problem, for the cause of justice. ಏನಾಯ್ತು ಮೇಡಮ್? ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ಸ್ ಪ್ಲೇಸ್ಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಅಷ್ಟೇ. ಅದೇನ್ ಬೇಡ. ಹ್ಯಾಂಡೆಡ್ ಓವರ್ GP ಅಂದ್ರೆ ನಿಮ್ ಅಲ್ಲ, ಬೇಡ, ನೀವು ಇಟ್ಕೊಳ್ಳಿ. ಐ ಬಿಲೀವ್ ಯು. ಆಯ್ತಾ? ನೋಡ್ಬಿಟ್ಟು ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್. I may not get sufficient time also, but I will read the entire papers. 1 or 2 days ಅಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟು ಕೊಡಿ. ಆಯ್ತಾ? ಬೆಳಗ್ಗೆ ಡಿಕ್ಟೇಟ್ ಇದು ಮಾಡಿದ್ ಬೇಡ ಆರ್ಡರ್. ಆಯ್ತಾ? ಈಗ ನಾಳೆ ವೆಬ್ಸೈಟ್